Hello everyone. I hope this message finds you fit and fine. For a moment, just consider that you don't have any conception of rights in your life. Rights means something which you consider as truly yours. And society also adhered to this idea. Yes, this belongs to you. And that is why you set claim on those things from family, society, or government. Now consider you don't have this conception of right in your life. What kind of life you would be living? Do you think it would be better off or it would be worse off? Now you can actually connect that we cannot exist without various rights in our life. We need something which we can claim. These are necessary for our development, for our basic existence. Right? Now, out of these innumerable rights, certain rights were given some prime status by our constitutional framers. And this status is fundamental rights. The word fundamental itself means that these are of utmost importance. These are mentioned in Part 3 of Indian Constitution, starting from Article 12 and ending on 35. And why they talked about fundamental rights? I hope all of you would agree on this point, that we learn from our experience. In our colonial history, we have experienced the travesty, the exploitation which is done by government if there are no limitations on this government. So this conception of fundamental right, as mentioned in Indian Constitution, put limitation on power of government so that you can enjoy your life in the best possible manner without compromising others' life. And that is why our fundamental rights are not absolute in nature. It means if we talk about any fundamental right in our Part 3, you should not consider that this is available to you in every situation. No, nothing is available in every situation. Terms and conditions are applicable. Right? Before we enter into this domain of fundamental rights Part 3, you should know there are three types of questions which UPSC is asking, specifically in Indian polity. One are on principles. From principles part, generally questions are not being asked from Lakshmikant specifically. For that, you should refer NCERTs. For example, today we are starting fundamental rights. So you should not think that UPSC is going to ask you question on specific provision only. When I say provision, it means what this article in Constitution says. Means they will make a statement and they will ask, this statement is true or not. So you can answer if you have understanding of the provisions in our Constitution. But sometimes, for example, 2-3 questions are being asked on principle part, the basic conception of right. For example, we are talking about Part 3 of Indian Constitution, fundamental right. But UPSC can make a statement on this idea of legal right, natural right, civil right, political right, right? So it means you should have understanding of these ideas and how fundamental right is evolving from these ideas, right? So those are principle kind of questions. Now the process part. As you move into Indian polity, you also find in different articles and subsequent laws which are made by Parliament, there are certain processes by which this political system work. It may be election process, it may be disqualification process, right? So process are also, important area from which questions are asked. From mains perspective, specifically from fundamental right, just have a look on these statements and you will be able to judge the demand of this section. 2021. Analyze the distinguishing features of the notion of the right to equality. Distinguishing features of the notion of right to equality in the Constitution of US and India. Now tell me, my friends, if you have understanding of right related to equality as mentioned in part 3. You have understanding of article from 14, 15, 16, 17, 18. Do you think the understanding of the provision is sufficient to answer this question? Because question directive is not explain, discuss. Question directive is analyze, analysis. And the word USA is also there, na? So it means what examiner is asking. Examiner is asking whether you are assimilating this knowledge or not. ऐसा तो नहीं है you are just cramming, right? And do you require some, do you need to read some 3-4 books on on Indian polity apart from Lakshmikant just to answer these kind of questions? My answer is no. What is required is that you are having sharp eye on the demand of this particular topic. And whenever you read an article that, oh, equality is in news, so you should collect the content keeping in mind, oh, this is going to be used in GS paper 2 because these are the common themes on which questions are asked. That's how you need to structure your knowledge. First, we are building foundation and then you need to structure your knowledge over it. Because ultimately, you have to clear the exam, right? Does the right to clean the environment entail legal regulations on burning crackers during Diwali? Discuss in the light of Article 21 of the Indian Constitution, judgments of the apex court in this regard. This question is directly being asked from what was in news. And I would say this is a direct question. Because specifically asking link between this event, article and judgments, right? Means information based question. What do you understand by the concept of freedom of speech and expression? Does it cover hate speech? Now, hate speech was also in news, right? Why do the films in India stand on slightly different plane from other forms of expression? Discuss. So, another contemporary question. And you should also keep in mind that OTT platforms were in news, right? Because CBFC, Central Board of Film Certification, does not apply as of now on OTT platforms, and that is why when you go through various TV series, Sacred Games and others, you see a lot of you can say rebuking going on, slangs are being used. So they are saying that it is, and this is under their freedom of speech and expression, because art need not to be in some bound or restrictions, otherwise art will be compromised. So there's a debate on the definition of art, because acting, script, writing, this is art component. And other, we have this morality component, right, which we have to protect. So where we should balance between these two. So UPSC is asking the application part, whether you think on these issues or not. Okay. Discuss section 66A of IT Act with reference to the alleged violation of Article 19 of the Constitution. Was in news as one cartoonist, Asim Trivedi, made a national emblem, which was disfigured. Some other images of politicians were used. At the time, this particular section was invoked. Now, Supreme Court heard this, that this particular section has been misused by government many times. And that is why this was struck down. But recently it was in news that still at ground, various police administration are using, when in charge sheet they are using this particular section despite the judgment of Supreme Court. How is it possible? So if this particular thing is in news, this particular provision is in news, so you need to connect with how it is connected to Article 19, subclause 1, subclause A, right? So I hope now you are clear with the demand, the direction which you should adopt while covering fundamental rights. Part 3, Article 12 to Article 35, I have already told to you. Now, before I jump into the provision part, I want you to understand this word natural rights, because 4 words are used specifically in context of part 3, means fundamental right. 4 type of rights are associated with fundamental rights. Natural rights, legal rights, civil rights, and political rights. These 4 rights are associated with fundamental rights, part 3 of Indian Constitution. Okay? And these words socio-economic rights, another type of rights, are associated with DPSP. Please understand this difference, because this can be a statement in an exam. Part 4, Directive Principle of State Policy, they have socio-economic rights. Okay. Now, it becomes important for us to understand these words individually. Later, we are going to understand socio-economic rights. Now, what is natural right, and from where this idea emerged? So, my friends, in 17th and 18th century, various political theorists supported this idea of natural rights. And as you can see, the word nature is there. Nature. So what was happening in European countries in 17th, 18th century? What kind of government which was popular there? All of you are aware, monarchy was the most popular form of government, right? And we know that king at that point of time was enjoying absolute power. Absolute power. Absolute power means whatever comes into the mind of the king will do that. And that act will be considered as legal act. And all of you, if you were considered about the people who were living at that point of time, it was responsibility of the people to accept whatever is declared as legal by this king. So don't you think this lead to some arbitrary action? Arbitrary action, and arbitrary action leads to exploitation, right? I hope you are able to connect with this journey. Exploitation. Now, some political thinkers was thinking we have to save people from this exploitation. So that is why they arrive at this concept of natural right. They said some rights are given to people by Mother Nature. These rights are given to people by God. Some of you might be thinking, ऐसा कैसे? How can this happen? Means बोलना एक बात है, लेकिन लोग जब तक accept नहीं करेंगे, if people are not accepting this, then this idea cannot actually have some ground. This idea will not be accepted, right? So why would people accept it? So these theorists said, there's a logic inside. You are given life by king or nature. You will say nature. So you are given life by nature. Don't you think by this logic you have right over your life? Because your life is not given to you by king. Life is given to you by nature or God. So how can king arbitrarily take action and take your life? This is wrong, right? And earlier kings were saying this is my divine right, and they said no, ये सब नहीं चलेगा. This is leading to exploitation. We need to understand new truth, and new truth is life. Along with this, can you actually live without property? When I say property, what comes into your mind? Some house, right? Car, bungalow, right? No. When I say property, it means possessions. Can you live without possession? Just look around when you are sitting. You have possessions around you. You have clothes over your body. That is your possession. That's your property. For existence, we need some possessions, property. right? So if life is given to us by the God, and God or nature has made us in such a way that we need possessions to actually continue, it means nature has given us right over property, right? Now you have thinking ability. You can think. If you want to go outside, you can go outside. No one will stop you. Why? Because you are given this ability. Thought comes into your mind and you move out. Thought comes into your mind, you start writing. Thought comes into your mind, you start reading. So it means these actions are occurring in your brain. So it means liberty is a component which is also given to you by nature. And now you're able to understand life, liberty and property. These are the three kind of rights which were given primacy from this 70th and 18th century. And that is why these rights are part of fundamental rights as well. Property was also part of fundamental right in our original constitution. Later, this right to property was removed, but earlier it was part. Right to life mentioned in Article 21. Article 21 talks about right to life and personal liberty. And this liberty as an idea is spread in many articles in Indian Constitution within fundamental rights, be it your speech and expression, your right to move freely, right? Right to choose your profession, right to form association, all of this, what this represents? This represents liberty. Because all these three types of rights are necessary for you to live your life fully, right? And this is emerging from this concept of natural rights. Natural rights. So if UPSC is making a statement that our fundamental right, as mentioned in part 3, incorporates rights derived from conception of natural right, that statement would be true or false? You will say true. Abhi abhi आत्मज्ञान हुआ है आपको, right? Now, when everything is correct, ठीक है, natural right you accepted, then from where this concept of legal right emerged? अब इसका क्या पंगा है? Legal rights. So the word legal, it comes to this word law, right? Now some other theorists of the same time, they say we are against this concept of natural right. And when the supporters of natural rights asked why you are against this concept of natural right, at least by this concept of natural right, we are able to put limitation on this government. Now government cannot take away our life, liberty and property without proper law which is accepted by all. So it is good for all. What's the problem you are having? Now the supporters of legal rights says you have given too much power to the people in the name of life, liberty, property. And we have an alternative logic. Then the supporters of natural rights asked, what logic do you have? Then they said, consider we accept your concept that yes, life, liberty, property are necessary. But when you use the word right, these are connected to claim. And do you think there will be any value to any claim without these claims being settled by someone? There should be some settlement of these claims as well, na? And how you can settle? You can only settle these claims, for example, your right to life, for example, your right to property. You are having this right, you are claiming. But can you actually enjoy your right to property, your right to life, liberty without a law made by government? What would be your answer? Yes or no? Your answer would be no, sir. Government को हल्के में नहीं लेने का है. Government का role तो है. Because you are able to enjoy this life, liberty, property because they are mentioned in a law. There's Article 21 there. There are Article 19 and other fundamental rights. That's why you are able to say, yeah, we have these fundamental rights. So, Constitution is the fundamental law. It means without law, no matter how many times you jump this, you actually, repeat this, no, this is our natural right, this is our natural right, but no one will give you this natural right until and unless it is backed by law. So that is the importance of the concept of legal right. So it means, according to legal right, who is the source of right? It is not nature. It is state. When I say state, it means government. And why? State is source, because state make law, and by this law you are able to claim this right. And now, if I ask whether we have this component or principle or say concept of legal right in our part 3, you will say yes. Because without law, how can we actually go to Supreme Court to ask that this fundamental right has been abridged, right? So this is conception of legal right. Now, the third, civil rights, quite easier one. Can you imagine your life without any order in society? You come out of your home and you move freely because you have belief that others are going to, have their conduct in orderly manner. Means there's an order in society which people have to follow. It means we need a civilized society. We need a society where there is order. And this order will be only possible when rights are clear. What you can do, what you can claim, that is clear. And where are the limitations? Till what point you can exercise this right? So it means all rights which are necessary for your civilized life, it means to bring order as well as you utilizing your potential. Because only when you have certain rights, right to actually say equality as well, that you are equal in front of law, right to say have equality in terms of opportunity, right to have equality in terms of opportunity in public employment. It means these steps are connected. And that's how you'll be able to lead a civilized life, a life where you'll be able to realize your potential, right? You don't want to get discriminated. This is possible only when this conception of civil rights are adhered to when you talk about rights. And don't you think these are mentioned in our constitution? Fundamental rights? Yes, they are. We're going to talk about them, right? Next, fourth, political rights. So what comes to your mind when you read this word political? I think election comes to your mind, right? My friends, the word political is way elaborate, is very much, is more than just election. Your stature, your relation with respect to the laws which are in place is also having political component there. It means when we say political, the basic idea is that you have right to participate in political process. But my friends, you will be able to exercise this political right in modern time only when you are treated equally in eyes of law. And that is why this principle of political right is also imbibed in our part 3 fundamental right. I hope now you are clear about these principles, right? Now let's move ahead. In original constitution, there were 6 types of rights which were given the status of fundamental rights. During constant assembly debate, some members were saying we should have more rights to be declared as fundamental rights. At that point of time, one person, Mr. B.N. Rao, who was legal advisor to Constituent Assembly, he said, let's divide the conception of right into 2 parts, part 3 and part 4. Part 3 will be given the name fundamental rights. It means it will be responsibility of state to ensure that these rights are given to the people, fundamental. And other kind of rights, which were socio-economic rights, B.N. Rao suggested, since our capacity of our government at that point of time, which is going to be formed, as well as political reality as well as social reality. When I say political social reality, it means aspirations of the people, demand of the people, commitment of the political parties of the time to actually make laws on these topics. So B.N. Rao suggested we can leave some things as some rights as DPSP, Directive Principles of State Policy. It means in future, whenever state is going to make policy, state is going to consider these principles mentioned in part 4 as directives. Now coming back to the topic, fundamental right. So we have 6 now, because 7th, this fundamental right on property was removed from fundamental right and placed in Article 300A. So we are going to start from right to equality. First we are going to talk about Article 12, Article 13 today. Then we are going to talk about right to equality. Then right to freedom, right against exploitation, right to freedom of religion, which is in news nowadays due to this hijab issue. Cultural and educational rights, right to constitutional remedy. Now these are some keywords which you can associate with this part 3, fundamental right. Words like Magna Carta. This Magna Carta was one royal charter which was signed by King John. I'm talking about 1215, who was signed by King John, who was unpopular king, and that's why his rule was in turmoil, and he was facing some resistance from local barons. Barons means landlords at that point of time. They were unhappy that king was actually working on his whims and fancies. He was changing taxes, he was putting these barons in imprisonment on his whims and fancies. No order, no security was there. No limitation was there. It means exploitation was happening. As they voiced their concern, and church worked as mediator at that point of time, so they actually made a document on which certain rules were clearly mentioned, that these will be limitations around which government will adhere, and these are the responsibilities of barons. So barons got a surety that yes, now this government is going to ensure these rights as our basic rights. And from there, this word Magna Carta became popular. Although the Magna Carta which was signed at that point of time was not, you can say, successful. It got changed later. But this idea gave us hope. Oh, there can be some rights which can work as a contract between state and common people. Right? Now it is not just about barons, it is about all the people. Uphold larger public interest. This is the purpose of fundamental right. Not sacrosanct or permanent. It means they can be changed. Yes. And we are going to talk about this debate, to what extent they can be changed. You cannot change or you cannot amend these fundamental rights to an extent which abridge basic structure of Indian Constitution. It means to some extent they are safe, right? But Parliament is given the power to amend fundamental rights. We are going to talk about case-to-case journey also. Justiciable, it means if they are abridged, you can directly knock the door of Supreme Court using Article 32. High Court, you can go for your fundamental rights using Article 226. Guarantor, Supreme Court is the guarantor. Because in Part 3, Article 32 specifically talks about Supreme Court and how Supreme Court can use these writs to safeguard your fundamental rights. Available against state and private individual. Please remember that. Many students remain confused in this part. When I say putting limitation on state, that it was the objective of having these rights. But there are certain rights which put limitation on individual, private individual as well. For example, Article 15 says that there shall not be any discrimination on the basis of religion, race, caste, sex, place of birth, but it is applicable on individual as well as state. You as an individual cannot restrict entry to a public park of a person just because he belongs to a different religion. That would be against Article 15, fundamental right. So it means this is applicable on you as well, not just government, right? Similarly, Article 17 related to untouchability. Now, negative in nature. Please remember, negative is not about bad. Negative means that these fundamental rights are putting some restrictions on state, and then only you will be able to enjoy your rights. Look at the language. Article 15 state, for example, there shall not be discrimination. Shall not be discrimination. Discrimination nahi karna hai. Article 16, a state shall not discriminate. Discrimination nahi karna hai. So it means when restrictions are put on state, then you are able to enjoy these rights, and that is why it is called negative rights, negative conception of right. Okay. Now I'm making a statement. I have not started, but I'm making a statement to actually tell you what kind of questions can be asked. With respect to the status of fundamental rights, it only incorporates negative conception of right. It only incorporates negative rights. This statement would be true or false. This statement is saying कि सभी फंडामेंटल राइट्स में केवल यही कंसेप्ट लगा हुआ है दैट स्टेट को ये नहीं करना है, स्टेट विल नॉट डू दिस. या कुछ ऐसे फंडामेंटल राइट भी हैं, डू यू हैव दोज फंडामेंटल राइट्स वेयर स्टेट इज बाउंड टू डू समथिंग in order to make you enjoy your rights. Take a look, Article 21A, right to education. Right to education is not just talking about what state should not do. It is talking about what state has to do. That is positive conception. And I remember one statement which was made by Justice Chandrachud, Supreme Court judge. So he said that even Article 21, when you talk about right to health, it is an interpretation from Article 21. We are going to talk about it. It should not be considered just as negative conception. It is having positive conception. And this positive conception of fundamental right was also exercised by Supreme Court during this second COVID wave when oxygen shortage was there. So when the discussion, deliberation was going on at that point of time, this debate also come up that yes, positive conception of fundamental right is what we need to accept apart from negative conception. Right? I hope you are clear. Negative means state should not do this, then you will be able to enjoy. Positive conception of right means state has to do this, then you will be able to enjoy your rights. Okay? But moreover, fundamental rights are tilted towards negative conception of right. Okay? Guaranteed to everyone except Article 15, 16, 19, 29, 30 because they are only available to citizens. Now, let's talk about Article 12. First article of it, you can say fundamental rights. It talks about the word state. Definition of state. So, why we are talking about state? As I told you, fundamental rights are putting some limitation on state, right? Now, who should be the state? On which entity these fundamental rights are applicable, where you can knock the door and say, oh, this entity, this government body has actually taken away my right. So that is why it was important to explain what is the meaning of state. So Article 12 explains Union Government and Parliament of India. It means executive and legislature at the level of union comes under the definition of state. Clear? Similarly, executive, legislature at the level of state. When I say state here, it means provinces, Uttar Pradesh, Madhya Pradesh, Maharashtra, Andhra, right? So they will also come under the definition of state. Means whatever conditionalities, responsibilities are given to state in fundamental right, they should be applicable on them. These entities should consider, oh, these are applicable on me. All local bodies, all authorities, it means Panchayati Raj, municipalities, municipal corporation, these all come under the definition of state. That is quite clear, right? Local, state and union. Now, you should take a look over this fourth point. Other authorities within territory of India or under control of government of India. Now, what other authorities can come under the definition of state? Now, I'm making a statement. You have to tell me the statement is true or false. If I say, no private entity can be considered under the definition of state as mentioned under Article 12 of Indian Constitution, do you think that statement would be true or false? Take a look over the Supreme Court. What Supreme Court says. Even private body or an agency working as an instrument of state falls within the meaning of state under Article 12. So it means private body, if it is working as an instrument of state, engage in certain responsibilities which we connect as a responsibility of state, then that private agency, private body can also be considered as state under Article 12. Please remember it. It is important. Okay. Now talking about Article 13. Article 13 is a kind of protection shield to the fundamental rights which are given to us. Why protection shield? Laws inconsistent with fundamental rights. Those laws which abridge fundamental rights which are given to us. What is going to happen with these laws? As I said, protection shield. Fundamental rights become operative from 26 January 1950. So now, this Article 13 says that your fundamental rights are primary. These laws cannot take away your fundamental rights. So when I say laws, so we need to categorize these laws first into two parts. Because some laws were present in pre-constitutional era also. It means our constitution was enacted, commenced on 26 January 1950, and there were many laws which were made by Britishers which were already in operation in Indian territory. And we did not repeal everything. Many British time laws are still working in India, right? But Article 13 says, if any law which is pre-constitutional, but this law is abridging fundamental rights as mentioned in Part 3, then what is going to happen? That particular law will be declared null and void. Now, in what way they will be declared null and void? In violation with fundamental rights, now they will be declared void. Now, there are two ways to actually make this particular provision of this law void. There are two ways, two concepts. One is doctrine of severability. This word severability comes from the word sever. Sever means cut karna. You are actually cutting a piece of a law because you are thinking this is of no use. So now you can connect what doctrine of severability says to separate, right? It means if this is a law and this law is having say 5 points, okay, 5 points are there, and we see that 2 points are actually abridging some fundamental right, right? So now what doctrine of severability says? Now we are going to cut these two parts away, these two provisions away. Now this remaining law will be in place, but these two provisions will be cut it out, right? Now, this doctrine was used by Supreme Court in A.K. Gopalan case. A.K. Gopalan, a communist leader who was lodged in Madras jail, and he filed a petition in Supreme Court that my fundamental right is being abridged. Supreme Court said, which fundamental right? He said Article 14, Article 19, Article 21, Article 22. Supreme Court said, oh, it seems like it's a serious case. Let us know how these are being abridged. So A.K. Gopalan said, I'm a communist leader and I'm put in preventive detention by the government. Preventive detention means I have not committed any crime, but because this government think I'm a threat, that is why they have put me in preventive detention. Now Supreme Court said, what is the problem in that? If you're a threat and there's a preventive detention law 1950 in place, and the same year this particular case was being heard in Supreme Court. So what is the problem? That law is clearly saying that government has this power to put you in preventive detention. Then A.K. Gopalan's advocate said, sir, the point is that there is section 14 in this preventive detention law, and it says that the ground on which this concerned person, means A.K. Gopalan, has put into detention, this ground cannot be furnished even before court of law. Just up, this law is saying that the basis on which this A.K. Gopalan has put in preventive detention, we cannot actually put these reasons even before court of law. Court said, what is happening? Means, how can this law say that? This is clear-cut indication of undermining of judiciary. So at that point of time, Supreme Court used doctrine of civility. Why? Because Article 13 talks about that if law is inconsistent, then that particular law will be void, right? Now, who is going to do that? Obviously, judiciary. But this particular section was undermining judiciary. This concept of judicial review is emerged from this very article, Article 13. And to protect that, judiciary used this doctrine. I hope now it is clear. Means section 14 was declared that it would be null and void, it would be inactive, and other part of that law will continue. Now, doctrine of eclipse. You know eclipse? So, eclipse is permanent or temporary. Solar eclipse, lunar eclipse. I hope you have read about or you heard about eclipse. Bachpan mein you have seen also. So, it is temporary in nature, right? So, doctrine of eclipse says that the provisions which are actually, you can say, abridging fundamental rights, we are going to keep these provisions into sleep, means sleeping section. And this was said in Bikaji versus State of Madhya Pradesh in 1955. It means we are not cutting the provisions and declaring them out. We are saying this will be a sleeping section. Fundamental rights will overshadow inconsistent laws till and any amendment comes in fundamental right. It means they will be there, but they will be in eclipse. Because who is superior? Fundamental rights are superior. And at any point of time, if there is amendment in fundamental right, then that particular sleeping provision will wake up, right? And in this case, you have already cut it out. If you want to bring that provision back, then you have to repeat the process. You have to bring that law in bill in legislature, then you have to pass, and then you can actually bring that particular cutout part again in the law. But here it is in sleep, right? That's how our legal framework works. Now, Article 13, Subclause 2, it talks about post-constitutional laws. It means laws which are made after commencement of Indian Constitution. It says that since you have already read Article 13, so you should be clear that you should not make any law which is inconsistent with our fundamental rights. A state must not make laws that are not in consonance with the Constitution fundamental right. If such is the case, then they will be declared null and void. Whether the law that is declared void is non-existent with respect to non-citizens of India, if this statement is used in any manner. So what does it imply? It simply implies, consider, certain rights, certain fundamental rights are available only to citizens, right? So if they are available to citizens and there is a law which abridges this particular right for a non-citizen, now can we use Article 13 in this case? No. We cannot use Article 13 in this case because Article 13 is protecting what is mentioned in fundamental rights. And if fundamental right is saying that this is available, this protection is available to citizens, why would Article 13 get activated for the protection of non-citizens? Right? I hope now you are able to have this clarity in mind. Right? Justice Matthew Bench. Special rights were given only to citizens which render them protection against post-constitutional law. Parties to which fundamental rights are not guaranteed. For example, I said some rights available only to citizens, not to non-citizens. That piece of legislation will be valid. There you cannot activate Article 13, right? And that's why it will not be void for non-citizens because it is just talking about non-citizens, right? Now Article 13 subclause 3, it says meaning and definition of law. Because again and again we are saying law should not be inconsistent with fundamental right. But what is law here? And there's an interesting debate around it. What the debate? Law includes any ordinance, order, bylaw, regulation, notification. Now some of you might be thinking, why we are even talking about or the elaboration of this law? Because there are various definitions of law, and on which definition Article 13 can be applied. This was the question in mind of many people. And that is why Article 13 subclause 3 is clearly saying that even if a notification is released by state and this notification is against fundamental right, then Article 13 will be applied. If you are a district magistrate and you have issued an order and this order is against any fundamental right, then your order will be declared null and void. You cannot say, oh, the definition of law should be a law made by parliament. No. At that point of time, court will say, please read Article 13 subclause 3. Right? Custom. Please remember this word custom. Customs which are prevalent are also under the definition of law. So if there's a custom which abridges fundamental right, then court can intervene and clearly say that fundamental rights are superior than this custom. Please remember it. You can expect one statement from here. Now, there are two exceptions to it. What are the exceptions? Number one, it means generally administrative and executive orders, those orders which are just having instructions or guidelines. It means these orders are not having some real power to create some action, to ensure some action. They are just instruction or guidance. For example, a notice board saying these are the general guidelines which you can follow. So in this case, this is an exception. Article 13 won't be applied here because direct change is not happening. Direct impact on someone's life is not happening in this case. Okay, please remember this is an exception. And UPSC's favorite genre are these exceptions. Now personal laws, they are also beyond the ambit of Article 13. Interesting. For example, Muslim personal law, right? So this will not be considered as law. There's a debate around it. We are going to discuss it in the issues part, but you should remember this is an exception. Now whether a constituent amendment be covered under law, because we have said these are going to be covered under the definition of law. But what about constitutional amendment? If Parliament has made a constitutional amendment using Article 368, can we say that now this constitutional amendment will be put to judicial review? Using Article 13, now Supreme Court can declare this null and void. Many of you would say that is quite obvious. This has happened in many cases. Take the example of NJC even, National Judicial Appointment Commission. Parliament made this constitutional amendment and later Supreme Court said, ho gaya, null and void, because it is against basic structure and basic structure is independence of judiciary. We are going to talk about this issue later, but the point here is, the dimension here is whether constitutional amendment should be under law or not. So we have series of judgment development on this particular question. Now, why this question has been raised? Because this question is connected to supremacy of Parliament and judiciary. Because if it is considered as a law, then judiciary will become supreme. Judiciary will say Article 13 gives me power to struck down any law which is inconsistent to fundamental right. But if it is given the status beyond the definition of law as mentioned in Article 13, then Parliament becomes supreme. Parliament will say, no, now you cannot use Article 13, you cannot declare null and void. My constitutional amendment is beyond this definition of law as mentioned in Article 13. So that's why this debate happened. Now let's talk about Shankari Prasad case. Quite simple. Just take a look how judiciary was behaving at that point of time. I'm talking about 1951. This is considered as some pacifist phase of Indian judiciary, because at that point of time Jawaharlal Nehru, the newly formed government, was having so much legitimacy in the eyes of people that judiciary was not in activist phase. They said includes only ordinary laws, not constitutional amendment. It means constitutional amendment are brought for amending even fundamental right, then judiciary cannot declare them null and void because Article 13 will not be applicable. Article 68 include the power to amendment of fundamental right, and that's how you saw first Constitutional Amendment Act to protect right to property. Laws Article 31 subclause 1, 31 subclause 2 were inserted, right? So that's how you can say first attempt to amend fundamental right happened, because judiciary said हमको लेना देना नहीं है, because already Article 68 Constitutional Amendment is beyond the definition of law as mentioned in Article 13. Now comes Golaknath case, and there we saw a change, a strong phase of judiciary. Judiciary revised earlier decision, and now judiciary said power of judicial review is supreme. Judicial review to hoga, and said under Article 68 can be challenged and reviewed as law under Article 13. So it means here Constitutional Amendment Act was not law in definition of Article 13, right? But here Constitutional Amendment Act was given the status of law in Article 13, and if it is given the status of law in Article 13, it gives power to judiciary to intervene, right? Article 68 has limited amending power because now judiciary will use this Article 13. Parliament cannot amend fundamental rights. First strong stand. Any amendment violating fundamental right will be declared as void. This was done in Golaknath case. At this point of time, Parliament was on back foot now, right? So challenge 17th Constitutional Amendment Act. Power to amend fundamental right is limited, right? It is not unlimited. Now this led to tussle of power between Parliament and judiciary, and as a response, Parliament brought 24th Constitutional Amendment Act. Parliament said, judiciary, what's your role? Supreme Court said, I am ultimate interpreter of Indian Constitution. Parliament said, oh, you are interpreter, right? Can you amend the language of Constitution, any article? So judiciary said, no. When it comes to amendment, this power is given to Parliament. Now Parliament as a response said, yes, this is what I wanted to listen. Now see what we are doing. 24th Amendment. What they did? Parliament inserted Article 13 subclause 4. Parliament said, you are continuously saying that you are going to use Article 13. Now read Article 13 completely. Judiciary, you have subclause 4. Any amendment brought under Article 368 cannot be challenged under Article 13 in judiciary. Clearly mentioned. They said, read in Article 13 subclause 4, we have clearly mentioned that if we are using Article 68 to amend any part, then you cannot use judicial review. And what you are? Judicial interpreter. So now interpret what it says. Now your powers are limited. Now Parliament becomes supreme. Or you can say, in terms of judiciary, now Parliament stands to gain more power. Supreme word is wrong because India has constitutional supremacy, not supremacy of Parliament or judiciary. Now, Parliament changed the line under Article 68 from procedure of amendment to power of Parliament to amend. And this also is a symbol that power of amendment lies with Parliament. Also, Parliament added subclause 3 to Article 68, and which says nothing in Article 13 shall apply in Article 68. To make it ultra clear, Parliament made this amendment. Okay, if you miss reading this, also read this Article 68. It says that this Article 13 will not be applicable when it comes to power of amendment of Parliament. Right? I hope now you are clear about this journey. Now was the final, you can say, a judgment which changed India's constitutional history. This is Kesav Nand Bharti case versus State of Kerala. And in this case, now ball came into the, you can say, on the table of Supreme Court, and Supreme Court clearly said, who is the boss? We are the boss. And how we are the boss? Constitutional amendment does not come under our ambit of Article 13 law. Ordinary laws comes. So, Kesav Nand Bharti case, saying, so Parliament, you are saying that you have amendment, you have power to amend any part of Constitution. Parliament said, yes, this is exactly we have said. And you also saw this 24C Constitution Amendment Act. Kesanand Bharti case, Supreme Court says, accepted. Yes, this is right. You have the power to amend Constitution. But you can amend any part of Constitution, but you cannot abridge basic structure of Indian Constitution, because we are the guarantor. We are the guardian. Now, Parliament asks, what is this basic structure? We have now never read this phrase in Indian Constitution. Supreme Court said, this is judicial creativity. You should learn from us. Basic structure, we are going to define time to time. Because if we release a list that these are going to be part of basic structure, then you can actually find a way out. That we are going to decide on case-to-case basis. Any increase and decrease in power of legislature under Article 368 should not destroy basic structure of Constitution. The scope of amendment under Article 68, which Parliament holds, was questioned. Power to amend the Constitution, already implicit 24th, now Constitution Amendment Act, was not required, because basic structure doctrine is in play, right? Now, Indira Gandhi versus Rajnarayan case. So it solidified the foundation which was already laid in Kesanand Bharti case. It said, no limitation on amending power of Parliament. Happy, happy. As people have elected them, right? That's why you have the power. But amendments of people will, it must be exercised. It means you have to exercise this power on the people's will, accept it, right? But it needs to be read with this basic structure, right? So inserted subclause 4, clause 5 in Article 368 to strengthen its power, but ended the amendability power tussle of judiciary versus Parliament, qualified certain features as basic structure. Because now these features will be applicable to put a restriction on what you cannot amend, despite clearly mentioning that this is the power of Parliament. Parliament is having power to amend any part, but basic structure cannot be flouted, right? I hope this message finds you fit and fine. My name is Shashank, and I welcome you all to our contest series on Indian polity. In our previous class, we were discussing fundamental rights. Specifically, we started with the conception of right, type of rights, natural rights, civil rights, legal right, political rights. And we also discussed Article 12 and Article 13. Today we need to discuss right to equality, Article 14 to Article 18. You will be surprised to know that in many parts of the world, constitutions were not having equality as an important pillar. But can you think of our constitution, this administration, without concept of equality in place? And why you think like this? Why equality is so much important for us? I hope the direct answer, one answer would be, if there is no equality, then it would be like system is based on injustice, right? But in ancient and medieval time, equality as an idea was not that much prevalent. Even people were not demanding equality from their government. It was in modern time that people started demanding, yes, we should be treated equal. There should not be any basis of discrimination. Social realities should not be the basis of discrimination in eyes of law. So this is a modern concept. It is connected to liberal values. And why I am discussing all of this? Because nowadays UPSC is asking question on these lines. The conception of right to equality as a fundamental right is connected to liberal value. So this line you are not going to find in Article 14, 15, 16, 17, 18. This is based on your understanding of this very concept. Now these are the articles, and I would like you to give attention to these words. For example, in Article 14, the word person is used. The state shall not deny to any person equality before law, equal protection of law. We are going to discuss this in detail, but the point is person. In Article 15, although we see the word citizen, a state shall not discriminate against any citizen on grounds only religion, race, caste, sex, place of birth, or any of them. Any of them means of these. Now in Article 16, again you see the word citizen. There shall be equality of opportunity for all citizens in matters relating to employment or appointment to any office under the state. Means we are talking about government jobs. Article 17, abolition of untouchability. Article 18, abolition of all titles except military and academics. So this is right to equality as a portion. Now, right to equality has a lot to do with this concept of rule of law. And at this point, we should remember Mr. A.V. Dicey, because he popularized this idea that law should be supreme. When I say no, law should be supreme, it means no one is above law. Now you should think on these lines. Do you think in India, rule of law is present in latent spirit? Do you see that some politicians flout some rules, specifically COVID rules in some election rallies, and there is no challan against them? But if you were going and you were sitting in a car, you were challaned, right? Say 5,000 rupees. So this example reflects that this concept, no one is above law, seems like it is not applicable here, right? But we have examples like Norway, where even Prime Minister was actually challaned, means action was taken against Prime Minister by the local sheriff because she invited 2 more persons in her birthday party. That was not allowed as COVID guidelines were in place. Now my point is that why so much importance to this? Because if law is supreme, then it will reduce the chances of arbitrariness. If it will reduce the chances of arbitrariness, then you can be sure of that the system will work as per the provisions mentioned in law. It means justice can prevail in that context. Abuse of power will get minimized. And that is why this concept of rule of law is important. Equal treatment. And this concept can be seen in this Article 14. Because Article 14, as we just read, has 2 specific keywords: equality before law, equal protection of law. I think it is not visible in front of you. It will be visible in subsequent slides. Apart from equality before law, equal protection of law, we also have access to justice, another important component of Article 14. And we have this equality as an idea specifically mentioned in our preamble as well. Now, these are the 2 key phrases. And this equality before law is taken from British Constitution. My friends, this is considered as a negative conception. When I say negative conception of equality, it means that state shall not do this in order to bring equality before law. It is a generic concept that everyone should be treated equally in eyes of law. Seems like a nice idea. Then why our constitutional framers added this phrase, equal protection of law? This is taken from American Constitution. So they have their rationale in place. Reason. Equality before law, this concept says it means that no man is above law. Don't you think this line is connected to this concept of rule of law? And I've just told you the benefits of rule of law, right? Every person, whatever be his, her status or rank, is equal in the eyes of law, right? This is equality before law. And when we are reading it, you should not relate it with practical realities like some powerful people, get some easier way to actually avoid certain implications of punishment. That is practical part. But the point is, you should uphold these ideals. You should know why these ideals were added in our constitution. Because whenever you have clear-cut idea that this is how system should work, then only we can actually take steps in that particular direction. So equality before law is clear. Now talking about equal protection of law, I told you it is a positive conception. It's a negative conception. Means everyone should be treated equally, right? And there should not be any discrimination. But this is positive conception. Means you have to do something. Do what thing? For example, equal protection of law says that unequals should not be treated equally, and equals should not be treated unequally. Some of you might be thinking, what is this? Syllogism? Nahi. Take practical example. If you and your friend are equal in so many parameters, and now government is treating you unequally, would you respect that kind of system? Would you like that kind of system? You would say obviously no. But what is happening here? Equals are treated unequally, and that is why equal protection of law says that equals should not be treated unequally. And if there are unequals, consider this example, that this board is a wall and there's a match going on other side, right? And I'm teaching here and you are in the class and you want to watch that match. So I allowed in 15 minutes break that yes, you can watch that match. But due to this height constraint, you're not able to see it. So you ask, sir, can we have some benches over here? Some placemats, some stools here? So I said, okay, it can be provided. I'll ask the management and they will do that. So now some of you might be of this height, some people of this height, and some people of this height. And all of you have paid equal fees. Now you are expecting that there will be equal treatment to you, right? And consider this example, you want that equal expenditure should be given to you. Equal expenditure should be done for this, for allowing you to, for arranging that you are able to see that match. But at this point of time, what is required? The person of this height need to be provided with you can say a chair or some arrangement of, you can say, this much height that may cost me say 800. Okay, I'm making a proposal that whatever I'm going to give you to see this match, this will be yours. Take home. Now, a person of this height might require of a chair or you can say stool of this height, and this one the minimum height. Now, the person who got the stool or chair of maximum height, then other might say, sir, you have spent 1,000 rupees for that student and you have spent just say 100 rupees for me. This is disparity. Then I would say that students, that unequal criteria is being used here. Unequal in terms of height. Unequals should not be treated equally. Because if I treat you equally and give you equal height, arrangement, then it would be injustice for others, right? So that is why this criteria is cleared by this concept, equal protection of law, right? And state will make efforts to actually allow people to make use of law so that they can protect their interests and take many actions. For example, establishment of bodies like NALSA, National Legal Service Authority. Similarly, we have SALSA, not the dance, authority, SALSA, State Legal Service Authority, by which we provide some government advocates on a very minimum fees or free to actually fight your cases if you are not having that financial capacity. So it means that like should be treated alike. The state cannot treat unequal people as equal. I hope now it is clear to you. Apples and oranges are not the same. Thus, it gives freedom mandate to the state to make a special provision for the disadvantaged section. For example, this NALSA of society. For example, affirmative action laws, special laws for women, children, etc. So this is a specific concept. Now there are some exceptions to equality. Take a look, Article 361. President and governor is not answerable to any court in the exercise and performance of the powers and duties of his office. This is an exception. President and governor will not be treated equally like you. Similarly, criminal proceedings shall not be instituted against the president and the governor during their tenure. If there is any case, then in that case, first they will be impeached or governor will be removed, and then criminal proceedings can start. But till the time they are in this position, criminal proceedings cannot start. This particular clause was in news during Sheila Dikshit, the time when she was governor of Kerala, and there was a case of CNG scam, and one section was demanding that criminal proceedings should start, but they could not start because she was governor of Kerala at the point of time. Now, Article 194, 105, no MP, MLA shall be liable to any proceedings in respect of the actions which they perform in the House. So, this is part of parliamentary privilege or state legislature privilege. Now, the foreign sovereign ambassador, now there is exception to them also. Why? Let me give you an example. So, consider you are traveling in a car and take a look over the number plate. Your car number plate is having white background and black alphabets and black digits, right? So, it represents that you are having a private vehicle, right? But say Mr. Rohan. So, Mr. Rohan is a diplomat, and by virtue of this position, he may be given a car which is having number plate with blue background and white some alphabets and digits. For example, 12CD07. These kind of numbers are on these cars. These are diplomatic cars. Now, both of you are traveling on the same road and you hit one person and that car also hit another person, right, at the same moment. Then when the police reaches there, you will be stopped. Your car may be seized. You will be told that you have to come to this police station. But when it comes to that car, diplomatic car, that diplomatic car will be given free pass. And it will be communicated that yes, we are going to communicate with the respective embassy in this regard, but that particular person will not be stopped. Why? Because diplomatic immunity is given, right? In that context, you cannot say, oh, I have read right to equality as mentioned in our preamble, or equality as mentioned in our preamble and right to equality as mentioned in fundamental rights, and this is wrong. No. You should also read about the exceptions, right? Now, prohibition of discrimination on certain grounds. That is Article 15. Have you seen that movie Article 15, Ayushmann Khurrana? So, Article 15, subclause 1. First of all, you should be clear that it applies only on citizen. Only on citizen. Okay? And not for non-citizen. It should be clear to you. And prohibits the state for discriminate against these citizens on the basis of religion, race, caste, sex, place of birth, right? So the state shall not discriminate on this basis. And the word only is used here. What does it signify? It means discrimination can be done on basis which are not mentioned in Article 15, subclause 1. Now some of you might think, oh sir, how is it possible? Why they use the word only here? Why the word only here? Because we should be against discrimination. Why we are giving scope that only on these bases discrimination cannot be done by state, and on other bases it can be done? Because whatever is not clearly prohibited in a law, it is deemed that it can be done. So my answer is that discriminate as a word is generally used in negative context, that this is bad. But in legal language, discrimination can be used in positive context also. When I say positive context, it means some special provisions can be done for some weaker section. That would be discrimination. But don't you think that this discrimination can support the idea of equality? Right? So that is why discrimination can have positive context also. Right? Now these cases were in news. For example, Sabrimala Ayappa temple issue. right? There, in this case, when women in menstruating age from 10 to 55, they were prohibited to enter into upper temple. Then Supreme Court, what it says? It is against Article 14, it is against Article 21, it is against Article 17. We are going to learn all of this. But the point is that at that point of time, this decision was taken that it would be discrimination, that is why it is prohibited. Similarly, preference for male in active military service. You must have seen that now permanent commission is given to female as well. Then this admission into gynecology. Recently there was an article where Rajasthan government said that male gynecologist will not be allowed to treat women. Gynecologist, it means that genre of medicine where they study the women body and they deal with providing solution to women problems. But the point here is that should be gender neutral. And later that government took this order back, right? Now, Article 15 subclause 2. Now please give attention. This is applicable not just to state, applicable to citizen as well, to private individual as well. It means you cannot do discrimination also, right? A state with even citizens should not discriminate on these 5 grounds. What are the grounds? Religion, race, caste, sex, place of birth, right? For example, public places like restaurant, shop, well. So you cannot say that, oh, this other person belongs to this religion, that is why I'm not going to allow this person to actually have water from well. And why our constitutional framers mentioned this word well even? The reason is they knew the ground realities. How people on the basis of their caste were restricted from having this drinking water from common well, right? And this is you can say, social evil. So to eradicate it, this particular provision was added. Apart from this, it is also clear that wholly or partially or state funded infrastructures, areas, places, you cannot actually have discrimination on this basis. Why this was mentioned specifically? For example, if you are having a garden in front of your home, and this is a privately owned garden, private property, and someone belonging to any religion, caste, place of birth, they want to enter into that garden and enjoy this sunlight, and you are prohibiting that person, you cannot enter. So now it is fine because that is your private property, right? But now consider, this case is applicable in case of park of your society. Can you prohibit the entry of a person based on religion, race, caste, sex, place of birth just because that this person belongs to this category? No, you cannot do that, because it may be possible that this park is being maintained by state funds, wholly or partially, right? If state funds are used, then you cannot discriminate. In case of private property, your own rules of entry and managing can be applicable. Okay. Now, Article 15, subclause 3, special provisions for women and children. Now, why this was added? Because our constitutional framers and later our legal luminaries were well aware of the fact how people are going to interpret these articles, right? Some of you might say that, oh, it is quite clear when it comes to state-funded institutions, government institutions, there cannot be any discrimination on the basis of, say, sex, right? And now state has made an institution, say a girls' college, and state is saying only girls admissions are taken here, right? And now one bright student, you can be that bright student, and you are actually knocking on the doors of girls' college and barging into the principal's office, and you are saying, ma'am, I want to take admission into this college. Now principal is saying, better, this is girls' college. But you are saying, no, ma'am, Article 15 subclause 2 says that if any institution is state funded, then there cannot be any discrimination based on sex. So how can you discriminate against me on the basis of this gender? I want admission in a girls' college. Then ऐसा भी हो सकता है that you will get a laugher, you will get a slap from the principal, and she will say that you should read Article 15 subclause 3, right? And if principal is going to ask who has taught you polity, so don't take my name, because I told you that state has this power to actually make special provisions with respect to women and children, right? So this particular women college will come under special provision as per Article 15 subclause 3. So we can say it is a positive discrimination. For you, it's a discrimination, but it's a positive discrimination. For upliftment or the welfare. Similarly, stopping child labor, reservation for women in parliament. These associated issues are connected to Article 15, subclause 3. Now, 15 subclause 4. Now, there's an interesting story behind it. This was not part of original constitution. What happened? So it was Madras state which actually made some reservation, right? And this reservation was around 68%. At that point of time, one girl, Champakam Durai Rajan, she wanted to take admission in medical college, and there were only two government medical college in Madras at that point of time, and there were two engineering college. There was another boy, Srinivasan, who was also fighting to take admission into that engineering college, both belonging to general category. And Champakam Durai Rajan filed a case, and she said, actually it is against this policy of reservation is against my fundamental right. Then court asked how it is against fundamental right. She said, sir, it is against Article 15. Because subclause 4 was not there. Article 15 was saying that there will be no discrimination on the basis of religion, race, caste, sex, place of birth. Then why court has made a special policy for reservation for a particular section? So at that point of time, the government replied, we have done this under the spirit of Article 46. Article 46, Directive Principles of State Policy, which gives this directive to state. The state has to take certain actions to secure the welfare of this backward classes. So state gave this decision. So Champakam Durai Rajan case actually put forth a debate which should be considered superior, fundamental right or DPSP, because her fundamental right is being abridged, and on the second point, state is saying we are actually securing the welfare of the deprived section, taking inspiration from DPSP. At this point of time, court observed that if we read Article 37 within this DPSP part, Article 37 says that DPSPs are not enforceable in court of law. And if they are not enforceable in court of law, it clearly represents that fundamental rights should be considered superior to DPSP. So this case went into the favor of Champakam Durai Rajan. And this was the first case in the history of independent India which was majorly having this debate on reservation policy in India. So, as this case was in favor of Champakam Durai Rajan, as a reply, what government did? Government made first constitutional amendment in 1951. And my friends, this was the time when we were not having, we did not have elections per se at that point of time, right? Full-fledged parliament was not there. Now, they made this constitutional amendment, and provision for advancement of backward classes in SC, STs was added. So what was added? Article 15, subclause 4 was added. And as a result, no reservation on communal lines, this was accepted. But reservation can be done for the backward classes in SCs and STs. And why this word no reservation on communal ground? The reason is, Madras government declared this reservation policy on the basis of a government order which was released in 1927 in Madras state. 1927, I'm talking about when we were not independent. And this government order was later recognized as communal government order. That is why CGO word was also used. Why? Because reservation was not just given to SCs, STs or backward classes. Reservation was given to Anglo-Indians. Reservation was given to Muslims. So it means religion was also a basis of giving reservation. So that is why in Champakam Durai Rajan case, the advocate was saying that if Article 15 is saying that there will be no discrimination on the basis of religion, and you are specifically giving reservation in education institution based on religion, then this is communal order. This is against Article 15. Right? Now, I hope this debate is quite clear to you. At one point of time, fundamental right, and On other side, you have this DPSP backed by Article 46, and then interpretation happened using Article 37. I hope this debate is clear. Now, talking about Article 15, subclause 4. So case, the background, Mysore government reserved 68% seats in medical college. So Mysore, where we right now have Karnataka. So there was another case. It happened after Champakam Durai Rajan. M.R. Balaji versus State of Mysore case. Now what happened there? The debate was that whether this government has this power to demarcate that certain seats will be reserved for a section by an executive order. Because it may be possible that government should actually bring a commission dedicated to give advice to the government that what efforts need to be made for this backward section SCs and STs, and then this matter can be given to president, and then president can actually bring a bill in parliament, and then this can be you can say implemented in the other states. So the debate is whether commission is needed, whether such reservation policy can be enacted just by executive order or law is needed, means law made by legislature. Third, whether it is necessary that only president can actually issue guidelines regarding reservation or state government can also do the same. So on these debates, finally this M.R. Balaji case happened. Now, both socially and educationally backward classes, they were recognized. At that point of time, here, there was also categorization between backward class and more backward class. And question was raised, no such categorization is there in our constitution. So, should we agree on this? And when I say backward, so what kind of backward you are talking about? And that is why it was clearly mentioned socially and educationally backward classes. Caste cannot be dominant factor while considering backward classes. It means socially and educationally both components need to be added. It may be possible in a social structure, a particular caste may be regarded as a lower caste, but the people from this caste actually got a lot of education in past, and that's why now they're from education perspective, now they're quite strong. So in that case, you cannot give reservation to that particular caste. So such debates were going on. No reservation beyond 50%, for the first time it was accepted, right? It was Indra Sawhney case who actually finalized the stamp, put the stamp on this. Backward class distinction into backward and more backward is not valid, as I told you. So it was not valid, no reservation beyond 50%. So this was M.R. Balaji versus State of Mysore case. Article 15, subclause 4. It is related to advancement of backward classes. So whenever Article 15 subclause 4 comes into light, so you should remember two cases, Champakam Durai Rajan and M.R. Balaji. Okay. Now Indra Sawhney case, the famous judgment on reservation policy, it clearly said not more than 50%. Also declared this concept of creamy layer. It means from OBC also there may be a category of caste or subcaste which are in creamy layer now, based on the criteria issued by the government. Creamy layer means now they will not be having benefits of OBC reservation policy. Classes can be classified and it's constitutionally accepted, means backward and more backward classes can be classified. So in M.R. Balaji case, it was not considered valid, but in Indra Sawhney case, it was accepted. Yes, we can have categorization within backward. Now, why Indra Sawhney case changed the stand which was earlier made in M.R. Balaji case? The simple reason is because concept of creamy layer need to be incorporated, right? If from backward classes, some backward classes are more backward, then they should be the one who should get the benefit, right? Backward class can be defined only on the caste. This actually gave a, you can say, idea which was not formalized at that point of time, but this seeds were sown that whether we can think of segregating reservation policy based on subcaste concept, because within a subcaste, if you categorize that this subcaste is more backward, this is less backward, so application of reservation policy may change, right? And this concept was later taken up by Justice G. Rohini committee also. That's a star point, you should search about it, Justice G. Rohini committee. And what are the recommendations of Justice G. Rohini on this concept of OBC reservation? Backward class cannot be defined only based on caste, means education criteria is important. Now comes Article 15, Subclause 5, admission of OBCs, SCs, STs. It means, now the debate was, now when it comes to education institution, so whether this reservation policy benefiting OBCs and SCs and STs welfare should be incorporated in private education institutions also. So this debate was cleared after this Article 15, Subclause 5. 93rd Constitutional Amendment was made to add Article 15, Subclause 5, so that state has the authority to impose laws that apply to all education institutions, all, means including private institutes, whether state aided or not. And we have exceptions here. For example, madrasa are exception there. Central Education Institutions Reservation and Admission Act 2006, 27 reservation quota for non-creamy layer OBCs was used, because creamy layer won't have this reservation. Now, Article 15, Subclause 6, reservation for economically and weaker section. It was brought by Modi government. At this point of time, so many advocates were saying that this particular provision, Article 15, Subclause 6, will be declared null and void soon by Supreme Court, but this did not happen. Why they were saying? They said in Article 15, the basis of this welfare initiative, positive discrimination, affirmative discrimination or reservation policy can be socially and educationally, not economically. Similar steps were taken by Narasimhan government also, PV Narasimha government also. And when he was planning that to give 10% reservation for economically weaker section from general category, Indra Sawhney case declared it as a, you can say, unconstitutional step, and this never materialized. So if it did not materialize at this point of time, then how it is working now? Answer is, Modi government first changed the language socially and educationally. They incorporated the word economically. And now all of you know that Supreme Court is interpreter of Constitution. So now government saying, you are interpreter, na? Just interpret what is written. Socially, educationally, economically. Oh, economically is written. It means on this basis, Article 15, Subclause 6 is very much logical. So 10% of the reservation must be set for EWS. Eligibility to get EWS certificate, family income less than 8 lakh per annum, agricultural land less than 5 acres, residential flat less than 1000 square feet, residential plot less than 100. I hope now it is clear to you. Now, talking about Article 16 of the Indian Constitution, it means equality of opportunity in terms of public employment. So there shall be equality of opportunity in terms of public employment, right? And this is applicable only to citizens, and this is applicable to public employment, government job, right? No citizen shall be on the grounds of religion, race, caste, sex, place of birth. Along with this, residence or any of them, descent and residence. The two more criteria which are added in Article 16, descent and residence. Now, can there be a possibility that certain position may be reserved for a person belonging to a religion? Yes. For example, a position of a pandit, priest in a temple managed by government. So obviously, their religion can be a criteria, right? Then Article 16, Subclause 3, Parliament has the authority to provide reservation based on residence also. It means for some government jobs, local population can be given preference, can be given reservation. And what's the logic behind it? Logic is speedy development and equal opportunity to even backward areas, so that people belonging to backward areas can have fair chance to enter into government job. That is the logic. Now Article 16, Subclause 4, most debated article, talking about backward class of citizens which in the opinion of state is not adequately represented in service of the state. It means reservation of appointment and post in favor of any backward class. In earlier, we were talking about 15 Subclause 4, we were talking about policies, right, for backward and SCs and STs, right? And here we are specifically talking about public employment. So in Devdasan versus Union of India case, it was cleared if the reserved seats have not got filled in that year. Consider there are 20 seats and only 10 seats were filled. Now the remaining 10 seats will be carried forward for the next year, means next recruitment, but will become null and void if it crosses 50% ceiling gap. Means I am saying 20, considering the total seats are say 50. But if 10 seats of earlier year and now they are added in the next recruitment and together more than 50% seats are coming in the reserved category, then that particular reservation cannot go beyond 50%, right? Out of 50, you cannot have 30 seats reserved. You can have 25 seats reserved. This was the judgment in Devdasan case. Now Mandal Commission 1979, which started a new politics in India, Mandal Kamandal, Kamandal the Hindu politics, Mandal the backward politics. So now investigate socially and economically backward. Earlier they were investigating the economic aspects as well. Can this be a criteria as well? So there were three important implementations. First of all, reservation to OBCs. Earlier there was reservation to SCs and STs, but they said no, reservation for OBCs is also required. Only in appointment, not in promotion. This was the advice. But later we are going to see reservation in promotion was also added. Total reservation not more than 50%. More than 3,000 socially, educationally backward classes provide 27% reservation. Why? Because more than 3,000 SEBCs are present and they are not allowed to have any reservation in SC and ST's category, right? That is why a new category was invented, that is OBC. OBC as a word, other backward classes as a word was not there in Indian Constitution, right? So Indra Sawhney case made this clear that 27% reservation, creamy layer, non-creamy layer are different. Now 16 subclause 4A, okay, 77th amendment, it was added, and now reservation in promotion for SCs and STs. Then 16 subclause 4B, added through 81st amendment, ended the 50% reservation ceiling in case of SCs and STs. It means if seats are carrying forward, earlier seats were not filled and they are carrying forward and they are passing this 50% limit, then you cannot declare them null and void as per Article 16 subclause 4B. Article 16 subclause 5, reservation in religious institutions. For the post of religious institutions, if the demand is to belong from a certain religion, this is the example I was giving, that for position of priest, position of a Maulvi in a institution, position maintained by government, there can be a reservation on the basis of religion as well. You cannot say, oh, it is against Article 16 subclause 1. You should see what is mentioned in Article 16 subclause 5. Okay. Example, Waqf board, which manages the religious properties of his Muslims. Now Article 17. Article 17 talks about untouchability, right? Abolition of untouchability. Now what is the meaning of untouchability? What comes into your mind? Oh, untouchability we know. It is about the practice which is prevalent in this caste system, right? But that is not true. That is just one kind of untouchability. There can be other kind of untouchability. For example, in Sabrimala temple case, that women were considered impure in this age 10 to 55, not fit to enter into the Sabrimala temple, as Lord Ayappa, the deity, is a celibate deity. So this concept of purity, impurity is involved. So if this concept is involved, then it will be considered as a case of untouchability. Okay. So it means untouchability is abolished and practice in any form is forbidden. Any form is forbidden. Okay. So the enforcement of any disability arising out of untouchability shall be an offence punishable. Now, was this offence, what punishment is mentioned in Article 17? No, it is not mentioned. Okay. Now our last article, Article 18. So Article 18 talks about abolition of titles. The purpose was, we have seen many titles bestowed on many Indians by Britishers, and it represents the concept of inequality, right? Special treatment. And concept of right equality is against special treatment, as I told you. And that is why Article 18 says that prohibits the conferment of titles. Government is not going to give title. Some of you might say, sir, Padma Shri, Bharat Ratna, these are these are, you cannot say these are titles. Okay, these are, you can say, for the contribution you have made, you are, given this prestigious, you can say, award, but you cannot use Padam Shri Shashank Tyagi. Many people use that, but that's not a title. Okay, but titles can be used in military context and academic context. For example, Colonel, okay, Colonel Rohan Sharma, academic engineer, doctor, right? And when it comes to Indian citizens are prohibited to accept any title from any foreign state. But if a foreigner is working on a position in Indian state, then that particular foreigner wants to take, a title, then in this case, then this particular foreigner need to take permission of President of India. For example, Mr. Raghuram Rajan, he was RBI governor. So if British government is giving him a title, then he should take permission of President of India. Okay. Provides that no person, citizen or non-citizen holding any office of profit, trust shall without consent of President, this is what I have explained to you, accept any present emolument or office of any kind in underway by foreign state. I hope Article 14 to Article 18 are clear to you now. Right? Article 19 to Article 22, right to freedom. Along with this, we are going to discuss all important cases pertaining to these provisions, and we are also going to attempt some important MCQs. All of you are welcome to ask your doubts regarding these articles. Please confirm your presence in comment section that everything is fine. So today we need to talk about Article 19 to Article 22. Have you ever wondered why right to freedom was so much important that these rights were added as fundamental right? Some of you might think, yeah, we got our independence. There was a struggle for freedom which was going on. And how can constitutional framers miss on this particular provision or these range of rights, right? Please confirm in comments that my voice is fine. Welcome, Uday. Great. So let's start with Article 19. We are going to discuss article by article. First, let's talk about Article 19. Article 19 consists of 6 types of rights associated with your freedom. It's starting from right regarding your speech and expression. Now, why this particular right was added and what kind of rights associated with this particular phrase speech and expression. So when I say speech and expression, it was very important to give you this as a fundamental right because this is important for you to realize your potential. And it is said that no government, no nation can become great without dwarfing their own individual. So it means you cannot put limitation on this aspect of our personality, right? Now, apart from this speech and expression, we have right to assemble peacefully, we have right to form association, we have right to move, we have right to reside, and we have right to choose occupation of our choice. You can remember all of these rights by a simple story. Let's start. Consider you are present in my class and one student, Uday, rose up to the platform as I was sitting in staff room. So he took this opportunity and he started speaking that there was a time when UPSC used to have more than 1,300 vacancies per year. But now vacancies are considerably low, and this is wrong because more than 4,000 seats related to IAS officers are needed. They are vacant. So what he's doing, he's exercising his fundamental right as mentioned in Article 19, subclause 1, subclause A. Please remember, all these 6 rights are mentioned in Article 19, subclause 1 because subclause 2 pertains to reasonable restrictions related to Article 19. Okay, so all 6 rights in subclause 1. Now, so just remember from Uday's story. First he started speaking. Now, you got this opportunity that now let's start discussing this among other students who are in this area where coachings are. Say you are in Karol Bagh, and all of you actually came down from the class and you assembled in front of coaching, right? And there Uday started speaking, saying that in 2015 our senior aspirants, they fought a battle, and thereby finally government increased the number of attempts. Earlier number of attempts for general category were 4, then they were increased to 6. So we can have same kind of battle, and thereby we can budge government, we can pressurize government to increase the number of seats. Now the point is, first he was speaking, now he make you all of you assemble. So all of you assembled. Now all of you are assembled, and many people were passing by. And you know what happens in India? If some 6-7 people or say 50 people are assembling, then other people who have nothing to do with you, they will also come and stand there. What is happening, right? So people were coming. But now many people were again and again asking, what is happening? Why you people are standing here? So at this point, Uday suggested, let's form an association. So he called up another student, Rohan. Rohan, bring a banner that All India UPSC Aspirant Association. So Rohan printed the banner and came with the banner, and now you have an association. So first step was speak, second was assemble, and third was banner of this association. So 3 rights are intact. Now, so all of you are assembled with your banner in Karol Bagh. But this country is run not from Karol Bagh, although people selected from Karol Bagh are running the country, but key decision makers are sitting where? Near Parliament Street. So at this point, all of you made a decision, let's move towards Parliament. So what you are doing? You are exercising your fundamental right as mentioned in Article 19 subclause 1, that you can move freely within Indian territory. So now you moved towards Parliament Street. So this was your 4th step. Now all of you were on this Parliament Street, and many cars were passing by of these politicians, and no one was actually stopping and asking you. So you were thinking कि इन्होंने तो हल्के में ले लिया हमको. No one is giving importance. So now you thought they are thinking that we are the students and we will go back in the evening to our PGs or rooms. Now to make your stand strong, you said all of us, let's reside there. Let's install temporary tents here. Because farmers also got something by installing tents. Let's install tents here. So now you started installing tents. Okay, I'm not talking about legal aspect. I'm just talking about what is going on there. Okay, and why you are doing this, that because in fundamental right, Article 19 subclause 1, you have next right to reside in any part of Indian territory. So you exercise this right. This was your interpretation, right? And you started, just sitting there, and you installed some tents. Now, then only no action was taken by government. So now one student suggested, it may be possible that we are lacking in something. What is that thing? So others suggested, we are not having media coverage. Farmers got success because they were hugely, they were covered internationally too. We are not having coverage even in local newspaper or local channels. So someone suggested, we have to do something for TRP. Then you exercise your next fundamental right mentioned in Article 19 subclause 1, right to adopt occupation or profession of your choice. So now you gave this idea. So let's install some pakoda shops there. So now media will cover the cream of India, the people who are preparing for civil service exam, intellectual students. Now they are bound to actually prepare pakoras sitting on this road. So now what you use this 6th right, right? So in this story, now just go back to the story from where you started. Right to freedom of speech and expression, Uday started. आग तो उदय ने लगाई थी. Now, right to assemble anywhere without arms, peacefully, right? Second step was this. Right to form association, Rohan brought this banner. Right to move anywhere, you move towards Parliament Street. Right to reside anywhere and settle, 5th right, right? That is why you installed tamboos there. Right to adopt occupation, profession. This is your 6th right, right? I hope now you will remember all these 6 rights mentioned in Article 19 subclause 1. Yes or no? Yes or no? Now, You should remember some other details too. For example, Article 19 is applicable only for Indian citizens. Okay, these rights cannot be exercised. Means, although foreigners can come and they can actually speak, okay, they have this freedom, but they cannot say that if this freedom is abridged, I will go to Supreme Court. Okay, many students misconstrued that if it is written that Article 19 subclause 1 is applicable only to citizen, then they think, oh, if foreigners, aliens, enemy aliens, they don't have any right respect to freedom of speech and expression. No, that is your misunderstanding. They have the right, but they don't have the fundamental right. They cannot knock the doors of Supreme Court using Article 32. They cannot knock the doors of High Court using Article 226. I hope you got the difference, right? Also, please remember, no fundamental right in our constitution is absolute in nature. Okay? They all are qualified in nature. Qualified. So, what is the meaning of this word qualified if this is used in statement? Qualified means reasonable restrictions are also mentioned. And why our constitutional framers also added reasonable restrictions within Part 3 of Indian Constitution? Because they were aware of this fact that no one's fundamental right should not abridge the fundamental right of other. Otherwise, it will become a legal issue, right? That is why a balance is needed. To bring this balance, our fundamental rights were given the status of qualified fundamental rights, not absolute fundamental rights. Not absolute. Okay? Now we are going to discuss each right, right? Freedom of speech and expression. So, what constitutes freedom of speech and expression? You have freedom to express your views, expression, belief, conviction freely. It means when I'm saying speech and expression, you should not take this just in literal sense. Oh, it is just about speaking. No, no, no. Your belief also comes into this. Please remember these kind of details, because a beautiful trap question, trap statements can be made on this and student will get confused. Okay, so belief is also part of this, because when you have belief, your belief is connected to your expression, right? Now, it also includes what you say from your mouth, writing, picturing, etc. Okay, for example, few years back, one cartoonist, Mr. Aseem Trivedi, so a case was lodged against him using Information Technology Act, Section 66A. We are going to talk about this section in upcoming slides. But at that point of time, Aseem Trivedi's advocate said, this is against Article 19, Subclause 1, freedom of speech and expression as fundamental right of my client. At that point of time, court said, your expression also includes picturing. And this Aseem Trivedi made a cartoon of our national emblem, which was derogatory in nature, right? And that is why it comes under reasonable restriction. Okay, so he exercises saying picturing is also speech and expression, but reasonable restriction does play on that. So when I'm saying reasonable restrictions again and again, so what constitutes reasonable restrictions? It includes if your expression is threat to sovereignty of India, integrity of India, security of India, public order. It means you are making a speech and due to this, there is a law and order issue. Okay, so at that point of time, you will see a knock on your door and police will say, be our guest for some time and have food in jail. Okay, this can happen. Jail is at later stage. First you will go to Havalat. Now, contempt of court and defamation. Please remember these two also, because most of the students remember sovereignty, integrity, security, public order, right? But these two are also reasonable restriction, contempt of court and defamation. Okay. Now, in Article 19, Some rights are explicitly mentioned, but some rights, some fundamental rights are implicit, as they are declared by honorable court time to time. When I am saying honorable court, I am talking about Supreme Court here, although interpretation power is with High Court as well. So these rights are coming under right to speech and expression. Okay, among these, some will seem obvious to you, and in some others, some students may have some dicey opinion. You should not have dicey opinion. Look, take a look. Right to propagate one's views as well as views of others. So this is your freedom of speech and expression. Okay. Freedom of press. Please remember, freedom of press is not mentioned in our constitution, but it is derived from Article 19, subclause 1. UPSC play game on these words: mentioned, derived, inspired, interpreted. So have some focus here. Okay, these are derived provisions. Okay, right to telecast. Right to telecast means government cannot stop telecasting service arbitrarily. Now take into consideration case of NDTV. All of you are aware about Mr. Ravish Kumar, and you also know that he is quite favorite of present government, right, as he is quite appreciative of ruling government at center, right, and that is why a few years back NDTV was banned, telecast was banned for one day. So advocate of NDTV said it is against Article 19 subclause 1, freedom of speech and expression, because right to telecast is also derived from here. So at this point of time, court said accepted, right to telecast is there, but government has a ground there. Why they are stopping telecasting? Because it is creating a public order issue. Government think it is creating a public order issue. On this point, government stopped the telecast for one day. Okay, so no government has monopoly here, obviously, right? Government cannot say now there will be no channel, no private channel, only government channel will be there, and whole day you will have bhajan kirtan of the achievements of government on these channel, because that should not happen. This will be against freedom of speech and expression. Okay, now freedom of silence. Okay, but you should not exercise this right in this class. If I ask you some question, which I am going to ask when I am going to talk about some MCQs, so you should not exercise your right to silence. Okay, but you should know that right to silence is part of speech and expression, and it is a fundamental right. Okay, now right against bandh. Now bandh, what is bandh? For example, a political party or any organization, they say we are starting Bharat Bandh on 11th say March, there will be Bharat Bandh. So against that Bandh you have right. Okay, you can actually go to your office, you can go to your classroom. That Bandh cannot stop your, you can say, movement, right? Because this is from a political organization, right? Right to demonstrate, picketing, but not right to strike. Now please remember, I'm making a statement, okay, to make you understand it more clearly, and I would appreciate if you respond. Which of the following statement is correct? चलिए एक ही statement बना रहे हैं. There's one statement. There is no right to strike. There is no right to strike in India, comma, although there is right to put forth your apprehensions before the establishment in a peaceful manner. Now tell me, my friends, this statement is true or false? Dharmen, this PDF will be available in the group, Telegram group, Shashank Tyagi for you. I'll show the link in the last, don't worry. So I'm repeating the statement and all of you have to respond, okay? So we are in Indian polity, and I'm going to continue only when I get simple majority responses here. Means more than 50% of present and watching should give answer, then only we are going to continue, okay? Now, I'm repeating. there is no concept of right to strike applicable in India, comma, although people have right to present their apprehensions before establishment in peaceful manner. This statement is true or false? Come on. All of you should respond. This statement is true or false? Uday, Dheeraj, Piyush, Dharmendra. I hope voice is fine, streaming is fine. Because everything is working top notch at my end. Yeah. So Ramay is saying true. Okay. What about others? Piyush is saying true. Right. Dharmendra is saying true. Right. So all of you are smart students. You have Shashi Yadav is asking the question. Piyush is saying, sir, voice is fine. Okay. I am repeating the question one last time again. Okay. Pankaj is saying true. All of you are united on true. Shashi, the question was right to strike. You can say go back into the streaming and you can actually listen to the question. Otherwise, it would be injustice for the students who are continuously listening to me clearly. I hope you will understand. Now, my friends, to your surprise, answer to this statement is false. It is false. Surprise? It is not a surprise. Now understand how it is false. Here I have mentioned right to demonstrate or picketing, but not right to strike, right? And from this you deduce this, and this is exactly what students do after reading Lakshmikant, right? And now understand why it is false. Because right to strike is not a fundamental right. Means right to strike is not a fundamental right, but it is a legal right. And now go back to my statement. I said right to strike is not applicable in India. Have I said right to strike is not fundamental right? No. I have just said right to strike is not applicable. So why all of you said true? Because there's a psychology working here and UPSC play on this. I call this personally blending technique. Blending technique is make half statement a vague one where students do not have clarity and make other half of the statement as the genuinely true statement, so that by the end, when student reaches the end of the statement, a student will make up his mind, oh, this statement is quite obviously true. But my friends, this is a trap in which many aspirants actually get entangled every year. But I don't want any one of you to get into this trap. It is a legal right. Now, explanation why it is a legal right? Because we have a law, Industrial Disputes Act. And within Industrial Disputes Act, there is a section 22. And this section 22 gives you right to strike in case the contract on which your employment was ensured, this contract is not actually being followed by your employer. In that case also, you have this right to strike only when you present notice to your employer. So it means by this particular law, right to strike is a legal right. Okay? So if it is clear to you now, mention HOLA, H-O-L-A. Because yes is too obvious, boring. So if it is clear to you now, mention HOLA, HOLA in comments. And I hope now you are not going to make this mistake in exam. Saved you from one accident. Let's continue. In comments, everyone. And I would highly appreciate if you want your friends to join in this live session. You can share this link in your groups or with your friends. They can also participate in this question exercises which are important for upcoming prelims. Let's see where students are moving. Chaliye. Now, take a look over this headline. Supreme Court upholds freedom of speech on internet. It means now your freedom of speech is also applicable with respect to internet. Okay? And strikes down draconian law. So what draconian law Supreme Court was talking about? Supreme Court was talking about section 66A of Information Technology Act. And some of you might think, sir, it was a good act. It was a good provision because just I shared this case of Asim Trivedi, right? So then why Supreme Court struck down? The word draconian is used because in so many cases our government, our police, they actually misused this particular section. For example, if Uday has put a post on against some action made by present government, so it may be possible that next morning a knock on Uday's door and police has come and police said, sir, aapko chalna hoga, you have to go because under section 66A we are arresting you. Then Uday's parents are asking, why? Our child is studying throughout day and night, why are you arresting him? He is the future of India. Now police is saying, sir, we are going to make his future in police station. Because last night he has posted a status on his Facebook and Twitter, and this has been retweeted and shared many times, and now many people are raising voice against the government, and that is why it can create a public order issue. Okay, so our best wishes with Uday. But Uday, you should remember, Supreme Court is in your favor. Supreme Court is saying section 66A should not be applicable because it was misused, right? But the reality is, to your surprise, that still in many cases it was found that local establishment, the police at the local level was unaware of this Supreme Court judgment. And in their charge sheet, they were actually adding this section 66A. Okay? Apart from section 66A, also remember two sections of IPC, section 153 and section 505. Please remember, these two sections of IPC are also used in case of hate speech, which was also in news. Hate speech. It means if your speech is inciting mob to act in anger and there's a probability of violence or animosity among public, then again a knock can be on your door, and the basis would be section 153 and section 505. If everything is clear until now, mention yes in comments. Now, apart from this, within your speech and expression, this homosexuality case can also be read. So, India's Supreme Court decriminalizes homosexuality, historic LGBT community. You all know about Navtej Singh Johar versus Union of India, right? At this particular judgment, Supreme Court said, your sexuality is also a part of your expression, and your expression is your fundamental right under Article 19, Subclause 1. Okay? Now, Article 19, Subclause 2, freedom to assemble. Now, this freedom to assemble is assemble peacefully. When I say peacefully, it means without arms. Okay? Without arms. And when I say assemble, it includes public meetings, demonstration, take out processions on public land only. You cannot do this, you cannot exercise this fundamental right on a private property. Okay? No violent protest, riots, assemblies involves arms could breach public peace. Okay? Now, I'm making a statement and you have to tell me the statement is true or false. Okay? Tireless study zone, answer to your question is yes. Now, no group or community is allowed to assemble with arms as an exercise of their right to assemble. I am repeating, no community or group in India is allowed to assemble with an arm, okay, as a matter of their right to assemble. Under Article 19, Subclause 2. So what would be your response? The statement is true or false? Come on, fast. We have to make it like a rapid fire round. Then only I can add more value into your preparation in limited time, which we have right now. Come on, fast. Good response, Sajal, as was expected from you. Answer is false. Answer is false. The reason is because Sikh community is given exception. The Kripan was declared that this is essential part of their religion, and that is why they can assemble with Kripan. But obviously, this Kripan cannot be used for violence. Okay, I hope it is clear now. Reasonable restrictions are also there. Now you have two sections which are related to this restriction with respect to assembly. Please remember section 144 CPC and section 141 IPC. Magistrate can restrain assembly if meeting or possession cause obstruction, danger, damage, health or safety disturbance rights. In this case, assembly can be restricted. Now you cannot knock on the door of Supreme Court using Article 32 that my Article 19 subclause 2 is abridged. 5 or more persons, if they are assembling and section 141 of IPC is in place, then that particular act can be considered as a crime. Please remember, it was in place, right, many times during the farmers' protest as well. Also was applicable in many areas during this COVID first wave, second wave, right? Now, right to strike. I hope now it is clear to you. I have just shared this question. Answer is legal right. And this is legal right. I have already explained to you using section 22 of Industrial Disputes Act 1947. Or I have already explained this to you. Now, Article 19, Subclause 3, freedom of association. Now, this is also your fundamental right. It means you can form association, union, cooperative society. Cooperative society word was later added. Okay. Now, I am making a statement and you have to tell me statement is true or false. Under Article 19, Subclause 3, Indian citizens are given fundamental right to get their society, association registered with government. This statement is true or false? Come on fast, everyone. I am repeating again. Under Article 19, Subclause 3, Indian citizens are given right to form and register their association with Indian establishment or Indian government. A statement is true or false? Form and register, two words are used here. Come on. Everyone, Sudarshan, Uday, Piyush, Dharmendra, Sajal. It should be quick. Because in prelims, your responses are quick. Answer is false. एक तो होता है गलत, एक होता है सरासर कैटेगरी का गलत. सरासर wrong. Okay, this was sarasar. The reason is registered word is not mentioned here. Registered is not fundamental right. You can form your association, but it is not like, sir, that SDM is not registering our association. That SDM might be having some objections in mind related to the work you are going to pursue in that area, right? That is why the answer to the statement is false. Okay, you have right to form association, but right to get registered is not fundamental right. I hope you got it. If you got it, mention in comments. Right to form company, society, trade union, partnership, firm, club, etc. But the word is form. I hope it is clear. Mention got it in comments. ऐसे नहीं चलेगा. I should be aware that you are getting value from this discussion. Establishment, administration and functioning are part of this particular fundamental right. But registering word is not there. Now, Article 19 subclause 4 talks about freedom of movement. Now, I am making another statement. Okay? Because in the story I have already explained to you that right to movement, and I have also mentioned that this fundamental right gives you this right to move freely within the Indian territory. Then can you say that this Article 19 subclause 4 also gives you fundamental right to travel abroad, means to move out of country is also your fundamental right under Article 19 subclause 4? Come on, fast. Yes, no, yes, no. Now I am giving you another trap which UPSC may lay in the upcoming prelims. One statement is right to move abroad is fundamental right under Article 19. Tell me, answer to this is true or false? Fast in comments. Another statement is right to move abroad is fundamental right. Tell me this is true or false. So this is statement 1, this is statement 2. So your answer should be 1, true, false, true, true or false. Okay, so in comments your answer should be 1T अगर आपको लगता है ये true है, 2F if you think this is false. Okay, this is how you need to put your comment. Come on, fast. I hope my handwriting is legible. Basically, it's a piece of art. Only genius people actually are able to, read it. Now in comments, fast, fast, fast. This is a rapid fire round. Piyush, Shuday, Sudarshan, everyone. What do you think? 1F, okay, 1F. One response is 1F. What about other warriors? 2T. Okay, 2T. Okay. Answer is 1F and 2T. Reason is because right to move abroad is not part of fundamental right under Article 19, because Article 19 talks about freedom of movement, but freedom of movement only applicable inside Indian territory, only inside. Article 19 talks about inside. Okay, but second statement says right to move abroad is fundamental right. Now some of you might think, which other article has mentioned this right to move abroad as fundamental right? My friends, this is not explicitly mentioned in Indian Constitution, but it is derived from Article 21. So answer is true. Okay, in Sardar Satwant Singh Sahne case, Supreme Court declared that right to move abroad is your fundamental right. Sardar Satwant Sahne case. Okay, if it is clear to you now, mention clear. And those who are ultra clear, mention ultra clear. Now, Article 19, subclause 5, freedom of residence. So there are two categories here. Right to reside. When I am using reside, it means temporary in nature. Means stay is temporary. For example, you belong to Bangalore. Okay, your permanent residence is in Bangalore, but for some time you were in Pune. So you have this right under Article 19 subclause 5 that for your job purpose you can reside in Pune. Along with this, you also have right to settle in Pune, because domicile and permanent residence is also a right given to you by our constitution under Article 19 subclause 5. Now, is it absolute? No. There are some reasonable restrictions. For example, restriction in tribal areas. For protection of tribal rights, government may issue guideline that in this particular area, no other person except the tribals can purchase land, can settle here, so that their culture, their rights can be protected. Public interest, for public interest this can be done, right? And this word public interest is considered vague. In this particular case, government has more power to actually issue the guideline which government is considering as public interest. If any one of you is not happy with the definition of public interest which government release at that point of time, then you have this facility of using Article 32 and knock on the door of Supreme Court that I'm not happy with this definition of public interest. Now that would be the, you can say, now the ball will be in the court of Supreme Court, what Supreme Court says. Okay. Now, freedom of profession, occupation, trader, business. But it should be clear to you, it is not like now you are preparing for UPSC and you are from engineering background and now you call up your mother back in Bareilly that mummy just order a board and on that board just mention Dr. Sajal Tiwari, and tomorrow I am reaching home and from tomorrow I am going to practice as a doctor because I have read this Article 19 subclause C, subclause 6, which says freedom of profession. Since I have freedom of profession, from tomorrow I am going to practice as a doctor. Now you should also know this particular section in detail, okay? Because this freedom of profession, occupation, trade is applicable, is allowed to you, but you should adhere to the qualifications which are needed and issued as a guideline by the government. Otherwise, you will be considered as a jhola chhap doctor and you will be put under arrest, okay? Because life of people will be under threat because you misunderstood this particular article. Now, restrictions, technical qualification for trade business, right? For example, if you have to open even a medical store, do you need certain qualification for that? Yes or no? Do we have some guideline in place? So those who are not aware, they should know that yes, you need a degree of pharma, for example, B Pharma, to open even a medical store. And those people who don't have this degree, what jugaad they do, they actually contact a B Pharma student and tell them that just give us your degree and we are going to send you 8,000 rupees per month, right? So this is how things work. No objection state whether monopoly or not. Means it may be possible, although you have this freedom of trade, but it may be possible in certain cases there is monopoly. For example, Uday is a bright student, right? All of you know that in the last question he answered correctly. And now he got so inspired from Article 19 subclause 6 that now he called up his friend that now I have chosen my profession. Now I got sense of purpose in my life. Now this will be my profession for life. Now these friends were asking what you read in Article 19 subclause 6 and why you are so excited, what profession you are choosing. He said, now I am starting a missile factory in my home. I am going to build missile. I am going to build bombs in my home. And now I am going to actually spur the growth of indigenous defense manufacturing in India, which India is lacking, and I am going to make India next Israel in defense sector. So it may be possible that NIA may knock the door of Uday and take him, with them, because in certain sectors there may be monopoly. Although now, since I am giving example of defense manufacturing indigenously, government has liberalized this field too, right? But it is not like you can actually start on your own. In certain section, government can reserve, if this missile category is there, only government DRDO may engage. And if government is engaging some private sector, then government guideline will be in place, okay? No immortal occupation allowed, child trafficking, explosive, etc. Obviously, this is immoral actually. Sorry for this. This is immoral. Means it should not be like, say, Sajal next day decide ki I am going to be a drug trafficker. I am going to be, the head of drug syndicate. Okay, I'm going to be next Pablo Escobar. ऐसा नहीं हो सकता, legally at least. You cannot take this inspiration from Article 19, Subclause 6. Okay, I hope all of you are clear till this point, right? Now, Article 20, another important provision, an interesting one. Look what it says. Protection against conviction of offences. Now, some of you might be wondering, conviction of offences. If conviction is happening, it means now it is being proved. It is in process and it is being proved. It may be any case that this person has committed some crime. Then what kind of protection we are giving to that person? Look at the humbleness of our constitutional framers. They are thinking of them also. Now, there are 3 clauses within Article 20 and quite easy one. First is no ex post facto law. It's a Latin term. What does it mean? It means if you have committed some action, I'm using the word action, I'm not using the word crime, point to be noted. If you have committed some action, say Sudarshan has committed some action 2 days back, and that action led to some harm to Piyush. Piyush's interests have been harmed due to some action done by Uday. Now Piyush raised this point that I am going to actually file a complaint against Uday. When he went for filing complaint, police said, sir, in our code, in our criminal code, such action is not declared as a crime. Thus, we cannot say that Uday is a criminal. So Piyush was quite fed up. And Piyush Chacha is Vidhayak. So Piyush was like, Chacha Vidhayak and wo bhi BJP, and we are going to actually, we have power and we need to be neutral politically here. No offense to anyone's political interest. But the point here is, Piyush is a person with clout, so many connections. So he called up his Chacha saying, I want a law to be made declaring this particular act as crime. Chacha said, हो जाएगा. चुनाव में बस ड्यूटी देते रहना, चुनाव में हेल्प करना. Piyush said, वो तो हैं ही आपके साथ. We are there for you. So now, even if law is made from, say, next week, emergency law is made from the next week, such is the importance of Piyush. Do you think now Uday will be arrested for an action which he committed previous week? And now that action is being declared as criminal offense? Do you think he will be arrested? Yes or no? Legally I am saying. Yes or no, yes or no, yes or no. Come on, fast, fast, fast. Answer is no. You know why? Because when Uday committed that action, when Uday did that action, at that point of time, that act was not crime. Okay? And on this interpretation, he cannot be arrested. Now, Piyush got this information. Piyush against called his Chacha. We need to actually enact this law from back date. So Chacha said, हो जाएगा. Now legal advisor of Chacha said, sir, ऐसा नहीं हो पाएगा. This cannot be done. Because in Article 20, ex post facto law is used. It means you cannot actually amend a criminal law from back date. Otherwise, it would be injustice with Uday. Uday would say, agar हमें पता होता, if we would have been aware of this fact that it can be considered as a crime, I would have not done it. This is wrong with me. This is wrong for me. That is why this no ex post facto word is used. It means criminal law cannot be amended or added from back date. Criminal. I am using the word criminal again and again. Okay? Criminal. So what does it mean? It means a law can be amended from the back date if that law is civil law. Can you actually give me some example where a civil law was amended from back date? Come on in comments, fast. Such kind of statement can be made by UPSC. Give me example. Criminal law can be amended, cannot be amended from back date, but civil law can be. Okay, so I'm giving you a star point. Those who are my student from past, they know, and those who are new, remember whenever in my class I say star point, it means this is important, but this is not part of discussion which we are having in class. That is why I expect my students to search these star points, give at least 10-15 minutes, search these star points and note down some important details. Okay, because questions can be made around it. So star point from this class, from this part, is search GAAR. GAR means General Anti-Avoidance Rule. Also search about Partha Sarathi Shom Committee. Partha Sarathi Shom Committee 1 and 2. I've given you 2 star points to search. Okay, General Anti-Avoidance Rule and Partha Sarathi Shom Committee. Okay, now coming to our second point, no double jeopardy. What does it mean? It means a person will not be punished twice for the same offense. For the same offense. If you have committed an offense, you cannot be actually punished twice. Okay. Now, third is no self-incrimination. It means that you will not be bound to be witness in your own case. Because if you are bound to be witness in your own case, then it would be against Article 20, because it may compromise the true process by which investigation and prosecution should be done. So these are 3 provisions. And why these 3 provisions were added in our constitution as fundamental right? Against arbitrary action and excessive punishment. Okay. So this is quite clear to you now from our discussion. Ex post facto law, a law which imposes penalties or convictions on the already done act, increases the penalty of such acts, and that is why it is not allowed. Only in criminal matters not allowed. Already told to you, informed you. In civil matters it is allowed. A tax can be imposed retrospectively. Okay. Income Tax Act was amended retrospectively and there was a lot of hue and cry. Double jeopardy, no punishment for the same crime more than once. Self-incrimination, self-witness not allowed. Now, UPSC is not going to play on these basics. Let me tell you, gone are those days. Now, UPSC is going to play along these lines. Now, attempt the question. And I want answers in comment. It doesn't matter whether you answer right or wrong. Okay. Your response are respected. Okay. What matters is that you are responding or attempting. Because there is a rule in psychology. If you attempt wrong and you immediately get the right answer, then you're not going to forget it easily. And this is our purpose, to contest. Polity should be contest to you. Sudarshan, retrospective taxation means if you amend tax law from the back date. For example, consider right now you are in 20% tax slab category. Okay, 20% tax slab category. Now government change the tax law from previous year. So if government change this particular tax law from previous year, now don't you think now your tax liability will increase? Change the means government changes, and this change increased the tax slab. Now you are in 30% tax slab category. So it means for previous year you paid 20% tax, right? And now government from previous year changed it to 30%. It means you have to pay 30% for this year as well as pay the balance amount from previous year. So Sudarshan, if you are clear now, mention clear. Come on. I would rest. If it is clear, mention clear. Now, response to this question. Self-incrimination as mentioned in Article 20 of Indian Constitution extends to. Some are saying A, some saying B. Is it? Extends to A. Actually, I was saying that UPSC is going to ask questions like this. This is quite direct question. Okay, this is quite direct question. I have another question in my package. I thought that question has showed up. This is direct question. This is lollipop. Okay, this is not what I meant. Yeah, attempt this question. Double jeopardy is not available in proceedings before. This is good. It will show some understanding, not just about the word, but about the application also. And UPSC want exactly that. Proceedings before court, proceedings before judicial tribunal, proceedings before court and departmental authority, proceedings before department and administrative authority. Answer is D. Answer is D. Double jeopardy is available only in proceedings before a court of law or judicial tribunal. Okay. Now remember, what was the double jeopardy? It means you will not be punished twice for the same offense by any court or judicial tribunal. Okay. But you can be punished twice in case proceedings before department or administrative authority. For example, you are an IS officer, a bright one, but highly corrupt. So a corruption case was lodged against you, and it was proven that you have just 300 crore worth property in 6 years of service. So don't you think it is an extraordinary achievement? So considering this extraordinary achievement in mind, a case will be lodged, case will proceed in court also, right? And your file will be transferred to UPSC as well as Department of Personnel and Training of Union Government. That this is a bright start, take a look over his or her file. So in that case, a departmental, you can say, action can be taken against you. You cannot say that, oh, I am already punished by the court, why department action is being taken against me? And department can also take multiple action against you. Okay, may impose fine, may take your job, a lot of things can be done, right? Fun things. So please remember, double jeopardy will not come there to protect you. Okay, I hope it is clear. Now, Article 21, protection of life and personal liberty, most popular fundamental right, right? Now, no person, this is the language, okay, and by interpretation, the meaning of this language has also been expanded, okay? And there's a popular phrase that Indian Constitution is a growing tree. And why growing tree? Because a lot of interpretations have emerged, right? And specifically Article 21, from Article 21, we have list of fundamental rights which have emerged. No person shall be deprived of his life and personal liberty except according to procedure established by law. So if I ask you this question, that Sudarshan, can government legally take your life? Your answer would be yes or no. Everyone should answer this question. My statement is, can Indian government take your life legally? Yes or no? Come on, fast. You should respond fast. Answer is yes. You know why? Because it can be taken by procedure established by law. It means government cannot take your life in arbitrary manner, but legally government can take. Okay? Legally, how can take? For example, Abhishek Kumar has committed a heinous crime. Okay? We are not going to name that heinous crime, considering respect for Abhishek Kumar. But in this particular case, the court can actually pronounce a judgment of death penalty. So if a judgment of death penalty is being pronounced, what does it mean? It means now government is taking your life legally. Now you cannot say it is against my Article 21 fundamental right to life and personal liberty. At that point of time, court will say, "Beta, please read procedure established by law also." Okay? So it is available to both. Both means it is available to citizens as well as aliens, means foreigners. Now, two cases are important whenever you talk about Article 21. These are first A.K. Gopalan case, then Menaka Gandhi case. We also have other cases like Mohini Jain case or Krishnan case, but two cases are most important. A.K. Gopalan case. A.K. Gopalan, who was a communist leader residing in Madras state. So as we got independence, the government of Madras at that point of time, issued a notice to the local, police that you should put A.K. Gopalan in punitive detention, in preventive detention. So A.K. Gopalan was like, कि मैंने किया क्या है? So police said, that is why we are putting you in preventive detention. So preventive detention means you are being detained not because you have committed some crime. You are being detained because there is a possibility that you may commit some crime. So for law and order security, you are taken into custody or you may be turned into house arrest. Okay. Now, A.K. Gopalan said, give me the reason why I am put on preventive detention. What kind of threat I am to society. So police said, okay, we are going to give you this reason, but you cannot give this reason to court. Now A.K. Gopalan said, Acha, you are fearful of court. So at this point of time, A.K. Gopalan filed a case in Supreme Court using Article 32 that my fundamental rights are being abridged. A.K. Gopalan asked Supreme Court to issue a writ of habeas corpus. We are going to discuss this writ of habeas corpus when I am going to talk about Article 32. But for simplifying things for you, please understand, A.K. Gopalan leveled put a case against government saying my detention is illegal. So now this case was discussed, A.K. Gopalan case. So in that case, advocate of A.K. Gopalan said, sir, this police, this government is not allowing us to actually discuss the grounds on which A.K. Gopalan is detained. Now they were like, how can this happen? Court can ask any detail about the case. So the government said, no sir, means the government, the department which arrested A.K. Gopalan said, no sir, we cannot allow sharing of detail of A.K. Gopalan case, the ground of A.K. Gopalan case before you. Supreme Court said, ye kya mazak hai? So police department said, sir, in preventive detention law, there is section 14. In preventive detention law, section 14 says that no detail on the ground of arrest can be furnished before any other authority. So any other authority means court is also the other authority. So Supreme Court said, bakwas hai section, nikalo isko. So at that point of time, in A.K. Gopalan case, Supreme Court used doctrine of severability. Severability word comes from the word sever, S-E-V-E-R. Sever means to cut, means cut this provision out of this preventive detention law and other sections will be allowed. Okay, means A.K. Gopalan sahab, you will remain in preventive detention because grounds are there, but this basis will be shared. Okay, so procedure established by law was used there. It means court said we have gone through the procedure. So it means this particular police department has followed the procedure mentioned in preventive detention law. They have not flouted any procedure. That is why it is justified. Okay, that is why it is justified, but this section is out. Okay, so at that point of time, A.K. Gopalan said, sir, this particular section is unreasonable. This is unjust. Supreme Court said, no, we only use procedure established by law because in Article 21, Constitution mentions procedure established by law and Supreme Court is interpreter of Constitution. So at that point of time, you can see that the power of Supreme Court was quite limited to procedure established by. They were just checking the procedure, if it is followed or not. Okay. So protection only against arbitrary executive action. UPSC is going to ask question from here. Please remember the detail. It means arbitrary executive action should not be there. It means purpose of executive is to execute the law. So department was executing the law in correct manner. Supreme Court said we cannot actually put a question on arbitrariness of legislative action, because legislative action means to make law. So Supreme Court said no, we are not going to question a law made by Parliament. Okay, we are there to check whether that law is implemented by executive in correct manner or not. Right? So this is the meaning of this. Personal liberty, liberty relating to a person or body of individual. So liberty as a word in Article 21 is mentioned here. Then there was Menaka Gandhi case, wonderful case. The case was Menaka Gandhi was given a notice by Regional Passport Office in Delhi under section 10 subclause 3 of Passport Act, and she was said, madam, you just submit your passport and we are going to impound your passport. Menaka Gandhi said, why you are impounding my passport? Regional Passport Officer said, ma'am, in public interest. So Menaka Gandhi said, at least give me some time to actually present my rationale that it is not good to it is not fine to actually take my passport. Regional Passport Office said, ma'am, we are just following the procedure because it is mentioned in section 10 subclause 3 of this Passport Act. So Menaka Gandhi filed a petition, put a case in Supreme Court that this is against my fundamental right. Because before that, Sardar Satwan Sahni case was already, discussed, and Supreme Court said that right to move abroad is a fundamental right. And if you impound someone's passport, can that person go out of India? No, that person cannot go out of India without passport, and that is why this particular case was taken up. And this particular case actually added a new dimension in Indian polity. Right to life and personal liberty can be deprived. And now, in A.K. Gopalan case, Supreme Court said we are going to follow just the procedure established by law. But here Supreme Court said no, now we are increasing our power. Now I am going to use due process of law as well. What is the meaning of due process of law? It means now we are going to check whether a particular section is just reasonable or not. It means now we are not going to remain silent कि ठीक है section follow रहा है कि नहीं. Now we are going to question whether that was reasonable or just or not, because Supreme Court said if someone made the law, that law was made to actually have a justice there, right? No injustice based, no section which is based on injustice cannot continue. So in this case, Supreme Court expanded its power, incorporated due process of law. Please remember, concept of due process of law was added through taking inspiration from American system, means US system. But when it comes to process established by law, it was taken through British system. Okay? Against arbitrary action of both executive and legislative. Please remember this difference. In A.K. Gopalan case, against arbitrary action of executive, now against legislative also. If UPSC make a statement, what is the status now? Now Supreme Court can question arbitrary action of executive as well as legislative. With existence and survival, right to live a dignified life is implicit. Means Supreme Court said in Menaka Gandhi case that in Article 21, right to life and personal liberty is used. Life is not mere inhaling and exhaling. Right also include a dignified life. It means whatever necessary for a dignified life should be considered as a fundamental right. And from there, my friends, we saw Mohini Jain case where Supreme Court said, oh, education is important for a dignified life. In Unni Krishnan case, Supreme Court again said education is important for a dignified life. And that is why, my friends, later we had a separate article added in our fundamental right, Article 21A, as right to education as a fundamental right. Now attempt this question. Which rights are known as golden triangle? Because this golden triangle was a contribution of Menaka Gandhi case. Because in Menaka Gandhi case, Supreme Court said Article 14, 19 and 21 should be read together to understand the essence of these provisions. They should not be read exclusively. Now some of you might say, sir, samajh nahi aa raha, what is this golden triangle and why we need to read these three rights together? All of you are aware of Article 14, equality before law, equal protection of law. All of you are aware of Article 19, right to freedom. We just explained. Article 21, right to life and personal liberty. All of these three articles, when they are read together, they establish a principle of natural justice. And when they are read together, they also represent constitutionalism. It means the government should be restricted from taking arbitrary action, right? So this is golden triangle. This is the contribution. Now, analyze the difference between procedure established by law and due process of law. I have just mentioned you through the case, A.K. Gopal and Menka Gandhi case, but UPSC can make specific keyword-based, statement. So please remember, there's less scope in procedure established by law. We saw in A.K. Gopalan case, there's large scope. Why? Because executive plus legislative. Here, only on executive, Supreme Court can question. Correct process means Supreme Court was just checking whether correct process was followed. Here, check the law itself, whether that law is correct or not. Originated from British Constitution, originated from United States Constitution. So now you can simply understand this. It is procedure established by law. When you add masala of principle of natural justice in procedure established by law, what you get? You get due process of law. Please remember it. This reflects your conceptual understanding, right? Now, in Article 21, as I told you, it has elaborated. So we have number of rights declared as fundamental right now. Right to medical care, right to food, right to livelihood, right to privacy, important Puttu Swami case, right to healthy environment, right to education, right to shelter, all of them are now emerging from Article 21. So now Article 21 carry a variety of rights. Right to privacy, Puttu Swami case. Please remember, right to privacy is also not absolute. Means there may be some reasonable restriction scopes, right? Right against sexual harassment of women at workplace. In this judgment, Supreme Court said, if women are being exploited in workplace sexually, then this can be considered as right against Article 21 because it is against their life and personal liberty, right? And there Supreme Court issued Vishaka guidelines on whose basis we had a protection of Women from Sexual Harassment Act 2013. But my friends, reality is I have been part of Delhi government. I was working with Minister for Social Welfare as a consultant for some time. So at that point of time, I observed that most of the organizations, private, I'm focusing on private one, they are not following this protection of the details mentioned in Protection of Women from Sexual Harassment Act 2013 because there's a mention of LCC, Local Complaint Committee. If we talk about inorganized sector, Internal Complaints Committee, if we talk about organized sector. But these laws need to be adhered to give women a better place to work. Now, when you say right to life, does it also include right to die? Answer is yes. Right to die with dignity. Although, right to death is not part. It means you cannot say, oh, I have right to life means I can also commit suicide. No. It is not correct. But right to death was discussed with respect to case of euthanasia. Here you can see this image. Aruna Shanbag. She was a nurse in KEM hospital in 1970s and she was sodomized by a lab boy. And she was strangulated with chain in such a way that she went into coma. That person went into jail for 6 years and now he later got released. But the point is, at that point of time, that person was not charged with rape because IPC section 376 rape section was not considering anal sex, means sodomy, as you can say in the definition of rape. Although after this Justice J.S. Verma committee report, now sexual harassment sections have elaborated a lot, but people actually took this challenge in their hand when this Nirbhaya case happened. I hope you remember the details at that point of time. But after this Aruna Shanbag case, Supreme Court accepted that because she was in utter pain and our constitution, our law was not allowing her to die peacefully, that is when Supreme Court accepted passive euthanasia. Passive euthanasia means if person is terminally ill, that person cannot be saved. In that case, life support system can be turned off. If life support system is turned off, then that person can die. But you cannot have as active euthanasia. Active euthanasia means you have to give some chemical or some something from outside so that that person die. This is illegal in India. And passive euthanasia is applicable, but that too in selective cases. I hope it is clear to you. In our journey in part 3, Fundamental Rights, we were discussing Article 21. And within that discussion, I mentioned Maneka Gandhi case and how it enhanced the power of Supreme Court from procedure established by law to due process of law. It means now judicial review was happening in context of both executive as well as legislative actions of the government. And when I say legislative, it means legislature. After that, I mentioned Mohini Jain case, Unni Krishnan case, and how all three cases made the background for inclusion of Article 21A, right to education. I hope you remember. So today we are going to start from Article 21A. As you can see, the language, state shall provide. It means it will be responsibility of state. Now the point is, our constitution was already having provisions with respect to a state having this responsibility towards education of children. But this is mentioned in DPSP, Directive Principles of State Policy, which are not enforceable by court, right? By inclusion of these principles in fundamental right made them enforceable by court. It means children belonging to this age group, if they are not having education service in their vicinity, that's a criteria that administration is going to decide, then they can actually claim that I am not having this facility, then the state is bound to provide that. Now, my point is, can you actually mention one government scheme which take care of nutritional and preliminary education aspect of children before 6 years of age? Can you mention that in comment? Come on. I'm repeating my question. I'm saying, right to education, Article 21A, make this mandatory over the state to provide free and compulsory education for children between 6 to 14 years. My question is, can you mention a government scheme which takes care of nutritional and preliminary education aspect of children before 6 years of age? Government scheme I am asking. Answer is ICDS. Integrated Child Development Scheme. You must have heard about Anganwadi centers. So Anganwadi centers are established under this scheme. Okay. Now this Article 21A was added through 86 Constitutional Amendment Act. That's a fact. Now this is clear to you. Now talking about Article 22. The language says protection of life and personal liberty with respect to. These two words are used in this particular article, punitive and preventive detention. First understand the difference, and then we are going to discuss what kind of protection we are talking about. Okay. Now, punish a person for an offense means when the word punitive is mentioned, it means you have committed some crime. Administration has proved that you have committed some crime. On these grounds, this detention will happen. Okay, even if you have not committed, but why you are going to be arrested? Because they have a proof that you have committed that crime. Okay, but when it comes to preventive detention, it means police department do not have any proof, and they also do not consider that you have committed some crime, but they are detaining you for prevention of law and order, because you can be a security issue if you are left alone freely in this society. Okay, we discussed this preventive detention in A.K. Gopalan case as well when I mentioned section 14. Now the prime focus of this Article 22 is the facility which is provided to you. It means if you are arrested, say in case of punitive detention, then it says who is arrested shall be detained in custody without being informed. It means you should be informed. Informed should be the key word. And you should be allowed to consult a lawyer legal practitioner of your choice. Number 2, these are 2 rights. And within 24 hours, you should be produced before a nearby magistrate. And this particular provision is also connected with this fact that if magistrate allows that you should be free, then you should be free. Okay, it means your detention beyond 24 hours will happen only on the direction of magistrate. So this protection is available to you in case of arrest. That is what, or you can say detention, that is what Article 22 is talking about. Also keep in mind, these rights are not available to enemy alien or person detained under preventive detention law. Now, I'm asking, consider someone is arrested, for example, in case of Delhi riots. Many people were arrested under UAPA, okay, Unlawful Activities Prevention Act, okay. Is it mandatory that if someone is arrested under UAPA, that person should be produced before magistrate within 24 hours? This is a question in front of you, because there were many articles in news regarding UAPA and some of the provisions which were questioned that these are draconian provisions and abused. So that's a question from you, for you. UAPA, star point. Okay. Now, the 44th Amendment Act 1978, so it reduced the period of detention about obtaining the opinion of an advisory board from 3 to 2 years. Now, what is the context? In case you are detained in, say, with regard to preventive detention, then the law says you cannot be detained beyond 3 months. If you are detained beyond 3 months, then it can be done on the direction of an advisory board, and High Court judges can be member of this advisory board. Okay. Now, but 3-month detention can be done, right? Now, 44th Amendment Act 1978, it reduced this 3 month to 2 months, right? But the point is, the fact is that it is not applied. That is why I'm saying this provision is not yet been brought to force. Hence, the original period of 3 months is still continuing. So these are the example of some preventive detention laws. You must have heard about MISA, Maintenance of Internal Security Act, right? Some provisions like TADA, POTA, so they have some provisions with regard to this. This is UAPA, Unlawful Activities Prevention Act, which I have just given you as a star point. Now, we need to talk about right against exploitation. Here we talk about 2 articles only, Article 23, Article 24. Article 23, it says prohibition of human trafficking and forced labor. And within this, it mentions word like human trafficking. What is human trafficking? It is buying and selling of human. Okay, if such thing is happening with you, then it is against your fundamental right as mentioned under Article 23. Okay, what punishment will be given if such thing is happening with you? That is not mentioned in Article 23. Okay, for this you need to refer a specific law made by Parliament in this regard. Apart from this, begar, bonded labor, forced labor, they are also prohibited under Article 23. Now I am making a statement, I expect you to answer. Okay, statement is, a state cannot make any law compelling people to work without giving them due of their labor. You have to tell me the statement is true or false. I am repeating my sentence because I mentioned that forced labor is against Article 20, forced labor is against a fundamental right. It is mentioned in Article 23. I am saying state/government, means I am referring to government, cannot make any law making citizens do some work, binding you do some work without any due payment regarding your labor which you have done. So that statement is true or false? Come on. And it is a rapid fire round, so I request your responses to be quicker. Welcome Sanjay, Sajal, Chelvaraj, It doesn't matter whether you answer right or wrong. What matters is that you have attempted this question. Come on. Should I repeat the question? Everyone, bring your presence into the comment box. जिंदा हैं तो जिंदा नजर आना भी जरूरी है. So here you can do that by being in this comment box. Interaction is necessary, otherwise it will be a pravachan class. I don't want that to happen. Answer is false. Now some of you might say that, sir, forced labor, and in this particular statement government is actually forcing us to do something by law and not paying us. So in this case, government can compel you to do this for national service, okay, but not private party. Okay, this is the differentiation. So it is available to citizens as well as non-citizens. It also need to be, you should keep this in mind. So human trafficking in the form of, I told you, buying and selling of men, women, prostitution, devdasis, slavery. Okay. Apart from this, it also says protection against state and private individual. It means it gives protection to citizens as well as non-citizens, and protection against state as well as private citizens. It means no one can actually do this with you, right? And force means physical, legal, economic compulsion. Okay, when I say compulsion, it means if you are paid less than the minimum wages law which is applicable in that state, then also it will consider as abridgment of your fundamental right as mentioned in Article 23. Okay, and when I say physical, legal, economic, it means if you are made to do more work, right, that is also a part of, you can say, forced labor. Means in a circumstances which are not allowed as per labor law. Okay, then it will be a contravention of your right as mentioned in Article 23. Now these are some laws with regard to this Article 23. As I told you, Parliament can make law for your protection. Bonded Labour System Abolition Act 1976, Minimum Wages Act 1948. So this was an act made by Parliament, but various state governments also make their own act to regulate minimum wages, and that is why you will find a difference between the minimum wages prescribed in Haryana to Delhi to UP. Okay, so minimum wages will be different. And why they are different? Because the living cost in different states and different areas may be different. Contract Labour Act, Equal Remuneration Act 1976, these are the example of the laws emerging from Article 23. Exception, I told you, government. Permit state means when I'm using the word state, what does it mean? You should refer the meaning mentioned under Article 12. To impose compulsory service for public purpose. Okay, for example, what is happening in Ukraine, you know. Right now, Ukrainian government is training their civilian for military purpose. Right? If such circumstances occur in India, then Indian government can also do. Right? And now you cannot say ki how much we are going to be paid for this work which you are compelling us to do. Then government will, and you are saying this will be abridgment of our Article 23, then government will say also read exception. Okay. So military service, social service, anything can be asked. Okay. No discrimination, caste, race, religion, class only. Means in this case there will be no discrimination, and these are the 4 criteria which are mentioned. Then we have Article 24, which talks about exploitation of child labor, or you can say child. So it is related to child labor. Please understand this particular article in 2 parts. It means what provision says in our constitution and what different laws says. What is the legal standpoint with respect to Article 24? Now, prohibition of employment of children, factories, etc. And why it was needed? Reason is that children are most ill-represented section of our society. For example, if women have certain issues, they think they are not having their rights in place, rights are not being enforced, then they can make association, they can ask, they can do you can say a movement. If a particular section, caste are not having their rights entertained or they want more rights, they can also have a movement, they can also pressurize government. But do you think same can be done by children? No. That is why it is our responsibility to ensure the rights of children, right? Because you should think that if this is the reality of our society, so you should think in a scale manner, how it impacts the major landscape or the potential of Indian society, right? It is going to compromise on that. So it forbids employment of children below 14 years of age in dangerous jobs like factories and mines. Did not prohibit their employment in any harmless or innocent work. Now, please understand, there was a lot of, you can say, debate on this provision earlier. Interpretation was complete prohibition. But as it was found, that time and again, reality is found that many people, many children below 14 years, they are engaged into various dhaba and other activities, and even family work as well. And there was another side, many government officials used to abuse this particular reality and barge into some work which is conducted by some, you can say, family together, and they are engaging some children. For example, Firozabad, you must have heard about the Bengal industry. So taking into consideration, now the idea is that they cannot be allowed to work in harmful circumstances. Another is they cannot be allowed to work in school time, okay, and beyond school time they can only be engaged in family work, that is safe, okay. So this was the definition. Although many child right activists were against this definition, some child right activists were in support of this definition. At least abuse of these families will stop. At least by this, many children will be actually getting opportunity to go into schools. Now, there are certain laws which you should keep in mind. For example, Child Labor Law, Prohibition Regulation Act 1986, renamed as Child and Adolescent Labor. Now, we have a law specifically establishing a statutory institution at the level of union as well as state for the protection of child rights in India. At the national level, we call it NCPCR. It means National Commission for Protection of Child Right, and at the state level, State Commission for Protection of Child Right. So whenever it comes to the debate that whether child rights are being enforced, so at the state level you should put a question on SPCR, what is the status? You should conduct surveys, you should, you can say, channelize support from various stakeholders, be it civil society or government departments. You should ensure that. So SCPCR at state and NCPCR at the central level. Employment of Children Act 1938, Factories Act 1948. So these acts are still continuing. Mines Act 1952, Plantation Labor Act 1951, Beedi and Cigar Workers Act 1966. We have Children Rehabilitation and Welfare Fund. Now, please understand, from legal standpoint, our children are divided into two categories. Number one, children in conflict with law. Let me note it down so that you can connect it. I think black would be more visible to you. In conflict with law. This is one category of children. They also need some kind of protection, obviously, because the word children means they are not developed enough to decide their actions, what is good, what is bad for them. In conflict with law. Second is in protection, or you can say care, in protection care of law. It is also interpreted as in need of protection or care of law. Now, the Commission for Protection of Child Rights Act, so this is the overall organization responsible for this, NCPSAT Center and SCPSAT State, in conflict with law. Whenever there is a case that some children have committed crime, so in this case, we have JJ Act, Juvenile Justice Act, which was also in news few times back, especially after Nirbhaya issue, right? So in this case, the decision is taken by JJB, Juvenile Justice Board, how much punishment should be given to this particular child who has come in conflict with law. Okay, for example, murder, dacoity and other activities or theft committed by children. Okay, but there are some children who are in need of protection of law. It means orphan, destitute. So in this case, we have a separate body, CWC, Child Welfare Committee. It is also known as Children Court. Okay, so two separate mechanisms are in place. And with respect to the definition of children in JJ Act, it was amended. And now when it comes to the definition, because general definition is that below 18 years of age, you are child, right, in eyes of law. But in case of Nirbhaya, you know that one of the culprit, he was found that he was less than 18 years of age, and that is why he could get a punishment of just 3 years, right, as per JJ Act. But later it was amended on the recommendation of Justice J.S. Verma committee report. And now, if someone is between 16 to 18 years of age, in this case, to take decision whether this person is a child or an adult, this decision is taken by JJB. Juvenile Justice Board is going to take decision. If JJB said that person is 17, but the mentality of that person with which that person committed crime is an adult mentality, in that case, now that child, earlier we were considering that person as child, now since JJB has declared him as adult or her as adult, now that person will be transferred for a trial in normal court, means a sessions court if this is a case of crime, right? I hope it is clear. Now, coming to right to freedom of religion, right? So we have two articles in this case, Article 25, Article 26. The major difference between two articles is that Article 25 deals with individual freedom with respect to religion. And when it comes to Article 26, it talks about religious, your freedom related to religion, but in terms of group institution, so that rights associated with managing the affairs of that particular, you can say, institution. Now, just check this question out. Right to freedom of religion means religious instruction shall be provided in all government education institutions. It's a quite direct question. I would appreciate if you attempt this question. Come on. I hope this is visible on your screen. Yes. Please answer in comments. एक तो होता है easy और एक होता है butter. So this question is like a butter. Religious instruction shall be provided in all education institutions. So this statement is wrong. No such case is there. Okay. Right to religion does not mean that in all the institutions this religious instruction will be provided. A state shall encourage religious thinking. Why would state encourage religious thinking? Bakwas hai ye, right? Give preference to person with religious bent of mind. Sarasar galat. Now, person shall have right to establish institution for religious and educational purposes. This is correct. So this is one of the right you have in right to freedom of religion. So answer is C. Okay. Now, let's start with Article 25. Now, let's take a look over what actual clause says. Okay. And I'm also going to ask one question from this particular article. Article 25 of the Constitution guarantees freedom of religion to all persons in India. Please give your focus. The word persons is used, okay? It is not citizen, right? And I told you clearly that at some places the word is person, at other places the word is citizen, right? And another word which we are going to find in Article 2930, that is minority, okay? So now it provides that all person in India subject to public order, morality, health and other provisions, means these are reasonable restrictions. It means your right to religion should not contravene public order, right? You cannot say I am going to exercise my right to religion and I am going to conduct a ritual in between highway. Okay, I'm not going to stop this ritual because this is my faith and this is my fundamental right under Article 25. So if you try to do so in between highway, then you will find a police party which will take you to the Havalat to do some seva, okay? Because expressively, but it is clearly saying that it is not available in case you disturb public order, morality, health and other provisions, okay? Are equally entitled. Now these are your rights. Freedom of conscience. What does it mean? It means you can have belief in whatever religion you consider fit for you, right? So that is at your internal level. Have the right to freely profess. Now profess is connected to your declaration, yes, this is my religion. Practice. Practice includes you conducting ritual, prayer and other practices which are associated with that religion. And propagate religion. And you also have this right as fundamental right under Article 25 that you can propagate your religion, propagate the ideas of religion so that other can also follow your religion. But as I told you, our fundamental rights are qualified in nature. So that is why we have restrictions here too. Now, let's go word by word. First is conscience. It means you can choose the path you want to follow. Profess, you can declare your faith. Right to practice means ritual, ceremony, exhibition, worship, belief, idea. All of this comes under right to practice. Right to propagate. Transmission of one's belief. No right to forcible conversion. Now, take example. If Sajal wake up next morning and he talked to his mother and father that last night I had a dream and I want to convert into another religion because God has given me this message, and he is about 18 years of age and he has also gone through polity. So his mother and father will say, no, you cannot do this. So he will say, if you try to stop me, I will go to Supreme Court using Article 32 because this would be against my individual right as given in Article 25. Because I have conscience, I have professed to declare religion, and I have this right to practice. And he also started from that evening he started practicing that religion. Now, in the night he met his siblings, and now he exercised another right to propagate his religion. So as his mother, father were looking at him in anger, he said, no, you cannot do so. Article 25, right to propagate. I'm going to propagate my religion among my siblings. Now, so his siblings are not interested to actually go his way. So what he did, he brought some chocolates and he presented that if you convert into my religion, I'll give you chocolate. Now, do you think that is also his right under right to propagate? No. Some of you might say, sir, this is forcible conversion. But giving chocolate is not forcible. That is a choice. If they are lured towards chocolate, then they are converting. So is it against this? Is it covered under this? No, it is not covered. It means when I say forcible conversion, it includes whether you must use muscle power, or whether you use any kind of arm twisting, or whether you lure that person for any kind of money or gifts. That will also be considered as that will be considered as illegal. Okay, that is not covered under your right to propagate. Now, it further provides that this article shall not effectively affect existing law and shall not prevent the state from making any law relating to. What does it mean? It means you have this right, but a state can actually intervene in your religion also in case regulation or restriction of any economic, financial, political, any secular activity associated with religion practice. Consider your practice, your ritual is contravening into fundamental right of a large section. Can state allow you to do that? No, state cannot allow you to do that. Take example of triple talaq, Sabrimala temple issue. What was happening? In Sabrimala temple issue also, one section was saying those who were restricting the entry of women into Sabrimala temple, they were saying that Supreme Court analysis or judgment is against our Article 25 and 26. Why 25? They were saying this is our individual belief that women should not be allowed because Lord Ayappa is celibate, brahmacharya. So at that point of time they said no, a state can intervene, right, if it is against the definition of morality and it causes public order, disorder. So and you know, in this particular judgment this word also became popular, constitutional morality, right, and UPSC also asked question from that. Now providing social welfare and reform, and you can also see that Sabrimala judgment or triple talaq judgment are considered as a reform, and this has been done by state. Opening of Hindu religious institutions of public character for all classes, sections of the Hindus. This is expressly mentioned in under Article 25. Now some of you might think, why constitutional framers specifically mentioned the case of Hindus? Why not other religion? First of all, you should know who are covered under this definition of word Hindu. And there's a debate over it obviously, but the definition include Hindus, Sikhs and Jains. Apart from this, you should also know that why this provision is mentioned specifically on Hindus, because in Hindus it is found due to this caste discrimination, a section of our population is not allowed to access these religious locations, for example our temples. So this is against their Article 25. This is clearly mentioned in our Article 25. Okay. Now recently you saw hijab debate, right? And some parents were saying, if we have to choose between hijab and education, we are going to choose hijab, because what is happening is against our Article 25, because it is part of our right to practice our religion. So on this point, this judgment by Karnataka government that we are going to bring uniformity in uniform, right, and there will be a common code and hijab will not be allowed in school. So on this point, the counter argument was hijab is integral part of Islam. Can state intervene into a practice which is integral part of a religion? So now what is integral part of religion? This particular debate started from this Tilkayat Shri Govindalaji Maharaj case. So what Supreme Court said here? Held that test to determine the actual status, whether this particular practice is an integral part of religion, it will be based on the belief which is held by majority of people of that religion. This was the analysis. You can read. What is an integral part of religious, whether it is regarded as integral to the community, that religion or not. So community is going to be, understanding the community is going to the basis to decide whether it is integral or not. Okay, for example, Kirpan, Kada. So these are considered as integral for Sikh because it was given as a sermon by the Guru. But same is not true. It is said that same is not true with respect to Islam. There's a debate going on. Some say it is, some say it is not. But you should know the case and what Supreme Court said, how it is going to be determined. So it is not going to be a unilateral decision of state. It will be based on the specific community. Now these rights are subject to public order, morality, as I told you, and state is permitted to. What state can do? Regulate, restrict, economic, financial, political. I have already told you. Provide social welfare and reform to all classes and sections of Hindus. I told you. Now, Next article 26 is freedom to manage religious affairs. So when I say religious affairs, it means it is also about managing movable, immovable properties. So it means we are talking about ashrams, madrasas, temples, gurdwaras. So now every religious denomination means a organization which belongs to a particular religion. Okay, because if there is an ashram, so that ashram must be registered in someone's name. There must be some group which is actually taking care of this particular area. So the right to establish, you have right to establish, maintain institutions for religious and charitable purpose. This is a fundamental right under Article 26. Now, subject to public order, morality, health, every religious denomination shall have this right. Okay, and what the rights include? You can manage this institution, establish and manage, to manage its own affairs and matters of religion. Now, this was the basis, this was one of the basis of the section which was opposing the move of Supreme Court in Sabarimala case. They were saying if Constitution itself is saying that in matters of religion we can manage our affairs, then how can Supreme Court intervene? To own and acquire movable and immovable property, right? To administer such property in a way they want, but as per law. It means law need not to be abridged. Now, I'm making a statement and you have to tell me that statement is true or false. Okay. As per under Article 26, a particular religious group has the right to manage its affairs. As an extension of this right, a particular religious group can excommunicate a particular person from religion. So that statement is true or false? Those who are wondering what is excommunication, it means you will be considered out of religion. So is it legally possible? Is it legally allowed that yes, it is a fundamental right under Article 26? Yes, no, yes, no. Come on. क्वेश्चन समझ में आपको? So answer is it is not allowed. Okay. So prevention of excommunication, and this was Saifuddin Sahib versus State of Bombay case in 1962. And in this case it was cleared. Excommunication means, I told you, the exclusion or expulsion of a person from a community or group which she was a member. And in this case excommunication was declared void. Okay, it should be clear to you. Now, 3 conditions of religious institution. I am using the word religious institution now. So what is religious institution? Can one fine day Sanjay Basi wala, so he can actually come up and say, I am purchasing a property and this property should be considered as a religious institution. So there's a criteria to that. First of all, collection of individuals who have system of belief which they regard as conducive to their spiritual well-being. This is one condition, because this is a religious institution. It is not a private institution. It is not an individual. It is a group of individuals who are part of religion. Now, common organization should be there and designate. So they should have a distinct name. So this is the criteria to decide whether this institution is a religious institution or not. Please remember these kind of details, because UPSC play on these lines, and these are the kind of statements we often miss while reading Lakshmikant. Now, talking about Article 27, freedom from tax and promotion. It simply means government cannot impose a tax for promotion of a particular religion. What does it mean? It means one fine day, if one leader actually stood up and on television and he says, Bhaiyo aur Behno, aaj raat 8 baje se, from today, from 8 p.m, now we are imposing another cess, that is Hindu Vruddhi cess. So can this happen legally? No. It will be considered as a contravention of Article 27. Okay. This example was given so that it can connect, well in your mind. Okay. Otherwise, we should have, since you have to be part of system, then you should be authentic and you should be neutral in your learning, understanding and then expression. Please keep in mind. So no tax can be imposed for promotion of a particular religion. First of all, it prohibits only levy of tax. It means there's a difference between tax and fee. Fee can be taken from people who are participating in a particular, you can say, religious congregation or particular area. But tax is different. Tax is imposed on a particular category of people. Let me tell you the difference. If Kumbh Mela case is referred, so as you go to Kumbh Mela, so you will find that you have to pay a minimum fees of 5, 10, 15 rupees. So this fee is collected by government, and then government department spend this money for upkeeping of that area. So at that point of time, you cannot say, oh, government is actually using this money which government has got as a revenue for promoting a particular religion. No, because that was a fee. That was not a tax. Okay, it was not taken from all. It was taken from those who were coming into that area for getting the service of that area. Okay, no public money collected through taxes. It means one is you cannot impose tax to promote. Other is the revenue you have, you cannot use that revenue for promotion of a particular religion. Okay, that would be against secular credentials. So you can see that Article 27 is representing secularism. Favoring, patronizing a particular religion, that is prohibited. Okay, purpose क्या है इसका? To control secular administration or religious institution, not to promote and maintain religion. So it is quite clear to you. I have explained this. What does it mean? Now, Article 28, talking about allowing or disallowing religious instructions in institutions. So, just read Article 28, subclause 1. It mentions the word wholly maintained. No religious instruction shall be provided in any education institution wholly maintained out of state funds. And UPSC play on these words: wholly maintained, administered, established, funded, right? So you need to give attention to these details. Everything will be clear. Nothing in clause 1 shall apply to any education institution which is administered by state. Now, there's a difference. Wholly maintained by state means government is funding the whole institution as well as administering the whole institution, whole upkeep, so totally owned by a state. But in this case, it is administered by state, but established under any endowment, trust which requires that religious instruction shall be imparted in that institution. For example, what happened? Some you can say businessmen came together, they established a trust and they pooled their money, okay, and they established an education institution. But after that, they tied up with the government that we don't have know-how of running this education institution, so please you administer this education institution. It means when it comes to appointment of teachers, principal, staff, so these government employees will be administered by the government, and government official of that particular district will take care of the administration. But the establishment was happened by trust. So in that case, this subclause 1 is not going to be applicable. Okay, religious instruction may be given, but the word is may be given. I have not said you are compelled to actually be there and listen to those religious instructions. There is a difference between the two. As of now, we are talking about given or not given. Okay, no person attending any education institution, now it is about you, recognized by the state or receiving aid of the state funds shall be required. Now, recognized by the state, what does it mean? Every education institution which is working, majorly of education institution, they are recognized whether by CBSE, right, ICSE or any state government, right, receiving aid out of state fund, shall be required to take part in any religious instruction that may be imparted in such institution. So you are not compelled to be there or to attend any religious worship that may be conducted in such institution or any premises attached thereto unless such person, or if such person is a minor, in that case guardian's permission is needed. Let me share one case. In one case where Kendra Vidyalaya was in news, two students, they came into the assembly and they said the prayers the prayers were starting from this mantra. The mantra which is belonging to obviously to Hindu religion. So they said we are not going to be part of this prayer. So the principal said no, it is our decision that every student should be part of the prayer. If you are not participating regularly, then it would be considered as indiscipline. Then these students said, and the parents said, actually this is against my my fundamental right under Article 25. Because my religion says that I have to uphold the practice of my religion and I should not do that. So that principal expelled those two students. So that matter was heard by Supreme Court. So in that case, Supreme Court said no. That these children cannot be bound to be participating in religious instruction. Okay. So this was coming from Article 28, subclause 3. So now I hope this is clear to you. This is a representation of the discussion which we just had. So now attempt this question. Institutions administered by state, established under any trust, government school, state university. Article 28 is applicable on. Come on. This is a good question. Take note, the word is administered. And you should also know that when UPSC is going to make a statement, UPSC will actually elaborate this. Okay, what UPSC will say? It will say that as per Article 28, no religious instruction will be provided in which of the following type of institution. This is how a statement will be expanded here. Consider this as a statement. Okay, then these options will be given. Then tell me what is the right answer. First of all, the word is administered, and I have already told you when I was explaining subclause 2 of Article 28 that please remember these religious instructions are banned in wholly maintained institution, but it is administered, so it means this should not be the answer. Established under any trust, and within subclause 2 I also mentioned the trust case, so this cannot be the answer. A government school means wholly wholly owned by state, so it means this is true. A state university, it means it is also about government wholly maintained, so it means answer is 3 and 4. Okay, now I'm making last statement of my class. Cultural and educational rights as mentioned in Article 29, Article 30. Thereafter we are going to discuss right to property, its status, then Article 31A, 31B, 31C in a simple manner. We are going to do operation on these provisions so that those details are visible to you on which questions are asked in exam. So two aspects, culture and education, and these rights are available only to citizens. This is one statement which can be asked. Now take a look over the title, the language which is used. Protection of interest of minorities, that is Article 29. So word minority is used in Article 29, okay? But that does not mean that our constitution defines the criteria on which minority status will be given. Although two types of minorities are recognized in our constitution within these set of rights. One are religious minority and other are linguistic minority. Okay. So now we have two clauses within that, 29 subclause 1. So it talks about your right to conserve your language, script and culture. Okay. So this right is a right given to group. Okay. Because a group will have a language, a group will have a script, a group will have a culture. Right. Now, but when it comes to 29 subclause 2, this right is available to you as an individual. Okay. No discrimination in education institution. My friends, Article 29 subclause 2 is not talking about minority institutions. Please keep this in mind. Some students actually link it like this, that since the title itself was saying protection of interest of minorities and subclause 2 is talking about no discrimination in education institutions, so they actually mix things up, but you should read it separately. Okay, so it says that no discrimination will happen with you on the basis of religion, race, caste and language, any of them, in an educational institution maintained by the state or receiving aid out of state funds. Okay, so this particular right, subclause 2, is available to you as individual, and these LSC, language, script, culture, so these are available to you as group. Okay, these kind of statements are made. Now, if I ask, can rights mentioned under Article 29 be accessed by people other than minorities? Now, what would be your response? Some of you would say, sir, what kind of question you are asking? It is quite common. It's obvious. Since the word is minority, it means only minorities will be able to access the rights mentioned under Article 29, subclause 1, subclause B, right? That is what you were thinking. But my friends, that's not true. Because Supreme Court has interpreted this provision in a different manner. And I'm also going to tell you what the reason was. So first of all, Article 29 grants this right to minorities on the basis of religion and language. I've already told you, 2 kinds of minorities are mentioned. Okay, so there was a debate that whether these rights to preserve language, culture, script are available only to minorities. What if some other people who are in majority, they want to take actions for preserving their script, and if any government authority is restricting them to actually take some steps to conserve their script, language or culture, can they knock the doors of Supreme Court using Article 29? So some scholars were saying, legal luminaries were saying, no, Article 29 subclause 1, subclause 2 won't be available to people from majority, because majorities won't need to conserve their language, script, culture. This need is only to the minorities. But as this debate was going on, and when this debate reached Supreme Court interpreted in a very beautiful manner. What Supreme Court said, the scope of this article is not necessarily restricted to minorities only. Okay? It is commonly assumed to be, since you read this title of Article 29, minority is mentioned. That is why you assume that. Sections of citizen word is used in the language of these clauses. Take a look. Article 29 title says Constitution of India, protection of interest of minorities. But when you read this language in subclause 1, it says any section of these citizens. So now Supreme Court said, since it is saying any section of citizens, it means it is available to every section of citizen, right? Residing in the territory of India or any part thereof, having a distinct language, script, culture, 3 things, LSC, its own shall have the right to conserve the same. So on the basis of this, now Supreme Court has interpreted this is not restricted to minorities only. This can be a statement in your exam, and many students will fall into this trap. Okay, but you are not going to do. Now, no citizen, subclause 2, which is available to you as individual. It says no citizen. It is not saying no citizens who are minority. Okay, shall be denied admission into any education institution. Any education institution, I told you it is not talking about minority education institutions, because that is mentioned in Article 30, not 29. Maintained by the state or receiving aid of the state funds on grounds only. Now grounds, on grounds questions are asked. Religion, race, caste, language or any of them. My friends, there are 4 grounds mentioned here. 4 grounds only. Okay. Now, I hope now this is clear to you. Right to conserve the language includes right to agitate. For example, if government authorities, state is not taking enough actions to preserve, or you can say conserve, your language, script and culture, and you want due efforts to be made, then you can agitate. And this right to agitate can also be considered under the definition or interpretation of Article 29. But this agitation is specifically for conservation of LSC. Okay? Please remember it, because if a statement is made in this manner that a right to agitate can be inferred through the interpretation of Article 29. So some students might think, oh, it should not come here. It should be related to Article 19. Okay, these kind of traps are leveled. Okay, but I hope now you are clear. It is interpreted in this context. Now, take this question. Article 29 subclause 2 protects from discrimination on the basis of, because basis is mentioned in subclause 2, which is available to you as individual. So what bases are mentioned? 4 bases. I have just told you. 4 grounds. Come on. Religion, caste, race and language. Now take a look in which option these 4 are mentioned. I hope it is quite visible to you. So this is the answer. Okay. Be prepared for such question, and the best way to remember these grounds is make a mnemonic. Okay. Mnemonic means some code. Okay. RRCL, right? And within R have this differentiation. Okay. RR means religion and race. Now, there's a difference between Article 15 subclause 1 and Article 29 subclause 2, because why there are similarities? Because both talk about discrimination. Okay. But there's a difference on the kind of discrimination and the grounds of discrimination. Protects rights only against the state. Subclause 1 I am saying. 15 subclause 1, we discussed it. Subclause 2 and on, they talk about state as well as private individual. But subclause 1 of Article 15 talks about only state. Right? Protect right against state and other institutions as well. Okay? Prohibits many type of discrimination in Article 15 subclause 1. Right? But in this case, it is talking about admission into, means special actions like admission into education institution, because word education institution is specifically mentioned in Article 29 subclause 2. And why? Because the kind of rights we were talking about are cultural and educational rights. Right? Cultural aspects have mentioned in Article 29 subclause 1, LSC, language, script, culture, and educational rights are mentioned in Article 29 subclause 2, and other educational rights with regard to minorities are going to mention in Article 30. We are going to talk about it. Now, this clause covers a wider area, and it is applicable on all citizens irrespective of minority or majority. Now, only relate to admission into education institutions maintained by state or receiving aid out of state funds. And this is applicable also on minority as well as majority. Please remember that, because this is a trap which UPSC is going to ask. Prohibits discrimination on the basis of sex and birthplace also, because Article 15 mentions what? What are the grounds on which state shall not discriminate? Religion, race, caste, sex, place of birth. But in this case, it is religion, race, caste and language. Right? So these are not the basis. Sex and birthplace are not the basis here. Are the basis? These are not the basis here. And what does it mean? It means that when it comes to admission to education institution, discrimination can be done on the basis of sex and birthplace. It means some education institutions may be restricted for women only, for men only. Okay? And place of birth can also be a criteria, that from this particular region only we are going to allow people to have admission. Right? So that's why these provisions were made. And these provisions were actually left when we talk about Article 29 subclause 2. I hope it is clear to you. Right? Now, take into consideration this question. If you give attention to each statement which is mentioned here, your understanding of Article 29 will be Jhingalala. That's my promise to you. Although answer is quite clear, but same statements can be used by UPSC in a different manner. UPSC can actually, what UPSC can do, UPSC can remove this statement, okay, and they will give these three statements and ask you which of the following statement is not true. This question is direct. This question is saying with respect to minority institutions, which of the following is correct, right? And first statement, the protection of Article 29 is available to Indian citizens only. So this is correct. This is the first sentence which I shared with you, that cultural educational rights are available only to citizens, culture, citizen, right? So this, when it comes to this question, answer is A. I'm saying if this question is reframed, okay, and now UPSC asks which of the following statements, okay, and you have no idea about these statements, right? Abhi to clear ho gaya ki theek hai, one is the answer. Now read the statements. A state cannot acquire the property of a minority educational institutions in any circumstance. What do you think? Means, can state acquire a madrasa or any religious education institution? What do you think? Is it true or false? Use your logic. So those who are thinking, no sir, we are a secular country, how can government do that? If government acquire a madrasa or any other religious education institution, it will create riots. It will be against the constitution. My friends, these kind of talks are apt for a politician. But you are here to get into civil services, right? So you have to be authentic and you should have clear-cut knowledge, okay? This particular statement is false because government can acquire a madrasa or any other religious institution, but there is a condition. Condition is adequate compensation need to be given so that their rights are not abridged, okay? So it means adequate compensation need to be given, and then yes, it can be acquired. So that with the compensation, the community, the people who are managing that religious institution, they can have some alternative mechanism in place. Okay. Now, third statement, the institution that neither seeks recognition nor aid from state is not a minority institution. Another beautiful statement. To have this understanding, first you should know what is a minority institution, how it is going to be categorized. So there are three categories of minority institutions. Three categories. What are these three categories? Let me show you quickly. Yeah. Minority education institutions are of three types. First, institutions that seek recognition. For example, recognition from a government board. Okay. Recognition as well as aid, means funds or some help from government. So this is one type of minority institution, having recognition as well as funds. Second, institutions that seek only recognition. Paisa nahi chahiye, paisa bahut hai, right? They don't need money. They only need recognition, so that other students can actually trust that education institution and they can come and study there, right? So this will be considered as a minority institution also. Okay, just recognition and money both. Okay, so here you have R and A, means recognition and aid. Here you are talking about just recognition. Okay, and these two are actually categorized as minority institutions under Article 30. But there is a third criteria also. Who don't want, जो इन सब चीजों से ऊपर उठ चुके हैं, right? उन्हें ना तो recognition चाहिए, ना aid चाहिए. They don't want recognition of government. They don't want aid from government. And yet they can be considered as minority institution. Okay, so institutions that neither seek recognition nor aid from the state, these are also minority institution, but they are not going to be defined as minority institution under Article 30. But since I am saying minority education institutions are of three types, so it means it is third type. Okay, but not as per Article 30. These details should be clear in your mind because UPSC is going to play on these points. Okay. Now, go back to the statement. The institution that neither seeks recognition, nahi chahiye recognition, aid nor aid from the state is not a minority institution. Don't you think that statement is false? Because it is a third type of minority institution. right? Now, a state cannot regulate the syllabus of such an institution if it is funded partially by the state. क्या मजाक है? If a state is going to fund you, then state is going to ensure the syllabus also. Okay? So here it is saying cannot means कर ही नहीं सकते. That's not true. Cannot is not true. Okay, there may be a case that you only required aid and you did not require recognition. In that case, a state can say, since you are not recognized with us, but we have just funded you, okay, we are leaving you, decide your syllabus on your own. But if you are taking money and you are recognized, so there can be a possibility that you are taking money and as well as recognized. So in that case, you are saying that the state cannot. How state cannot? State can regulate. Okay. So in these kind of questions, you should take a look that if UPSC is making a statement which is absolute in nature, cannot only, then you should be on red alert. Is there an exception which can happen? So there you can actually identify that statement is true or false. Okay, an understanding we are going to gain in this series, you need not to worry. Okay, now, so the explanation which I shared with you is explanation mentioned here. This PDF will be available in this Telegram group, Shashank Tyagi, for you. Okay, I'll share the detail in the last, so you can have this PDF there. Now, right of minorities to establish and administer educational institutions. This is Article 30. Please give attention to words. Right of minorities, establish and administer. Okay, now bell should ring in your mind. Okay, it means now they're talking about minority institutions only, right? But in Article 29 subclause 2, we were using the word educational institutions. Okay, no discrimination in educational institutions. Okay, but here the word minority institution, right? Right of minorities to establish, administer education institution is mentioned. Now, also known as Charter of Educational Right. Okay, so if UPSC says Article 29 is considered as Charter of Educational Right, that statement is false. Article 30 is considered as Charter of Education Right. Please remember that. These kind of factuals are also asked. Now, right to establish and administration education institutions of their choice. And when I am saying of their choice, what does it mean? The choice word is also quite elaborate. Okay. So when I say choice, just choice include choice of how you are going to conduct the examination, how you are going to appoint the staff, how you are going to admit the students, how you are going to teach. It means, keep in mind that when I am using the word minority institutions, you should not relate that minority institutions will only be there to provide education related to religion or a particular language. No. They can opt for modern education, IT, engineering and others also. For example, Jamia. Jamia is a best example of minority institution, right? So many type of courses are there. In granting aid, the state shall not. Now, in Article 30, our constitution framers also actually added a protection layer to these minority institutions. Why? Because we have UGC at the center, University Grants Commission, whose purpose is to provide grants to these higher education institutions. Now, since minority institutions enjoy significant autonomy by virtue of Article 30, there can be a possibility, there could have been a possibility that UGC would say, oh, so you are the one who are going to enjoy your own autonomy. Other universities are working as per our directions, but you enjoy autonomy. Okay, so now we are going to give you less funds. So this minority institution would say, no, you cannot do this because Article 30 gives us this protection. Okay, so in granting aid, a state shall not discriminate against any education institution managed by a minority. Okay, so you have many minority institutions. For example, you have Khalsa College in Delhi University, you have St. Stephen's College by virtue of a Christian society which opened it, right? Similarly, you have Mahavir Tirthankar University in Moradabad, right? So rights of minorities, whether religious or linguistic. So two type of minorities I've just told you. Now, I asked whether government can acquire a madrasa or any other religious institution. So you know the answer. Yes, it can be done. 44th Amendment Act 1978, to protect the right of minorities in this regard, the Amendment Act deleted the right to property as a fundamental right under Article 31. Now some of you might be thinking, why we are talking about 31 here? Because people were interpreting this education institution right of minority with property as well. So the compensation amount fixed by the state for the compulsory acquisition, means acquisition can happen, government can acquire, of any property of a minority education institution shall not restrict or abrogate the right guaranteed to them. So shall not restrict or abrogate the right guaranteed to them, it simply means that compensation should be enough so that they can have some alternative mechanism in place, so that future of those students who were dependent or who were relying on this minority institution, that should not be compromised. This should be the priority. Okay. Now, Article 29 is about, means it is available to both minorities as well as majorities. I told you the interpretation made by Supreme Court about the language of 29 subclause 1, subclause 2, right? But Article 30 only to minorities or on the basis of religion and language, and these are available only to citizens. So both are available to citizens, but this is available only to minorities. Okay, so a statement can be made by UPSC on this particular differentiation. Please remember this. Okay, I have explained you the reason also. Okay, now so I have told you that 3 types of minority institutions, right? And these 2 types are under Article 30. Recognition, aid, Article 30. Only recognition, then Article 30, right? Now there are some guidelines related to minority institutions. So these guidelines were elaborated after Secretary Malankar's Syria Catholic College case in 2007. Now, so it summarized the general principles relating to establishment and management, and why this case actually came into being. Because the word establishment is quite clear. Okay, establish means you are starting. But when it comes to administration, so it is quite elaborate word, because so many aspects are there in administration. Hiring faculties, having a criteria for admission, deciding the syllabus, paying the faculties, taking fees from students. So all of this comes under administration. Now the question was, if Article 30 should be interpreted in such a manner that this minority educational institution trust will decide faculty criteria on their own. For example, if someone you have to hire as a faculty to teach, say, engineering students. So common criteria is that person should at least have Masters in Technology, MTech. Okay. But if there is a minority institution, and can they make a criteria that for teaching BTech students, we can hire a person who is having diploma in engineering, right? Do they have this kind of power, this kind of protection that government cannot do anything, whichever criteria of hiring faculties are made? What about fees? So can they charge on their own? What about passing marks? Can they actually make a criteria that for us 15%, if 100 out of 15 marks you gain, you will be deemed passed. So if they start giving degrees on this basis, don't you think it will be actually a harm to our overall education system? It will be harm to the future of those students as well. On what basis, on what standards you are maintaining for actually giving these degrees? So don't you think this is actually a valid question? How this word administration need to be elaborated? What kind of powers are there under administration, right? So that's why this was elaborated. Now, right of minorities to establish and administer education institutions of their choice means Article 30. So these are the choices. First is choose. It is governing body and manage the affairs. There will be a governing body of minority institutions and they will manage the affairs. Appointment, teaching staff and non-teaching staff, both will be there, and there will be some standards in place which they need to follow also. Admit eligible students of their choice and to set up a reasonable fee structure. Okay. use its properties and assets for the benefit of the institution. It is not like, since it's a minority institution and now trust is actually one part of that particular property, now trust is using for personal purpose, booking that property for banquets and cancelling the class, and now change the whole institution into a marriage hall, and just some area are allowed for education institution. This kind of fraudulent activities cannot happen, because this was clearly mentioned in Supreme Court guideline. Ensure equality with the majority. Now, this was another important development. Supreme Court said giving Article 30 is necessary, means for protection of the educational interest of these minorities. But it should be understood that ensure equality with majority not intended to actually place the minorities in more advantageous position. Means if minorities are given these rights, that they can establish their institution, right? So it should not be considered that they have this advantage but majority do not have this advantage. It should not be treated in this manner. Okay. The general laws of the land relating to national interest, national security, social welfare, public order, morality, health, sanitation, taxation, etc. will be applicable to all. Even if you are a minority institution, but you have to adhere to these guidelines. Okay, you cannot consider that special preference are given. So that's why they will be you can say different from you can say application of these provisions. These are mandatory provisions, will equally apply to minority institution as they apply to majority institution. I hope now you are able to actually understand why this word ensure equality was used. Ensure equality in what context? In that context, in this context. Okay. Now, the right to establish and administer education is not absolute. Is not absolute. What does it mean? Consider there are 5 wealthy people belonging to a minority community, and they apply that we want to start this minority institution. And if government is not allowing them, no, we are not going to allow you, we are not going to register your institution as minority institution. They cannot say, oh, this is wrong, we'll go to Supreme Court under Article 30. Even if you go to Supreme Court under Article 30, government will say that there is a guideline in place. For example, if guideline says if you want to establish a university for minorities, then you should have at least this much strength of staff, you should have this much financial capability, you should have these many labs in place, you should have this much land. So the basic criteria to establish an institution should be there, then only you will be allowed to establish. You cannot say, since I'm minority, I can start a university in my home. Now I'm converting my home into a university. You cannot do that. Okay. Nor does it include the right to maladministration. Means if you have privilege, but privilege cannot be considered as a maladministration. I'm going to run the administration on my own. No, you have to maintain the standards. The unaided minority education institutions who are not taking any aid, finances, will have the freedom to appoint teachers, lecturers by adopting any rational procedure. Please remember, my friends, the word rational procedure is mentioned. It means even if you are not taking any money from the government, okay, but if you appoint teachers who are not qualified enough, then it is like compromising the future of those students, and at that point of time government can intervene there. Okay, don't you think it is a necessary step, right? That's why regulation by government is a good step in that scenario. Now, the conditions can be imposed by the state to ensure proper utilization of the aid. Proper utilization of the aid means government will play on this intricacy. If you have got 1 crore rupees as a financial aid from the government, then it is not like your prerogative to actually spend it in your own manner. Let's organize a fest in this minority institution and we are going to bring some famous artist. You cannot do this in this manner, right? You have to be rational while you spend money without, however, diluting and abridging their right. It means a balance will be maintained by the government. It is not like government is going to pinpoint on every step, but government will ask whether that money is actually being spent in a right manner or not. Okay. So this was Article 29, Article 30. I hope these details are clear to you. Now talking about Article 31. So Article 31 was repealed. Repealed means it was removed from our constitution, fundamental right part, and then it was added as Article 300A. Means it is a right mentioned in our constitution. But now you cannot knock the door of Supreme Court using Article 32 saying it is my fundamental right. Fundamental right status was taken. Okay. Now, so before this repealment happened, actually right to property was mentioned at two places in our fundamental right part 3. What were the two places? Article 19, subclause 1F. Okay. So what it said? It said everyone has the right to acquire, hold and dispose of property. Okay. Acquire means purchase, hold means to maintain and dispose means to sell. So earlier this was a fundamental right given to you. Okay. Now, when I'm using the word property, what is coming into your mind? Most of the students think property means land. Sir is talking about land. But property is an elaborate term. There can be movable property, there can be movable property, right? So movable properties are also your properties, right? So you don't have that fundamental right now. Okay. Apart from this, Article 31 also mentioned about a right to property. No one can be deprived of their property. Okay. But after 44th Constitutional Amendment Act 1978, both of these provisions were repealed. Okay, means removed from part 3, and fundamental right now was given the status of constitutional right under Article 300A, because it is mentioned in Constitution. That is why we are using the word constitutional right. Okay. So you should keep in mind that if this fundamental right is taken, it is not like government will knock on your door tomorrow and government will say, since you don't have this fundamental right, now you have to empty your home within 24 hours because we are taking over this. And if you ask, sir, what we are going to get, then they will say, they cannot say that you are not going to get any penny. Okay, it means government can take your home for national importance, matter of national importance, but there will be suitable reason behind it. Okay. There should be suitable reasons, means arbitrary action will not happen. Okay. Now, so if government take this land, then government is going to compensate you. Government is going to provide money to you. Okay. What are the provisions for the compensation? That how much compensation will be given to you, on what basis? So now for compensation, we have two segments. For example, Article 30, property of minorities, they have their own compensation mechanism which is given due priority. It specifically mentioned that compensation should be such so that this right of them under Article 30 should not be compromised. As I told you, alternative mechanism they can settle so that future of those students who were actually relying on this institution, they should not be compromised. But when we talk about Article 31A, it is talking about a tool by which your property can be acquired by government, property within statutory limit. Now, what is the statutory limit? So, in some states, government started this land ceiling law. So, what is this land ceiling? Consider, you have one student, Rahul. Okay. So, Rahul was having 100 bigha land. Bigha is a unit of land, okay, area. Now, UP government enacted a land ceiling in which under one name a person cannot have more than 70 bigha. Okay. So, statutory limit means as per law made by Uttar Pradesh legislature, now the law says 70 bigha is the statutory limit. It means 30 bigha of your land will be taken by government. Now, how much compensation will be given to you? Now, just mention in comments how much compensation will be given to you if it is found you are having land above this statutory limit. How much compensation? Answer is 0. Mat baniye hero. You will be given 0 rupees. Okay, because you are having this above statutory limit. Now, some of you might think, sir, why, how, on what basis government make these kind of laws? This is injustice with Rahul. We have solidarity with Rahul. Galat hua Rahul ke saath. The reason is government want to bring social justice so that these 30 bigha, or someone will be having say 120 bigha, so that person will be contributing 50 bigha. So government will actually accumulate this, and then government will redistribute it among landless farmers or landless people, weaker sections, so that we can have economic justice in society. So this provision is a tool to do that. Okay, now, so what happened with Rahul? Now Rahul is having just 70 bigha because 30 bigha is gone to the government. Now out of the 70 bigha, now government want to make a highway, and for highway 20 bigha land of Rahul is required. Now when government acquired this 20 bigha, now tell me, this 70 bigha, it is above statutory limit or within statutory limit? Answer is within statutory limit. So if government acquire your land within statutory limit, then government is going to compensate you. Government is going to compensate you. So compensation will happen in this 20 bigha case, but compensation will not happen in this 30 bigha case because it was above statutory limit. Okay, I hope now it is clear to you. Now, take a look. Limit varies from state to state. For example, I gave UP 70. So different states can have their own, you can say land ceiling. And is it mandatory that every state should declare statutory limit? No, it is not mandatory. It is prerogative of state as mentioned in Schedule 7 of our Constitution, state list, land being a subject of state. So state can take away your land even when you are breaching the limit under the Article 31A, 31B, 31C. We are going to talk about these articles in detail now. Article 31A, 31B, 31C, exceptions to fundamental rights. You can call them exceptions to fundamental right. It means government wanted to justify their actions and without declaring their actions null and void. Because government was well aware what is there in Article 13. Article 13 says if there is a law which abridges these rights mentioned under Article 13, that law will be null and void, right? So government wanted some protection, so that is why they added these. Now, even if these articles violate Article 1419, Article 1419 fundamental right, one cannot go to Supreme Court because it is clearly mentioned in Article 31A, B and C that now this won't be considered as an abridgment of fundamental right. Now, I also want to tell you, here I am using the word 31A, means capital A. So it means it is a separate article, okay? And whenever you read articles in this manner, Article 19, subclause 1 or subclause A, so it means whenever small alphabet is used in these quotes, in these brackets, then it means this is part of, means this is within this article. Okay, but when I am using 31A, so it means it is a different article altogether. Another example for you, take example of Article 21. So Article 21 is your right to life and personal liberty, right? So when we use this Article 21A, so can you say 21A is actually within Article 21? No, Article 21A is a separate article which was added by our Parliament through 86th Constitutional Amendment Act. So this is a separate article. So there can be an amendment where government add a particular article. Okay. For example, recently we saw right to property was added. So right to property was added in 300A, capital A, a new article was added. Okay, although government can also do another kind of amendment. For example, if there is A, government can add B. For example, I discussed in Article 16, subclause 4, subclause 5 were added later, right? So subclause 4 means subclause, means we are adding in bracket. It means it is being added within that particular article. And why government do so? Because if the subclauses which government want to add are part or making the same sense as it is mentioned in Article 21, then government will add as a subclause. But if the sense is totally different, then government will add it as a separate article. Okay. Now, So we have exceptions like to ensure social justice and economic equality, told you, that's why government can acquire this land. We have example like Zamindari Abolition Act, Land Ceiling Act. Zamindari was abolished. So when land was taken from the Zamindar, do you think for every hectare of land which was taken, they were paid adequate compensation? No, because the statutory limit means statute limit provision and specific provision that this land which you are having is with you due to the kind of land policy which was actually made by Britishers, and it is not conducive for the farmers of India, and that is why by law government took that particular, you can say, the excessive land which was there, and so that it was redistributed later, right? So now 31A, what does it say? Just take a look at the kind of power government is getting. First, government can actually take, means acquire, estates. The word is estate. Okay, estate means property, land. Government can also take over management of property. It means it is possible that government is not acquiring you. Can acquire. We have this power in subclause 1. Another is government is thinking, let's not acquire, but let's manage. So in that case, government will appoint certain officer that you will decide on how this property is going to be used. So government can do this if it is necessary for the nation. Okay. For example, a particular ashram, is having, vast amount of lands in that particular area, and that the main person who was managing that died, and now there are a lot of conflicts happening on that property, and since it is a vast property and a lot of conflicts happening, in that case government can appoint a particular officer to manage that property till this dispute is resolved. Okay. Amalgamation of corporations. It means, consider there are two companies. One company is quite weak, but a lot of people are working in that company. So if that company actually, you can say, go into the doom, then so many people will lose their job. So in that case, government can take action to amalgamate, to join this company with one strong company, so that jobs and prospects of growth for the other company can also be secured. And modifications of the right of directors of that corporation, what rights they have, the directors, because if they were not quite successful and they were having certain allegations, for the protection of the future of the company and many people who were dependent on the company's future, government can take such action. Okay, and government has taken such actions. Look what Indira Gandhi ji was doing, right? We saw many private banks were actually nationalized, right? Amalgamation can happen or nationalization can also happen. Modification of the rights of mine owners, because mines were given on the lease, so in between the lease facility, the rights can also be altered by government using Article 31A. Okay, now cannot go to Supreme Court. You cannot go to Supreme Court if any of this thing happen with you. Okay, in the national interest. Article 14, Article 19, if they are violated under these provisions, you cannot go to Supreme Court. Okay. So expressively, means clearly, it is mentioned that if Article 14, 19 are violated, you cannot go to Supreme Court. Okay, you cannot say why only my company is amalgamated, why only my property is managed by government, why not others? This is against law. I'm not having equality before law, right? Why I'm not giving chance to present my case before court, before Supreme Court using, knocking the door of Supreme Court using Article 13. You cannot say that because Article 14, Article 19 are not available to you. Now, there's a beautiful, you can say, detail here. If I make a statement that if government acquire your property using the power in Article 31A, then you cannot go to court. You cannot go to court against such decision made by government. Tell me, the statement is true or false? Come on. So those who are saying, sir, this is true, because just we have learned that government can acquire, and even if it is against 1419, you cannot go to Supreme Court. But my friends, in my statement, I have not used the word Supreme Court. I have used the word court. There's a difference between Supreme Court and court. The word Supreme Court was used here in Article 31A because now you are not having protection of these part as a fundamental right. But since you are having a right over your property, and if government acquire your property, you can go to local court. You can go to local court, but you cannot go to Supreme Court. You cannot say my fundamental right is abridged. And when you go to district court also, you cannot say my fundamental right is abridged, because they will actually analyze your case from the point of view that you have legal right over your property. Now court will assess whether there's a rationale behind such acquisition or not. Right? ऐसा तो नहीं है that the person who is a district magistrate who is acquiring this property, and this property belongs to some ex-girlfriend. Right? That movie you must have seen, ना? मेरा इंतकाम देखेगी. अगर आप सोच रहे हो वैसा आप कर लेंगे, if you're thinking this can happen, मेरा इंतकाम देखेगी, then that person can go to court and court will ask you, you are district magistrate, but you cannot take arbitrary action. Give the rationale. Okay? So some things are fine in movie, but in reality, we have some layers of law in place. Right? So you have to use your mind when you exercise your power. Power is not the only thing. Now, Article 31B, laws enacted under 9th schedule. So, what is the story of 9th schedule? Government actually made a box, consider 9th schedule as a box, a protection box that government said that we are adding 9th schedule, and whatever law we are going to mention in 9th schedule, that will be beyond the judicial review or power exercised by Supreme Court using Article 13. It means we are adding a schedule, adding a list, list in the last of our constitution, 9th schedule, and whatever law, 1, 2, 3, no matter how many laws we add here, it means now these laws are getting some protection from Article 13. Okay? Now, so Constitution by First Amendment Act 1951. So it was done during the rule of Jawaharlal Nehru. Okay, he did this legal change. Okay, constitutional change. Why? Because so that the sanctity of the laws which Nehruji was doing, enacting at that point of time, primarily land reforms. Because why it was necessary to add 9th schedule and to give protection over Article 13? Because, my friends, till that point of time, this right to property was there in fundamental right? To make sure that the laws which are made by the government of the time are legally protected, and these should not be declared null and void. That is why this protection was added. Later, it was that this right to property was repealed. But earlier, this protection mechanism was made. Against principle of justice, government can misuse it. So these are some points here. Can insert unlimited laws to immune it. Means we are saying that adding the schedule 9 was having a lot of debate, that this can be misused against principle of justice. Because if any law is added there, then you cannot actually have protection of review by Supreme Court. Right? Can insert unlimited laws here because there was no limitation mentioned here. Now validity cannot be questioned. So that is why such action was actually questioned. Now, what happened? 13 laws in the beginning, and there were around 282 laws now. Okay. So now if I ask whether this 9th schedule still have that protection, that judicial review cannot be applied? No. We have this IR Coelho case, and this IR Coelho case, Supreme Court interpreted that violating fundamental rights, if this is happening, you can act, in this case, judicial review can happen. It means cannot go to Supreme Court under Article 32. This is what Schedule 9 was saying. But laws under 9th schedule after this date, means 24th April 1973, won't be immune. It means laws which were added by previous governments in 9th schedule, they will be immune. Means Supreme Court is not going to use judicial review power under Article 13 over those. Okay? उन पे नजर नहीं डालेगी Supreme Court. But those who are added later, as per our Coelho case, now we are going to use judicial review. Okay? So I think you will understand that this is a good initiative, right? Good interpretation. Misuse of ninth schedule could have been stopped. Now, Article 31C, the last part, introduction of 25th Constitutional Amendment Act. By this, Article 31C was added. So, this particular article was added to justify government action for actually applying or bringing a policy which is backed by DPSP. For example, our directive principle state policy have given this direction to the government. When you have enough capacity, political will is there, society is ready, then at this point of time you can make a law and provide these socio-economic rights which are mentioned in DPSP. Although they are not judicially enforceable, but it is a responsibility of government. But what happens sometimes when laws are made for giving these socio-economic rights, then they contravene with some of the fundamental right. Now, which should be regarded as superior, DPSP or fundamental right? So there's a beautiful debate here, right? So to save these laws, get into debate, 31C was added so that legitimacy of government action can be ascertained. Article 31 with a subheading right to property. So this has 44th Amendment Act. This was removed and it was added in 300A. Now, what it says, any law by Parliament, state legislature in order to enforce 39B, 39C, we are talking about DPSP, violating 1419 will not be void. Okay, so it means if government is making, means state legislature or parliament are making law for enforcing DPSPs mentioned in 39B, 39C, and even if they violate 14 and 19, then also it will not be considered as violation, it will not be considered as void. Okay, equal distribution of resources, 39B, 39C says no concentration of wealth. I hope now you can connect why 31C was added, because 39B saying equal distribution of resources, 39C saying no concentration of wealth. So if you have too much wealth, so there is nothing like too much when it comes to wealth according to some people. But the point is, other people are having so much poverty, inequality is there, inequality is going to create instability. So government may take some part of your wealth by having such law. So at that point of time, you cannot knock the door of Supreme Court, sir, just declare this null and void. Why? Because 31C is giving protection to this law made by government. Because government will say, sir, DPSP gave us information, DPSP gave us the direction, we just simply actually followed what was the ideal given by constitutional framers. So even if it abridged 1914, then also this will not be considered as void. I hope this discussion is clear to you. In our journey of Indian Constitution Part 3, today we are at Article 32. We are going to complete 32, 33, 34, 35, and that's how Part 3 of Indian Constitution will be completed. Okay. Now, Article 32 talks about constitutional remedies. Remedy, it means solution. So when you talk about solution, you only talk about solution when there is some problem. So what kind of problem we may face related to Part 3? The biggest problem is the fundamental rights which are given to us. We need to protect them. So it means problem is state or private individuals in some case, they may abridge your fundamental right? So we need to give you certain tool to protect yourself, and that tool is Article 32. Okay, that's why we are using the word remedy, solution to this problem of fundamental right protection. Okay, now Dr. B.R. Ambedkar, he made a famous statement regarding Article 32. He called this provision as heart and soul of Indian Constitution. Such is the importance of Article 32, because Constitution establishes relationship between citizens and state, means government. So now every relationship is based on rights which you can claim in that relationship. How this relationship is going to let you utilize your potential to the, you can say, maximum extent, right? So in that case, this is only possible when you are given certain rights and there's a tool given to you so that you can protect those rights, right? Otherwise, the legitimacy, the value of fundamental rights would have been decreased, right? Now, Supreme Court has ruled that Article 32 is basic feature of Indian Constitution. You are well aware of Kesavanand Bharati case, as we discussed in previous classes, right? So now Kesavanand Bharati case talked about basic structure doctrine. My friends, don't take this particular sentence lightly, because a beautiful statement can be made and many students are going to get trapped into it. For example, as per Kesavanand Bharati case, Parliament has power to amend any section of fundamental right. Because there was a debate going on whether fundamental rights can be amended or not. Kesavanand Bharati case said, yeah, you can amend fundamental rights, but you cannot touch the basic structure, change the basic structure of Indian Constitution. Now, in that context, can Parliament make a law to remove any of the writs which are given? Writs means power of Supreme Courts to actually issue some legal order. So, writ means legal order, okay? And this power to issue legal order by Supreme Court regarding fundamental rights is mentioned in Article 32, okay? So now, Parliament cannot take away any of those writs, because now Article 32 is considered as basic feature of Indian Constitution, okay? You cannot abridge it. Supreme Court has been constituted as the defender and guarantor of the fundamental rights. And which article expressively, means you can say from which article Supreme Court draws power to judicial review? Article 13. We talked about it. Now, you can simplify Article 32 by understanding 4 provisions which are mentioned here. Okay, there are 4 provisions which are given in Article 32. Number 1, right to move Supreme Court, because this is the first step now. Purpose of adding Article 32 is when your fundamental right is abridged, right? Or possibility you are thinking that it is being abridged. So in that case, you can move to Supreme Court using Article 32, right? So it means you are here and you move to Supreme Court. This is the first step. This is a way to remember actually these provisions. Now, Supreme Court should be given certain powers, right? So that Supreme Court can actually protect you. So this is step number 2, or you can remember it. This is actually provision number 2. Okay, the Supreme Court shall have the power to issue direct orders, writs. Okay, and what are those writs? Habeas corpus, certiorari, prohibition, mandamus, quo warranto. We are going to talk about it. So it means this is the second step. Then only your rights can be protected. So these are the 2 clauses. Now, third clause. Parliament can empower any other court to issue direction, order, writs of all kinds. Now, when it is saying all kinds, it is specifically talking in context of constitutional remedies. Now I'm making a statement and you have to tell me that statement is true or false. Article 32, subclause 3 allows Parliament to give power to issue writs, power or extend the power of writs to High Court. Full stop. Now tell me that statement is true or false. I am repeating my sentence. As per, you can say, as per Article 32, Parliament has power to give power to issue writs to other court, in this case, High Court. My friends, the point I want to make is that this subclause C is not related to High Court. Okay, it is not related to High Court. The reason is because High Court already has power regarding fundamental rights using Article 226. Then why would have constitutional framers added third clause and referring this any other court as High Court, right? So it means this any other court here is not High Court. Okay, it means it represents court beyond Supreme Court and High Court. I hope this intricacy is clear to you now, right? Because these are the intricacies where UPSC play. Now, Constitution provides that President can suspend the right to move any court for the enforcement of the fundamental rights. And you are well aware, we are talking about Article 32, and Article 32 is giving you this power that you can go to Supreme Court, right? Now here, this provision is saying that this particular right can be taken away, right? In what case this can be taken away? For example, in case of national emergency, we are going to deal with national emergency as a separate chapter, but you should remember, in case of national emergency, your right to move Supreme Court for fundamental right can be taken away, okay? But can it be taken away ipso facto? Ipso facto means automatically. No, that's not true, okay? A separate order may be issued in this regard. We are going to discuss this, okay? Now, purpose. What is the purpose of Article 32? Purpose kya hai? That these fundamental rights are guaranteed, effective, expeditious and inexpensive. The purpose was this: protection to only fundamental rights and not other rights. For example, non-fundamental constitutional rights, statutory rights. I'm giving you another example. Consider you are given a right through a law made by Parliament. Then that right will be considered as a statutory right or legal right. Why it's statutory right? Because it is made because of the statute which is passed by Parliament. Now, if this right of yours is abridged, can you knock the door of Supreme Court using Article 32? No, because Article 32 is mentioned in Part 3, which deals with fundamental rights. Okay, that is why this service of Article 32 and Supreme Court is available only in case of fundamental right. And in this context, you should also remember the statement which was made by ex-CJI, Mr. S.A. Bobde. So what he said? He said, Article 32 should be used by people only when other alternatives regarding they ensuring their fundamental rights, they have used those alternatives. And then they should come to Supreme Court as a matter of last resort. At this point, there was a huge debate in news. Several articles were in news and he was criticized too, that this is a right given in Article 32 and this Article 32 has not mentioned this. First you have to move in other courts and then as a last resort you can come to fundamental right. Then you can come to Supreme Court to ensure these fundamental rights, right? So there was a debate in this. Okay. Now, jurisdiction of Supreme Court, Article 32, and jurisdiction of High Court, Article 226. Now, I'm making another statement. Okay, and you have to tell me the statement is true or false. I'm saying the territorial jurisdiction of High Court regarding usage of writs in fundamental right is more than Supreme Court. Simply saying, let me simplify this statement for you so that you would not forget. I'm saying, when it comes to High Court, so High Court's territorial jurisdiction regarding fundamental right, writs, means writs used for ensuring fundamental rights, is more, or you can say larger than Supreme Court. Then Supreme Court, and in case of Supreme Court also we are talking about territorial jurisdiction. And you have to answer me in true or false. Okay? Obviously when we are talking about writs for Supreme Court issues writs only for fundamental right. Now tell me the answer is yes or no. Come on. My friends, answer is no. You know why? Why yes is wrong? Because we have used the word territorial jurisdiction. Territorial jurisdiction means territory, extent of the territory to which High Court can actually have power of its writ, its legal order. Okay, so you should remember this, because why I'm mentioning this, because there can be another question. I'm going to make another question, and sometimes students get confused in these two dimensions. First of all, take case of say Allahabad High Court. So you belong to Madhya Pradesh, okay, and there some of your fundamental rights are abridged. Now tell me, can you go to Allahabad High Court saying, although I belong to Gwalior in Madhya Pradesh, but I'm going to exercise my right mentioned under Article 226 and it allows me to go to High Court. So I choose to be in Allahabad High Court because I have some friends here. Then Allahabad High Court would say, okay, sir, go back to your home state and apply, file a petition in your High Court. The reason is because Allahabad High Court's territorial jurisdiction with respect to the writs used in case of fundamental rights is restricted to that particular state only. That particular state only. Okay? But when it comes to Supreme Court, if Supreme Court is actually issuing an order, then this will be applicable to whole India. Okay? Now, second dimension. Second dimension is High Court's power or scope of usage of writs is more than Supreme Court. When I'm saying Supreme Court, I'm talking about power scope, basically power in context of scope. And when I'm saying scope, it means in how many cases, how many type of cases this scope of writs is going to be applicable. Okay. Now tell me, the answer would be yes or no. Come on. Now here answer is yes. You know why? Because in case of High Court can use writs to protect your fundamental right as well as your statutory right, or you can say legal rights. But when it comes to Supreme Court writs as mentioned under Article 32 can be applied only in case of fundamental right. So it means scope is more in case of High Court, means variety is there. Variety hai. But kahan tak ye variety chalegi? Till what extent this variety will be applicable? Only to that state. So word territorial jurisdiction and scope, it should be clear in your mind. Okay? Now, take this table, and I hope this is visible to you on your screen. So this is taken from Lakshmikant. So you can open your Lakshmikant simultaneously and just take a look on the table. The differences between Article 32, Article 226. I've just explained this to you. Article 32 is applicable in case of fundamental rights only. That is scope. But when it comes to 226, it is applicable to constitutional rights. Means it is for fundamental rights as well as statutory rights. Statutory rights can also be added. Suspension. Article 32 can be suspended if emergency has been declared by President. Just mentioned this with you. Now 226 cannot be suspended even at the time of emergency. Means because now you should think that when I'm saying Article 226 cannot be suspended even at the time of emergency, it does not mean that you should look at this statement only in context of fundamental right. We are using this Article 26 cannot be suspended because there can be many legal rights. And presidential order which is issued at that point of time, we are going to talk about Article 358, 359 in emergency chapter. It is specifically deals with fundamental rights. Okay, so legal right aspect is not there, when it comes to emergency in case of High Court. That is why this particular statement has been made. Now, Article 32 has a narrow scope, just told you, and Article 26 has a broader scope, fundamental right, legal right, both, right? This is clear to you. Jurisdiction. Article 32 empowers Supreme Court to issue writs all over India, just told you. And this is local jurisdiction. Local jurisdiction means specifically in context of state, like Allahabad High Court, UP, right? Discretion. Since Article 32 is a fundamental right, the same cannot be refused by the Supreme Court. Article 226 confers discretionary power to the High Court, which means that is it at the discretion of the High Court to issue writ or not. Okay, but in this case, Supreme Court cannot refuse this particular, you can say petition, if the points are valid. The reason is because it is mentioned in Article 32, and Article 32 is mentioned in Part 3, right? So it means core responsibility of ensuring our fundamental rights is on Supreme Court, not on High Court. Okay, because High Court power is out of Part 3, mentioned out of Part 3. Okay, so this difference need to be clear with you, because there can be a statement in exam. Okay, now type of writs. So these are the 5 types of writ. First of all, habeas corpus. So it's a Latin word. It means you may have the body. It simply means that, consider there's a student with the name Rohit. Police came at Rohit's door last night, and Rohit was actually detained. So police said that we are arresting Puneet because we have some proof that Puneet has committed some crime. Okay, so it means it was a punitive detention, right? But when the some friends, they reached in the morning the police station, police said no, we don't have Puneet, or we don't have Rohit. So in this case, you can go to Supreme Court using Article 32, that detention of Rohit is illegal, is arbitrary. And you can ask Supreme Court, please issue this writ of habeas corpus, so that body, means person, Rohit, can be produced in court, and police can be asked question on what grounds you actually arrested Rohit. Do you have sufficient ground or not? So that investigation can now start in that particular process. So don't you think it is important, so that the arbitrary action of government machinery can be, you can say, put to a check, right? And you should also know that habeas corpus can be applicable in public as well as private detention. Okay, public as well as private detention. What does it mean? It means if you are detained, or someone is detained by government authority, then also you can go to Supreme Court. If there is private detention, right? So in that case also habeas corpus will be applicable. So to release a person who has been detained unlawfully, whether in prison or in private custody. Okay, now some of you might be finding it interesting why private custody word is used, prison. Because when prison is used, so in case of prison, there are official records. Okay, this person came in prison at this point of time, and these were the people who actually brought this person to prison. But it may be possible that you were not lodged into prison. You are at some unknown location, no official record at that point of its present, and in that case also habeas corpus can be used. Okay, now mandamus. So mandamus word means command, to command. Let me explain this to you in an interesting manner. First of all, it is command, certiorari, to be certified, prohibition, to forbid, quo warranto, what's your authority. So what does it mean? Let's understand through these interesting cartoons. Now, habeas corpus is a Latin for to have the body, like we were asking for the body of Rohit, is used to secure a person who has been detained unlawfully, illegally. Please remember, unlawfully, illegally. Okay, it's not like if that person is legally detained and you think that's my brother and he should not be arrested and you can go to Supreme Court. No, in that case your petition will not be accepted. Okay, unlawful, illegal should be the basis. Now, take this example. Your Honor, my client has been detained illegally. I'm here to ask for his body back. So, writ of habeas corpus has been issued in this regard in front of this judge. Now, judge will issue this direction to the respective department that you have to produce the body on such date in front of us, along with the grounds on which you arrested that person. Writ of habeas corpus can be issued against both. It means public authorities as well as private individuals. Okay. For example, if you are a contractor and you have some bonded labor, and these bonded laborers were demanding that they should be released now. Although having bonded labor is itself illegal, but now you have, you can say, put them in some custody. So in that case, this habeas corpus writ can be exercised against you as well. Now, writ mandamus. Mandamus, we command. Just connect. Mandamus means command. Okay. So when command is given, so that someone can perform that action. right? Take this example that one government authority, some officer, has to perform some task for you, okay? Consider that your grandparents, okay, and they have retired and now they want to start their pension. But the person in Treasury office is demanding bribe. And since your grandfather was so upright, your grandmother was so upright, they were saying, no, we are not going to give bribe and we want our work to be done. We have given our whole life to this government service and this is my entitlement. I have contributed to in this. So now this government officer has made some, fraudulent, you can say, reasons to object the file altogether, and this is creating a livelihood issue for your parents, so for your grandparents, right? So don't you think it is against their right to life as well? Because their medical supplies, right, they have to take medicines and they have to go to doctors, so their treatment is actually being compromised due to not issuing of this pension. So in that case, if they go to the Supreme Court using Article 32, then court will issue a letter to that concerned treasury officer that you have to come to Haveli. Where is Haveli? Supreme Court is Haveli, and वहाँ पर आपसे होगी बातचीत. Means we are going to ask on what grounds you stopped, and we command you to actually get this done. Okay. So in this case, please remember, it is not necessary that they will call you up into the court. Okay, it is not necessary. Okay, for example, in habeas corpus, the department has to produce the body because the body is the issue, that person is the issue, person in custody is the issue. But in this case, mandamus, a simple direction can be issued on the basis of proofs which you have provided, and that particular person, particular authority will be given a command that you have to perform this task. Or if you don't perform this task, give us a suitable reason within this time. So in this way, mandamus writ work. So take example. Your Honor, police is not taking my complaint, aggrieved individual. So now, we order you to take complaint. Writ of mandamus is used. Means order, command, because this is your duty. So now what police is saying? Sure, sir, public authority. So please remember, mandamus can be issued only against public authority. In habeas corpus, I told you, public authority as well as private individual. For example, I gave contractor, right? Now, why only public authority? Easy way to remember is, mandamus is used when a public authority is not doing a set duty. Okay. Now, my friends, can you actually give this command to a private company? No, you cannot give this command to a private company, because private companies' work is not fixed by the process made by government. Okay, they have some independence to perform their task. So this is applicable only on public authority. Writ of the mandamus cannot be granted against private individuals or organizations. Okay, I hope this is clear to you. Now, writ of certiorari, it means to certify. It means to be certified, is issued by the higher court to some inferior court, and please remember, the word transfer is used here. It means, take example. So this is a lower court, and this lower court has issued a direction, that issued a judgment, we give you life imprisonment. And this person is saying, oh no, zindagi khatam. But this person's advocate said, this particular judge and this particular level of court does not have suitable authority. And there is a case of error of law. Means proper law has not been applied. In this case, the law which is used by the concerned judge is not applicable. There is error of law. So in this case, the advocate of this person can go to higher court. When I say higher courts are Supreme Court and High Court, right? So now higher courts will say, hey, lower court, we want this case to be transferred to us. So please remember, in case of certiorari, there is transfer of case, because higher court says that you are not capable because you have done these mistakes. So we are going to look into this matter. So writ of certiorari is issued on the grounds of excess of jurisdiction, means you have gone beyond the periphery. For example, say tribunal word is used. So consider example of NGT, National Green Tribunal. Now due to a pollution from a factory, industry, so now what happened? Some people have said that due to this pollution, our life is under threat, and some people have got cancer. So NGT is listening to this case, listening to the argument, and now NGT is proposing that we are going to have some criminal action against the industrialist. So now, my friends, when you read NGT's provisions, so you will find that NGT cannot deal with criminal matters. NGT can also look on environmental aspects. In criminal matters, the matter need to go to sessions court, right? So if NGT try to play on these provisions, then this particular case can be transferred to higher court, because there is an error of law, or you can say excess of jurisdiction, lack of jurisdiction. Okay, I hope it is clear. Now, many students remain confused between certiorari and prohibition. Prohibition is to forbid, means to forbid. It is issued by higher court, means in this case also it was issued by higher court to the lower court. In this case, it is also being issued by higher court to the lower court to stop the law court tribunal from exceeding its jurisdiction. So now, what is the difference? Look at the difference. By the listening to all the facts and arguments, lower court, writs of prohibition is saying, hey lower court, we forbid you from deciding anything on the matter. It means here judgment was made, life imprisonment, done, and this person is like, oh no. But in this case, judgment is not made till now. Okay? Judgment is not made till now. In this case was transferred to the higher court. But in this case, there is no transfer of case from this court to this court. Okay, no transfer of case is happening. So it means judgment was made there, no judgment was made here. Case was transferred there, no case is transferred here. Okay, hey lower court, we forbid you. So writ of prohibition is not available against administrative or legislative bodies, private individuals or organizations. Please remember, this is applicable only on judicial bodies or quasi-judicial bodies. Okay. Now, writ of quo warranto, last writ. Quo warranto means by what authority you are on this position. Take example of Rohit. So in the first example, we said Rohit was arrested. Now days of Rohit have changed, right? Now Rohit got appointed as a civil servant. He cleared UPSC and he is appointed as civil servant. And when he was about to get retired, so his time period is gone, time period is done. He should have been retired, but he is still on this position. And why he is still on this position? Due to some kripa of concerned minister or prime minister, some political people. Now, some junior of Rohit, he is jealous and he is saying that I am jealous on legal ground, that by law, Rohit should give up his position, because there is no extension letter issued from the date he should have been retired. If there is some extension letter issued by government, then it is fine. But there is no extension letter in record and yet Rohit is working on this position. So by what authority Rohit is functioning on that position? So that jealous colleague, he can raise this issue in court. Public office, writ of quo warranto. By what authority are you holding this office? Now, High Court, look at the expression of Higher Court. High Court is saying, just Rohit, just explain us. कानून का मजाक बना रखा है आपने. You should have an extension issued and then you should have continued on this position, right? The writ requires the concerned person to explain to a court by what authority she holds the office. Okay, so I hope it is clear now. Now, this was Article 32. Now we need to talk about Article 33. So Article 33, Constitution, Armed Forces and Fundamental Rights. Now, do you think the kind of fundamental rights we have discussed in Part 3 are equally available to the people who are part of armed forces or police forces? Answer is no. You were quite happy reading Article 14, 15, 16, 17, 18, 19 and all. For example, Article 19, Subclause 1, Subclause A. You have freedom of speech and expression. But if you are an army person, you don't have equal freedom of speech and expression. Now, some of you might think this is wrong. No, you should understand the reason why this was made. And so that sanctity of this law is intact, so that army person not knocking on the door of Supreme Court that my freedom of speech and expression is being compromised. That is why Article 33 was mentioned in fundamental rights. So first let's talk about Article 33. So it empowers only the Parliament. First of all, you should remember only the Parliament. Okay, state legislature cannot draw power from Article 33 to restrict or abrogate the fundamental rights of the members of armed forces, paramilitary forces, police forces, intelligence agencies, analogous forces. And no state legislature can actually make this law. And why this is made? Take this example. This is Indian Army, Indian Defence Forces. Here you have Pakistan, here you have China, and here they are standing strong, rock solid, main hu na, right? Now, do you think if right to strike is allowed to the army people, if right to form association, right to engage with media freely is allowed to army people, don't you think it could create a lot of problem? If right to strike is allowed, if army is on strike, what is going to happen with the security of India? Consider for 1 day or 2 days, the police forces in your area, they say that we are going on a strike, we are not going to be on work. Don't you think your life, our property, everything will be compromised? Right? And we cannot let it compromise. And that is why Article 33 is important. Objective is ensure the proper, there should be, duties should be maintained because these are essential duties, and the maintenance of discipline among them. There was a case, I think 2-3 years back, when a BSF person, he made a video and that video was circled, was online that there's bad treatment of or bad quality food is given to these people, right? And he was making some claim against our Prime Minister. So action was taken, disciplinary action was taken against that person. So many people were actually getting emotional in that point, no action should have been taken, he has raised valid points. My friends, points are valid and these grievances need to be resolved. But the point is, if these kind of things start happening, apprehensions start circulating and they go on a strike and there is indiscipline, then our borders will not be secure, our internal area will not be secure. And that is why some fundamental rights are not allowed to them. That's a choice they make. And we should respect them for actually giving up these fundamental rights. We should respect them. Those who are not aware of this, then your respect should multiply. But the point is, this country can only prosper, can only run when laws are followed. And not just by army people, by everyone. Right? But the point is, this is what Article 33 is saying. This is the objective expression. Members of the armed forces also covers, please remember, also covers those people who are in non-combatant position. It means if a person is hairdresser, cobbler in army, yes, there are. So they cannot say, since I am not in combatant position, I can go on strike. No. It means mechanics, cooks, chokidars, bootmaker, trailer, everyone comes under the provisions made by Parliament, drawing power from Article 33. Because laws are made by Parliament. Some example of these laws: Army Act 1950, Navy Act 1950, Air Force Act 1950, Police Forces Restriction of Rights Act 1966, Border Security Force Act. So all of these laws are made by Parliament, and in these laws they specifically mention what cannot be done, what kind of rights are not available. Okay. Those impose restrictions on their freedom of speech, right to form association, right to be members of trade union, political associations, because they have to be neutral, right to communicate with the press, right to have public meetings and demonstrations. 2-3 years back, there was some conflict between some people from Delhi police and some advocates in Tisajari court. So some policemen, they actually gathered near this Tisajari metro station and they were raising slogans against Delhi Police Commissioner. That this is disrespect of Delhi police people, that some advocates get entangled with, and there was some beating there. So at that point of time, this particular incident was actually, you can say, read in context of Article 33. What wrong can happen if such things go on? Now Article 34, martial law and fundamental rights. What is martial law? Martial law means a temporary provision where civil administration collapses, and in this case military takeover. So that is martial law. So our constitution says restriction on fundamental rights while martial law is in force in the area within the territory. Now what kind of restrictions are going to happen? For example, the courts you have as of now will not work in case of martial law. Every part of administration will be taken over by martial law. Now please remember, this is different from emergency. In case of martial law, it is in specific area, first of all, right? Second, it is temporary, okay? It is temporary. In case of emergency, there is change in relation of sentence state, right? But this kind of changes doesn't happen in case of martial law, right? So the expression martial law not being defined anywhere in the constitution, but emergency provisions are defined in our constitution, article 352, 350, 360, but martial law has not been defined, okay? Article 34 empowers the parliament to indemnify, compensate any government servant. For example, you are a part of military and you are posted in some unstable area in Manipur, right? And there is a martial law in place. Consider there is a martial law. Martial law is at last stage, okay? Now you have committed some actions, and through those actions, some fundamental rights of people have been abridged. So in that case, can some action be taken against you? So this particular Article 34 gives you a protection layer on the actions which can be taken against you, okay? So it means for act done by him in connection with the maintenance, restoration of order in any area where martial law is in place. So in this case, protection will be given. The act of indemnity made by the parliament cannot be challenged in any court. Because parliament has made the law, you cannot challenge it, okay? Because Article 34 gives this power to parliament. So now Supreme Court held that the declaration of martial law does not ipso facto. Ipso facto means that very fact. ऐसा नहीं है martial law लगा तो all the fundamental rights will be abridged. Okay, there will be an express order in which fundamental rights, how this matter will be dealt, will be expressively mentioned there. Now, the declaration of martial law under Article 34 is different from declaration of national emergency, Article 352. I have just explained you the difference. This is the difference. It is visible in your Lakshmikant. Please open the Lakshmikant. As you read, you will understand. As I told you, in a specific area, martial law can be placed. But when it comes to national emergency is applicable in all India, or certain areas of India can be actually kept out of national emergency. You should not remember, oh, it's a national emergency, it means it will be applicable in all over India. No, there's an exception there. For some parts, national emergency can be kept aside. In previous session, we were talking about Article 32, Part 3 of Indian Constitution. We talked about 4 clauses which constitute Article 32, right? Can you quickly remember what those 4 clauses were? We discussed, right? Thereafter, we talked about 5 writs. Then we talked about difference between writ jurisdiction of Supreme Court and High Court. We also played certain rapid fire question round, right? Thereafter, we discussed 33, 34, 35 was left, right? So let's have a short recap, and thereafter 35, and then we are going to discuss DPSPs. So Article 33 was talking about empowering Parliament, that Parliament can prohibit, abrogate fundamental rights with regard to certain services, right? We discussed. Now, I'm giving you the star point. You should search about ESMA, ESMA, Essential Services Management Act. The question is, if ESMA draws power from Article 33, what kind of services are part of ESMA? Can such law can be made by state legislature also? So this is my question from you, and you have to mention in comments. Okay, don't consider that UPSC is going to ask questions specifically on the language which is there. They want to check your analytical side, how you understood it, and whether you are able to apply it in current scenario if some developments are made. Because during the doctor's strike, government was saying we can impose or we can use ESMA. We can take their right to agitate. Okay, so this is an important debate. Thereafter, we discussed Article 34. We talked about differentiation between martial law and emergency, right? Then 35 talks about power of Parliament to make law regarding enforcement of certain fundamental rights. Now, important thing is, it says that regarding certain specified fundamental rights, only Parliament can make law, right? So, सबसे पहले तो why only Parliament can make law regarding certain specified fundamental rights? The answer is to bring uniformity throughout the country. For example, if certain fundamental right is abridged by someone and Parliament is making law that all over India this is going to be punishment. So it means it is bringing uniformity throughout India, right? Because if nature of fundamental right is same and punishment of their infringement should also be same, right? Now, please remember, if UPSC makes a statement drawing inspiration, or you can say question can be asked from Article 35, that as per Article 35, no state legislature can make law regarding enforcement of fundamental rights. Now tell me, a student will tell me the statement will be true or false. I'm repeating the statement. As per Article 35, no state legislature can make law regarding enforcement of fundamental rights. Some students might say, sir, this question is quite easy. It is quite visible here, is that only in the Parliament and not in the state legislature, right? So those students who are saying yes, my friends, answer is no. The statement is false. You know why? Because statement was saying no state legislature can make law regarding enforcement of fundamental rights. It means all fundamental rights. But Article 35 is saying certain specified fundamental rights, which are specified by Parliament, that in this regard only we are going to make law because uniformity in punishment is needed. But when I'm saying fundamental right, it means fundamental rights which are mentioned in Constitution as well as fundamental rights which are time to time interpreted through Supreme Court, right? So regarding other fundamental rights, state legislature can also make law, right? So I hope now you are not going to get trapped into the question. These are the intricacies on which we have to play. The examiner knows where you are going to get trapped. Now, since we have gone through this part 3, we need to know in which case Parliament shall have the power to make law. So one is when it comes to prescribing the residence as a criteria, right? Article 16 means regarding public employment. This is one criteria where Parliament shall make law. Apart from this, empowering courts other than Supreme Court and the High Court to issue directions, orders, writs or kind of enforcement of fundamental rights. We discussed about this in Article 32, right? So coming from Article 32, it specifically says Parliament has power. Then restricting or abrogating the application of fundamental rights to members of the armed forces, 33. This power only, lies with Parliament, right? Apart from this, indemnifying, compensate any government servant, any other person for any act done, means we are talking about martial law. So in this regard, power is with Parliament, okay? Now, Parliament laws for prescribing punishment. So there are some examples, for example, human trafficking. Okay, regarding human trafficking, for example, regarding untouchability, Article 17, Parliament has power to make law, Parliament make law. 35 of the above mentioned, even if they fall under state list, Parliament can make laws on these subjects, on these issues, right? Now, what are the popular criticism of fundamental right? Most popular one are, even if Constitution has given us so many fundamental rights, but there are so many restrictions also, excessive limitations also, reasonable restrictions are there. And that is why, due to the ambiguity, or you can say multiple interpretations, applications of these restrictions, many times people are not able to access these fundamental rights. Second is no social economic rights, because socio-economic rights are mentioned in DPSPs. And those rights which are mentioned in Part 4, they were not given the status of fundamental rights. So this is another criticism, right? And you should also know that you should not just understand or remember the words. Okay, you should remember that when we read our preamble, so our preamble says that social, economic justice are priority. So if they're priority, then why they were put under DPSPs and not fundamental rights? So my friends, when you write answer in mains, So at that point of time, you need to bring substantiveness, logic behind. Means this is one criticism, but why this criticism? That logic need to be reflected in your answer, not just this pointer. Okay. Now, no clarity. As I told you, ambiguity is there. For example, right to life and personal liberty. But life, what constitutes life? It was not clearly mentioned. According to some people, some scholars, life means you are living, you are breathing, you are alive, and that life of yours need to be protected. But in Maneka Gandhi case, we discussed that life is not just mere existence, life is living with dignity, right? So no clarity as such in this part. No permanency means there can be situations where you cannot exercise your fundamental rights. Suspension during emergency means your fundamental rights can be taken away. I mentioned this, Article 358, 359. We are going to talk about this in detail when we discuss emergency. Expensive remedy, because consider a poor person in some distant village in one corner of India, and his or her fundamental rights are abridged, right? And local administration is not supporting. Now, this person came to know that there is Article 32, and under this person can knock the door of Supreme Court. But can this person afford that? So it means accessibility of justice is an issue which has not been dealt in a manner it should have been, right? Preventive detention. This preventive detention as a method has been abused to curb your fundamental rights. No consistent philosophy. It means so many variations are there, or no variations are there. That is why multiple point of views on fundamental rights keep on popping up. Okay. You should also remember this in this context. When I say no consistent philosophy, so my friends, when we talk about fundamental rights, DPSPs, or any part of our constitution, they are outcome of one or other political philosophy, and they have roots, in ancient time. But when we look at Indian Constitution and we look at fundamental rights, we see so many variations, so many philosophies compiled together beautifully, right? Some of you might be wondering, sir, how means we are not able to relate with it. Take example. Means our constitution talk about preamble, and our constitution talk about socialism as well as socialist as well as liberty. So traditionally they are totally different philosophies. And when you see this in part 3, you see in Article 19 we talk about liberty, right? So liberty is there. We also know that there are instances where liberty is curbed for the social interest. So it means society can be given primacy over your individual right in certain circumstances. So it means somewhere socialism, somewhere liberalism, there's a mix which is used. So some people use it as criticism, but you should also consider it as a beauty, because purpose was to make a constitution, make fundamental rights which are more applicable, and they actually deliver to the aspirations of the people, right? Now we need to talk about DPSP's part 4. And there is an interesting story behind it. Starting from 1945 Sapru Committee, which said in India we should actually have two kind of individual rights, and thereafter group rights. So they said some should be enforceable by law and others should be not enforceable. So what is the meaning of enforceable by law and not mandatorily enforceable? It means certain rights are of such importance that you cannot enact Indian Constitution by not guaranteeing those rights. Otherwise, people will not be able to feel any difference after this independence. Because if you ensure that these are the guarantees given to you by Constitution, then people will feel, yeah, there's a change now. So those rights were given the status of fundamental rights part 3, because government was quite, you can say, able at that point of time to ensure that these fundamental rights can be given. Civil and political rights are actually part of that. And I discussed about this when we started Fundamental Rights Part 3. When we talk about socio-economic rights, now these were given the status of directive principles of state policy due to numerous reasons. Other person, Mr. B.N. Rao, also supplemented this idea in Constituent Assembly. Yes, we should divide these rights into two parts. And this division was not so easy, my friends. In Constituent Assembly, many members were of such idea that no, let's pick these rights which you are putting in DPSP and let's put in fundamental rights. And then there was debate, right? Now, so we have DPSPs in Part 4 of Indian Constitution, and it includes Article 36 to Article 51. Okay, so it is, you can say, the bandwidth of directive principles of state policy. Let's break the word itself. Directive. Directive means direction. And you know, direction is always necessary for progress. Principles means core ideas, means directions based on some core ideas. Of state policy, it means when state is going to make policy. So when state is going to make policy, these directions based on these principles need to be followed. But if you are not having any of these socio-economic rights which are mentioned in DPSP, you cannot go to court. No, I have not, state has not provided me this, because these are non-justiciable. It means you cannot go to court directly. It means this ease was given to state that when time is fit, you have enough resources, society is ready, political will is there, then you can actually make that. For example, DPSPs were talking about state responsibility regarding providing education to these children. But our government was not having enough capital to guarantee that every child in India will have free and compulsory education from 6 to 14 years of age. At that point of time, we were not having enough resources. But later, when we were ready, 86th Constitutional Amendment Act came, and we saw that inspiration coming from DPSP, and then it was declared as a fundamental right under Article 21A. Right? Now, another differentiation between DPSPs and fundamental rights are, in fundamental rights, there were certain titles associated with type of fundamental right. For example, in fundamental rights after Article 12 and 13, we started right to equality. And within that, we discussed Article 14, 15, 16, 17, 18. 14 to 18 we discussed. Then we discussed right regarding freedom, right? But in case of DPSPs, there are no such titles present. Okay, no such titles are present. No such categorization within DPSPs are present in Part 4. So now how we categorize them? So this categorization is done based on analysis of certain scholars, and they categorize this into three parts. So they categorize this into three parts, and those three parts are socialist, liberal, and Gandhian. And we are going to discuss this in detail. Socialist, liberal, and Gandhian based on the type of provisions which are there. Now, just take a look over this statement made by famous legal luminary, Mr. Granville Austin. So he says DPSPs are conscience. The word used is conscience of Constitution, antaratma. Right? So it means, जैसे कहा जाता है ना, you should act with your conscience. So states should act with the conscience of Constitution. And please remember, these kind of statements are asked in match the following. Okay? Borrowed this idea from Irish Constitution, and Irish Constitution borrowed this idea from Spanish Constitution. Now, guidelines to be followed by state while establishing policies, I have just told you. Apart from this, when we take a look over Government of India Act 1935, GOI 1935, so in that particular law, there were instrument of instruction. So instrument of instructions were actually given to Governor General as well as governors of provinces, that when you are going to conduct the affairs of the administration, these are the core principles you should keep in mind. So you can say instrument of instructions as mentioned in Government of India Act 1935 as well as Irish Constitution, we draw inspiration from both. And Granville Austin says it is conscience of Indian Constitution. Take a look what B.R. Ambedkar sir is saying. So the point which I've just discussed with you, that it draws inspiration from this instrument of instructions. Now, you should have this question in mind. Sir, you were mentioning about socio-economic rights, but why we need socio-economic rights? What are socio-economic rights? So it means rights which ensures that your social condition will not be a basis of your discrimination. You will be having access to resources of society, facilities of society like any other person. Don't you think this particular provision is much needed for the welfare of many people, right? And when it comes to economic right, can any one of you say that, sir, I don't need any economic right? Economic right means your right regarding having facility of ensuring adequate livelihood. It means कमाने के लिए, means आपको रहना है, you need to live, for that you need resources. But it is responsibility of state to give you such circumstance so that you can earn your resources. And when you are going to earn and when you are going to ensure that these resources are there, then only you can live, right? So socio-economic rights are very important. Now these rights are the foundation of the concept of welfare state. Welfare state. So what is the meaning of welfare state? Actually, this idea emerged in Europe at a time when exploitation in front of state got increased a lot as a product of industrialization, laissez-faire system where government was on back foot. Now let's connect what it means. So there was a professor in Glasgow University, Mr. Adam Smith. So he published a work, Wealth of Nations, and in that work he said government should be on back foot. Government should not regulate the market, and market should work on its own. That is for the best, and prosperity will come and everyone will be happy. Such were the, you can say, dreams. But what happened? Due to this, few people got extremely rich and others were getting poorer. And since state was not allowed to, it was said that state should not engage. So state was not engaging even for the welfare of these poor people, these workers. So severe exploitation was there. Now my friends, tell me what happened if exploitation is there. There is a possibility of instability, right? Lawlessness. So thereafter, this idea became popular that no, government should actually function as a welfare state. It means if some social conditions of the people are such so that they are not able to take care of the basic needs, in that scenario, state means in this case you can say state, government has to intervene and take care of the basic needs of these people, right? So this is the idea of welfare state, right? And in Indian context, these ideas of welfare state were prevalent way back, right? We had this concept of Raj Dharma. We had this concept found even in Arthashastra of Chanakya, that the prime responsibility of king, Raja, should take care of the welfare of its subjects, right? So they were present in Indian context also. Now, what is the aim of these DPSPs? So you can say that there are three aims, and now you can relate these three aims were present in preamble as well: equality, liberty, and fraternity. And these three are important to ensure socio-economic justice as well as political justice is important. And those who are thinking, sir, what is political justice? Why you need political justice? Acha, tell me, consider you are not part of political system. You're not given right to vote. Consider your opinion doesn't matter. And if your opinion doesn't matter, you don't have right to vote. Now government will be, if government makes certain law which are detrimental for you, means have negative impact on you, can you do something about it? No. But if there is political justice, you have a voice. You can be a seed for change. So political justice as an idea is equally important as idea of social justice and economic justice. Right? So now, this is a fact. I've told you that DPSPs are not enforceable, not justiciable, right? It is prerogative of state. When they're ready, they can actually make determining the constitutional validity of law, right? So what does it mean now? So Supreme Court said that these are not enforceable, non-justiciable. You cannot come on knocking on the door, sir, this DPSP has not been followed. But Supreme Court can actually look at the validity of a law. It means if a law is made, And some of you filed a petition in Supreme Court, sir, this particular law is this should be null and void, it is unconstitutional. Then at that point of time, our government says, no, this is not unconstitutional. I made this law to taking inspiration from DPSPs. So now Supreme Court will see, oh, what is written in DPSP? Acha, this is written in DPSP that state has to take action to reduce the chances of inequality. And this particular law is actually making sure inequality decreases. So in this context, Supreme Court might say, yeah, this is constitutionally valid. Okay, I hope now you are clear about the meaning of this line, right? So we classify these DPSPs into three heads, as I told you. Socialist principle, Gandhian principle, liberal principle. And I told you, though, there's no specific title mentioned in DPSP such. It is based on an analysis. So when you talk about socialist principle, so when you read DPSP, just think, in this DPSP, priority is given to equality. Priority is given to welfare of society, not individual liberty. Right? So when these kind of provisions are found in certain DPSPs, we call them socialist principles. For example, these. Priority to society. Priority to bringing equality. Priority to reduce the concentration of wealth, then only equality will come. Right? Gandhian principles, ideas which are related to Gandhian ideas. For example, Panchayati Raj, intoxication, banning intoxication, right? So making panchayats self-sustainable, also about giving due protection to the milch animals, cows, calves, right? So these are coming from Gandhian principles. When it comes to liberal principles, so it means priority is given to individual. That individual's choice should maximize and restrictions on that individual should reduce, then that individual will be able to enjoy socio-economic rights. So in whichever article we find this particular thought getting reflected, we call it, okay, this is liberal, you can say, principle. Now, this DPSP starts from Article 36. And Article 36 simply says what state means. So it says state is same as Article 12. And you know what is the meaning of state under Article 12? We discussed it, right? Legislature, executive at union level, legislature, executive at state level, local government bodies, panchayat municipalities, and other such bodies which perform the function of state. It means regulation function, right? So same is the definition of state here in this context. Now some of you might be thinking, sir, why they have added one article, specifically Article 36 here, if they wanted to tell us that it is same as Article 12? Why they have added one more article? The reason is that we are talking about a separate part, a separate chapter, you can say, part 4, right? And I told you in the start that state word is used in two senses in Indian Constitution when we go through different articles. So when we say state here, so it means we are talking about different organs of government which perform the function of state, because state is there. But when it comes to this union part and state part, when we use the word state, it means we are talking about provinces, for example, Uttar Pradesh, Madhya Pradesh, right? To make it clear, that is why adding this was necessary. So it is a legal standard that need to be maintained. The state includes, we discussed it. Now, what Article 37 says? So Article 37 talks about the status of DPSPs, how you need to relate with DPSPs. So it expressly mentioned that they shall not be enforceable by any court but are fundamental in the governance. And please remember these kind of phrases, fundamental in governance. So UPSC will make a statement within part 4 of Indian Constitution, DPSPs, it is clearly mentioned that DPSPs are fundamental to governance. So some of you might thinking, yeah, fundamental governance. But this statement is saying, clearly mentioned, the word mention is there. So some of you might think, yeah, farki to nahi rahi UPSC humse, kahin ghuma rahi ho, right? But yeah, it is mentioned, clearly mentioned, fundamental in the governance. Okay, these kind of statements. And it shall be the duty of the state to apply these principles in making laws. So this is 37. So how you can remember 37? First, non-enforceable, status of DPSPs. Second, stated role is or importance is fundamental in governance. Okay. Now, coming to the Article 38. So now we are going to talk about socialist principles. Okay. So it says promote social, economic, political welfare of the people. Okay. So social, economic, political welfare of the people is a directive to the state. Now, a state can make certain programs, subsidies for the deprived section, and that if deprived section is getting these subsidies, then it can be considered as economic welfare of the people. Can you mention some government scheme which is specifically dealing with the welfare of women section? Come on in comments, because everything should be interconnected in your mind. That's how you can concise your knowledge and recall easily in exam. Yes. Mention in comments government schemes, they should be ready. Now, Article 39. I hope by now some of you are remembering. I'm giving you advice. Best way to remember government schemes and connect them with DPSPs is that you should structure these schemes in your mind. As I said, women. So within women, there should be some sections in your mind. Oh, with regard to women. So there are some schemes for pregnant women. Okay. There are some schemes where eldest women of the family is considered as the original holder of that scheme. I'm giving you a hint. Oh, there are some schemes for girl child also with regard to education. Right? There are some schemes for destitute women also. Right? We have many schemes. Nah? There's a dedicated program also. National Social Assistance Program, NSAP. There are other programs also, NFBS, National Family Benefit Scheme. Right? Matatva Vandana Yojana, Lakshya Initiative, a Ladli scheme. So many schemes are there. So easiest way is structure in your mind. Okay, then interconnect. Now, Article 39, to secure adequate means of livelihood for citizens. Don't you think it is connected to economic justice? As I told you, livelihood is necessary. So you should be provided job opportunities. Right? Because developmental model matters a lot. Right? Right developmental model matters a lot. And government has important role to play there. So it means within Article 39, first is talking about livelihood for citizens. Now B is saying equitable distribution of material resources. Then it is saying prevent the concentration of wealth. Now, how many of you are able to recollect that we mentioned about Article 39, subclause B, subclause C, somewhere in fundamental rights also? Come on in comments. Those who are not able to recollect, just check out what we discussed under Article 31C. That if a law is made by Parliament, drawing inspiration or based on Article 39, subclause B or subclause C, and it abridges in some way Article 14 and 19, then also that particular law will not be considered as null and void. Right? I hope now you remember. So these are the Article 39, subclause B, subclause C. And are you able to see that these subclauses B and C are based on socialist ideas? Because ultimate purpose is that equality need to be established, equitable distribution of material resources, and prevent the concentration of wealth. Distribution equal करें और किसी पर इकट्ठा होने ना दें. Right? Now, equal pay for equal work. Now, I hope you can connect this with feminism. Right? Equality in context of rights of women. Then preservation of health and strength of workers and children against forcible abuse. Then you have opportunities for the healthy development of children. It was later added. It means 42nd Constitutional Amendment Act added 39 subclause F in our Constitution. Okay, please remember the amendment part specifically. Okay. Now, 39A. Please remember, 39 subclause A means we were talking about this subclause within 39. Okay, which we're talking about livelihood for all citizens, right? But when we say 39A, capital A, it means it's a separate article, right? And if 39 capital A is there, it means it was added later, right? Otherwise, if it would have been added at the enactment of the Indian Constitution, then they would have placed it in Article 40. But to have this constitutional scheme drafting intact at the later part, when amendment was done, it was added through 42nd Constitutional Amendment Act, and that is why A was used. Capital A means a separate article is being added. For example, 39B would be, capital B would mean, oh, there's another article, separate article is added. Now, promote equal justice and provide free legal aid. Now, can you mention certain, you can say, policy of government which is connected to, or you can be drawing inspiration from Article 39A? Come on. Nalsa, salsa. So I'm not talking about salsa dance. National Legal Service Authority, State Legal Service Authority. Along with that, there was another important initiative government took, telelaw. So these policies, telelaw, through common service centers, government is providing this facility. If you need some legal advice, then government independent lawyers are going to provide this legal advice to you, free legal aid, right? So this is 39A. So these policies were made taking inspiration from this DPSP. Then Article 41, secure right to work, right to education. Now, right to work, right to education, right to public assistance in case of unemployment, old age, sickness and disablement. This is Article 41, important article. So many policies are made by government taking inspiration from Article 41. Right to work. I hope all of you remember MG Narega, Mahatma Gandhi National Rural Employment Guarantee Act. Right to work, right? Right to education, Article 21 is expressively, especially mentioned. Right to public assistance. It means in case of unemployment, government provide, right? Unemployment allowance, old age. There are old age pension by Ministry of Social Justice at center level, and state government, there's Ministry of Department of Social Welfare. So this is a centrally sponsored program. You can search about NSAP. I just mentioned it also. National Social Assistance Program. So public assistance, NSAP, this program, this policy drew inspiration from Article 41. Okay. So in a question where they want to ask you about the developments which you have seen as a contribution coming from DPSPs, you can mention these links also. Okay. Sickness and disablement. So government provide, aid, support to in case of sickness. For example, government spend on these public health infrastructure. Also, Ayushman Bharat Yojana, right? Now, and with respect to disablement, how many of you are aware of this PSU Alimco? Please search about it, Alimco, and see how it is connected to Article 41. Now, Article 42, make provisions for just and humane conditions for work and maternity relief. And you know that we have improved a lot in context of maternity laws in India, right? So Article 42, then 43, to secure living wage. It means wage which is bare minimum for your life. Decent standard of living, social cultural opportunities for all workers. Workers, it means we are still in socialist dimension of DPSPs. Then 43A added through amendment 42nd Constitutional Amendment Act. What it says, participation of workers in the management of industries. Don't you think it is connected to providing policies with respect to trade unions, their participation in the management, right? And I think 2015 or 16, UPSC asked this as a statement. The statement was, which of the following are not part of DPSPs? And one statement was this. And many students who were not well versed with the provisions mentioned in Part 4, they thought, oh, how can workers participate in the management of industries? So because when you actually read this word worker, so what comes into your mind? Your mind talks about, or you have idea, okay, worker is someone who is having some, menial work that person is doing. When I'm saying menial work, it means the person who is doing some hand holding kind of work, or you can say the basic work, right? But every work is important. That is the idea behind 43A. No work is menial. Intellectual work and physical work are same. But when you say worker, what comes into your mind? Physical work. But if someone is a manager also, that person are using intellect, that person is also a worker, na? Right? So this is the socialist idea. And why it was added? Because if there is no participation of workers in industry, and every kind of worker, who is an employee, whoever is an employee is a worker. So what is going to happen? The person who invested the money is going to draw the maximum out of profit and actually minimize the wages or salaries which need to be provided to these workers, and it will lead to inequality. Such should not happen. And how we can ensure such condition doesn't happen? Only when there is participation of workers. Okay. Then Article 47, raise level of nutrition, standard of living and improve public health. Can you mention some government scheme, policy, drawing inspiration 47? There are so many schemes. ICDS, midday meal scheme. You can directly say Poshan Abhiyan. Poshan Abhiyan. Modi ji launched it from Jhunjhunu district of Rajasthan. So the Poshan Abhiyan, right? Along with this, you can also mention NFSA, National Food Security Act, PDS, TPDS, all of them, these policies are drawing inspiration from 47. Now, Gandhian principles. First of all, Article 40, most popular article, organize village panchayats and endow them with necessary powers. Necessary powers. Can you mention some policy? Law made by government. 73rd Constitutional Amendment Act. So this act declared that these Panchayati Raj bodies are now on constitutional bodies. So it was drawing inspiration from Article 40. Then 43. So 43 is Gandhian principle. So we have categorized them into segment, means principles, means philosophy from which they are emerging. The state shall promote cottage industries. So Gandhi used to say cottage industries are necessary for self-reliance. So can you mention some law regarding promotion of cottage industries, some body? Come on. KVIC, Khadi Village Industries Commission. Just check about PMEGP, Pradhan Mantri Employment Generation Program, and how it is connected to village industries, right? Now, 43B, again, it was added through Constitutional Amendment, 97th Constitutional Amendment. Promote cooperative societies. And when we were discussing about Article 19, there also I mentioned this 97th Constitutional Amendment Act was used to amend Article 19 subclause 1, and now you can say establishing cooperative setup is also a fundamental right. Cooperative society, such is the importance. Because why such importance was given? Because government cannot be considered as the solution provider to every problem which is there in society. This is a faulty conception. If you see any problem in your society and you look at the government, what you have done? That's a wrong conception. Because solution should come from society as well. Right? So we can come together. The word cooperative comes from the word cooperation. We should come together and build some solution in this regard. And government should work as an enabler, not the provider of, in every case. That is the idea. And we have so many examples in different sectors where cooperative model has helped a lot. You can check about the concept of grain bank and how this concept is solving the problem of hunger. You can also search about this, it's the most popular, this Amul model. Amul Doodh Pita Hai India, and how it has transformed the life of so many dairy farmers, right? Now 46th, to promote the educational and economic interest of scheduled caste, scheduled tribe and weaker sections of the society, and to protect them from social injustice and exploitation. Do we have some policies in this regard? Come on, fast. Yes, we have. We have seen government established through constitutional amendment a dedicated commission for National Commission for SCs, National Commission for STs. There's dedicated ministry too. There are dedicated schemes also, establishing various hostels across India where the students can live on subsidized rate. They can study on subsidized rates, right? So these policies are drawing inspiration from 46. 47. Intoxicating drinks and drugs need to be prohibited. And do you know certain law? Come on. NDPS. That was quite in news during this Aryan Khan case, right? We have NCB, right? And various state governments also have their drug de-addiction policy, a dedicated policy. Now, Article 48, prohibition of the slaughter of cows, calves, and other milch and draught cattle and to improve their breeds. Now, the word cow is mentioned in our constitution, but along with this, other milch animals and draught animals, cattle are also used. Okay. Now, improve their breeds. Can you mention some government scheme, policy drawing inspiration from Article 48? Come on. Fast in comments. Rashtriya Gokul Mission. How can you forget? Government is improving, these breeds, indigenous breeds, right? And you should also know about these basic questions. What is the difference between A1 milk, A2 milk, which were associated with these Rashtriya Gokul Mission, right? So you should keep an eye on that. Now, what are liberal principles in DPSPs? Article 44. It talks about Uniform Civil Code, UCC. There has been a lot of debate on implementation of UCC in India. It means no personal laws. There should be one uniform code for all, right? Article 45 provides early childhood care, education for all children until 6 years of age. Do you have some policy? Yes, ICDS, Integrated Child Development Scheme, which targets children below 6 years of age. We have Anganwadi centers giving them food as well as basic education. When we talk about children from 0 to 6, so there is facility of weaning food, WEANING, weaning food as a policy of government. You can consider weaning food as government Cerelac, So this is drawing inspiration from 45. There's another word for that also, that is Panjiri. Now, Article 48, organize agriculture, animal husbandry on scientific lines. So we have a dedicated ministry for that, right? So this has been added as elementary education has been added as a fundamental right. We discussed it earlier. Now, Article 48A, protect and improve the environment and safeguard forest and wildlife. So it was added through 42nd Constitutional Amendment Act. So we have numerous laws made by government with regard to protection of environment. We have a tribunal also, NGT, right? Along with this, we have other state level boards also, central level boards also to protect environment, right? For example, CPCB, Central Pollution Control Board. Now, Article 49, protect monuments and objects of historic interest which are of national importance. Article 49. So, you can remember, the government launched this scheme, Rashtriya Dharohar, right? In which CSR funds are being mobilized for the upkeeping of these monuments, right? Article 50, separate the judiciary from executive. This is also a DPSP, please remember that. And it was important considering in mind the independence of judiciary, right? And clarity in the functions of these two important pillars of our democracy. Then we have last article, Article 51. My friends, we were just talking about features part. Features, understanding, knowing about these features are important. But the next level is debate between fundamental rights and DPSP, the laws and the development. This is the last article here, Article 51, promote international peace, security, maintain just and honorable relations between nations. Article 15 is a reflection of India's foreign policy. So you can say Indian foreign policy is a reflection of Article 51. Because we believe that international peace and security should be maintained. We should have honorable relations between nations. Respect international law. We respect international law. Unlike China, in many cases, in recent past, treaty obligation, settlement of international disputes by arbitration. And I must quote Mr. Modi ji. He was saying that India is going to be arbitration capital of the world. It means world will come to India for resolving their conflicts in amicable manner, right? So considering that you have gone through the previous lecture in which we discussed feature part of DPSP, right? Now let's start with the question. So my purpose is that you should think and use this lecture so that you can answer questions comfortably in exam. So one probable means question can be, critically analyze the status of DPSPs as enshrined in Indian Constitution. I am repeating, critically analyze the status of DPSPs as enshrined in Indian Constitution. Full stop. And question can be 15 marks, 200 words. Now on this point you should think, critically analyze. So do you have some points? And they should not be just points, they should be arguments. And to score more, your argument should be backed by certain people, popular people. When we are talking about a constitution, so you can quote some members of Constituent Assembly, what their opinion was on the status of DPSPs. Okay, so this is one type of question. And by the end of this video, we will be done with the discussion on these points. Now second question. Discuss the debate between fundamental rights and DPSPs, comma. In your opinion, they are complementary as well as contradictory in nature. Discuss in your opinion. Yeah, what can be done? That they can remove this word in opinion and they can simply use the statement. Discuss the status of fundamental rights and DPSPs and their nature being complementary as well as contradictory. So now, while answering this question, you should not just focus on the provisions part. Okay? Because this question is about means, right? So there you need to talk about the substantive part. Means the very idea which differentiates fundamental right to this DPSP. So means we need to bring the debate of political right, civil right at one end, socio-economic rights at another end. We need to also bring the debate of the principles of justice as mentioned in preamble. So by these 2 points, I think now you are a bit, clear that when these kind of questions are asked, you should not just focus on provisions which are mentioned in part 3, part 4. Okay, this understanding need to be reflected. Okay, now when it comes to prelims part, from DPSP, one common kind of question is, which of the following is not a DPSP mentioned in Indian Constitution? So this is obviously can be covered when you have gone through the previous lecture. You have gone through the features, or you can say parts which are mentioned in DPSP. Now, another more important is, a question can be on cases which are related to status of DPSP. So one prelims question can be on the cases. For example, according to Champakam Durai Rajan case, DPSPs were given primacy over fundamental right. So this is one statement. So how can you answer? You can only answer when you know, okay, the whole trajectory, Champakam Durai Rajan case, what it said. Then what was first Constitutional Amendment Act, 7th Constitutional Amendment Act. Thereafter, how Golaknath's case was totally different from the opinion which was raised in Champakam Durai Rajan case. And after Golaknath case, what was the status of DPSP as per Kesavanand Bharati case? And along with this, you should connect what Article 31C was saying about it. Okay, so if this trajectory is clear in your mind, then you can answer this kind of question, means second dimension of the prelims question easily. Okay, now third part. Third part is applicability part, which is becoming a, you can say, a favorite part of UPSC nowadays. You can check the questions which were asked last year. Means some questions will be checking the fundamental aspects, whether you are clear about this or not. For example, when you open your Lakshmikant, so in the critical part there's a word that DPSPs are conservative in nature. Okay, and there's an explanation also in your Lakshmikant that that these DPSPs were inspired from English socialists, right? For example, Sidney and Beatrice Webb, right? And this word Fabian socialism is mentioned, that Fabian socialism is reflected in DPSPs, and in this particular part it is used as a limitation. Now what UPSC is going to play on, they will actually connect Fabian socialism, its limitation, with the status of DPSPs. So you can easily answer such kind of question, which many students are going to get trapped in, if you understand what is Fabian socialism and how relevant it is in present context. Means how it is related to DPSPs, whether it's a limitation or there are some positive, you can say, connotation to that also, right? So it means whenever you start a topic, my advice is keep in mind the kind of questions which can be asked in prelims, kind of questions which can be asked in mains. And how you can do that? You can easily do that, just go through the previous year question papers. Okay? Now, let's start this discussion. Welcome Manjeet, welcome everyone. So you can share this discussion with your friends or group so that other can also engage in this discussion. So DPSP is part 4, 36 to 51. So let's start with a trap question. Okay, let's have a good start. So I'm making a statement and you have to tell me the statement is true or false. This is our signature style, okay? So that I can be sure that all of you are, on the right track in your preparation. Statement is, judiciary is not considered as a state as mentioned under Article 12. So I'm repeating my statement that judiciary is not considered under the definition of state as mentioned in Article 12. Why I'm making this statement at this point? Because in previous session I mentioned Article 36, and Article 36 I told you that Article 36 says the definition of state is same as mentioned in Article 12, right? And I told you what is mentioned in Article 12. That's union legislature as well as executive, state legislature, executive, local government bodies, and fourth was other bodies, right? And other bodies which have regulating function as state. We discussed in Article 12 as well. So now I have made a statement that judiciary, now tell me, because the word judiciary is not mentioned in Article 12, and if it is not mentioned in Article 12 and Article 36 in DPSP says definition is same as Article 12. Now my point is, since it is not mentioned in Article 12, whether judiciary is considered as a state in Article 12 or not. So you have to answer me true or false. Come on, this is how we are going to start. Welcome Bhumej, Badal, Rahul, welcome everyone. And everyone has to answer. Okay, I have no expectations from you at this point of time. Okay, purpose is that if you are going to commit mistake, you will get the right answer, and then you are not going to commit this mistake in exam. That is the only purpose. Every answer is going to be respected. Now, come on. First, judiciary as a state or not? Tell me. Come on. Answer is that the question statement was saying judiciary is not, right? It means answer is false, because in judiciary We can say there are two functions of judiciary. Means judiciary also has two functions. One is administrative and other is judicial. So my friends, please remember, judicial wing of judiciary is not considered as state under Article 12. And what is the meaning of this administrative and judiciary? Whenever you are going to go to court, okay, so you will find that there is an administrative staff also. Consider, say, High Court. So High Court is having a dedicated secretariat also. Supreme Court is having a dedicated secretariat also. So there is administrative staff, and they also make certain policies. They also conduct recruitment drive, right? So that is administrative function. For example, when it comes to vacancies in High Court, so our constitution allows this, that High Court is going to coordinate with State Public Service Commission regarding these vacancies in High Court. So at this point, High Court is having administrative function, okay? But in case Sunil Nayak has committed some crime and his case is being heard in High Court, so when High Court is listening to the arguments of advocate and now going to pronounce the judgment, that is judicial function of High Court, judicial function of court. So judicial function is not considered as a state in Article 12, but when it comes to administrative function, it is considered as a state. Means this segment of judiciary is considered as state under Article 12. If this is clear to you, mention yes in comments. Now let's move forward. So now this topic, sanctions behind DPSPs. It means why DPSPs were given such status. Means non-justiciable, right? So you cannot go to court. Why? So before talking about the, you can say, reasons part, you should also know about certain popular comments which are made by constituent assembly members. For example, Mr. K.T. Shah, so he said DPSPs are like check, means such a check which is given to the people, but this check will be only encashed when bank is going to have the cash. Means it is going to be on the prerogative of bank whether bank wants to give you money or not, and also at what time bank wants to give you money or not. So this is actually like a check. He also used another word, that DPSPs are like pious superfluities. It means there are good words, means good ideas, good ideals, principles. But when it comes to its implementation and the status, it seems like it is way beyond the practical reality. The need is that they should be implemented, but अच्छी बातें हैं, but implementation से तो they are very far. Okay. Now, when it comes to B.R. Ambedkar, so B.R. Ambedkar used DPSPs he commented on DPSPs in positive context. He used novel principles as a word. Okay, but now we are just focusing on critique part, because in the starting of this lecture, I asked you one question: critically analyze the status of DPSPs in Indian Constitution. And there I told you that you should not just focus on what is mentioned in DPSP, you should focus on giving argument. So you can use the argument of Mr. K.T. Shah. Okay. Apart from that, you can also mention Mr. Nasiruddin. So Mr. Nasiruddin said that these DPSPs, they are like New Year resolution. These are like New Year resolution. And what happens to New Year resolution? All of you know that what happens? They actually get break on the very next day. I'm not saying this is with everyone, but this is the popular reality, that these are like New Year resolution. Okay. Another Constituent Assembly member, Mr. T.T. Krishnamachari. I'm writing TTK. So he said that DPSPs are like veritable dustbin. It means good ideas are there, but the status is such that they are reduced to a dustbin. It means no one is going to pick things from this dustbin. But this is veritable. Veritable means very important. Its status is important, but due to the kind of conditions we have put, that this is like a veritable dustbin. Okay, so I hope you will remember these. Okay, now you should also, since question is talking about critically analyze, so obviously we need to have some critical points in mind. But please remember, the word is analyze. It means we have to balance our answer also. So what argument you are going to use there? So as of now, I'm talking about quote, and thereafter, when we discuss further, you are also going to get the argument. Okay, quote. So in quote, you can use Mr. B.R. Ambedkar, who was having high hopes from DPSPs, because he was saying, B.R. Ambedkar was saying, I am just writing it down here. B.R. Ambedkar was saying that they are going to bring social and economic democracy. I hope you are writing them down, right? The whole trajectory of the lecture should be there in your notes as some, you can say, keywords. Okay, I'm not saying write everything, but keywords. So he said socio-economic democracy is going to be the product from DPSPs, because when it comes to political democracy, it can be ensured through fundamental rights. Okay, socio-economic democracy as well as novel principles. Okay, there's another famous scholar, Mr. Granville Austin. So he was saying that DPSPs along with fundamental rights represent the conscience of Indian Constitution. Okay, K.C. Vihre. Conscience, he was using the word conscience. Okay, and please remember that UPSC may actually make a question. On one side, they will mention the name of these people. On the other side, they will mention the popular comments and ask you to match the following. Okay, so in this scenario, you should be well versed with this dimension of question. Okay, now coming to the point, why they were made non-enforceable. So you can easily remember, they do not possess sufficient financial resources. It means we were just getting independence, right? And we were not having enough financial resources. If Indian Constitution would have given them the status equal to fundamental rights, then it could have created legal issues, right? For example, if fundamental right is abridged, you can knock the door of Supreme Court, right? But in this case, socio-economic right, a huge financial burden needs to be taken by state, and state was not having that kind of capacity at that point of time. Vast diversity and backwardness. And due to this vast backwardness of Indian society, the implementation part was not that much easy. So those who are wondering, what is this? Please remember, law, legitimacy of law is only when it is in consonance with the social reality. Please write this statement down, because when you write these kind of statements in your answer, it increases the legitimacy of your answer. Okay, what I said, that legitimacy of law enhances when it is in consonance with social reality. For example, in fundamental rights, I mentioned Article 17, untouchability. Okay, prohibition of untouchability, right? And we also have laws made by Parliament which talks about prohibition of untouchability. But tell me, in reality, do you think this untouchability is prohibited in Indian society in practical scenario? No, right? We still have certain instances where this discrimination happens, right? So now, don't you think if social reality is different and people are not changing, and those when this law is saying that this is wrong, so one section of people belonging to a particular caste, so-called upper caste, they can say that, oh, you are intervening in my life, my religion says that this discrimination is justified. So if they are saying this discrimination is justified, so what does it mean? It means social reality is different from legal reality, and when they both work in consonance, then we find that there is legitimacy to that law, implementation to that law. If every one of you agree to this part, mention agree. It is clear to you? Yes, K.M. Parikar also said DPSP is bringing socialism in economic sphere. Now, to reduce the burden of newly formed India, because we were just formed and we already had so many challenges on political front, right? So at that point of time, it was conceived that social and economic front will also be taken care by Indian state in phased manner, right? Now, criticism. So 1, 2, 3 and 4. And within 4th, we are going to discuss further, okay? Because in 4th, we are going to discuss these. So there are 4 prominent criticism of DPSP that you are going to use in critically analyzed part, okay? But you should not just write no legal force, okay? You should also talk about what does it mean, right? And why, and since it is analyzed, you should also talk about why such provision, why such status was given. So no legal force, it is quite clear that as it is mentioned in our constitution, it doesn't mean that it is legally in force, right? But why the status was given? These were the reason, right? Why this was not legally enforceable. But since it is analyzed, you can also mention that door of its enforceability, although was open as per the direction given to the state, and state is going to make the law, okay? And within this, you should also mention some arguments. For example, Mr. B.R. Ambedkar was of the view that since we are going to have a government based on popular vote, no government can actually take this risk of sidelining the principles of DPSPs, because these DPSPs, they represent the aims and aspirations of the people. Aims and aspirations of the people. So any government who will try to sideline the aims and aspirations of the people, they are going to give this response to this particular party who is having government in the next elections. So by this logic, even if they are not given legal force, but this does not mean they will not having any value. So use this line. It means no legal force does not mean they will not have any value. Value will remain because representing aims and aspirations, and we have popular government, right, responsible to the people. Now, because when I'm going to talk about parliament, then we are going to discuss this word responsible in detail, because responsible word has different connotation when we talk about parliamentary form of government. But B.R. Ambedkar was talking that, yeah, since people are the one who have given you vote, you need to give respect to the aims and aspirations which they have. Now, illogically arranged, it means no coherent philosophical structuring was given to part 4. What does it mean? If you go through the previous lecture, you'll find first we were discussing socialist principles, and within socialist principle, some principle, for example, Article 40. So we picked Article 40 from there and we discussed it separately under Gandhian principles. So the logic says that some crucial provisions were actually placed with not so important provisions. It means no coherence is there on philosophical line, ideological line, as well as importance line, right? So these are the 3 things on the basis of which they are considered illogical. Okay, these 3 things need to be mentioned. Okay, now conservative. Why conservative? Because it is said that ghost of Sidney and Beatrice Webb. Sidney and Beatrice Webb, have you heard about them? Actually, these were husband and wife, and these were famous scholars, English socialist scholars. means British socialist scholars. And they were the earliest member of Fabian Socialist Society in Britain. And my friends, UPSC is asking questions on these details nowadays. Now, Fabian Socialist. And why Ghost? If you take a look over the education profile of many prominent members of Constituent Assembly, where they studied, simple answer is Britain. Our first Prime Minister, Mr. Jawaharlal Nehru. Jawaharlal Nehru also accepted that he is a Fabian Socialist. So what is the meaning of Fabian Socialist? This should be a question coming into your mind. Let's break this word into two parts. Fabian Socialist. Okay. Fabian word comes from the word Fabius, King Fabius, whose idea was by adequate intervention of laws, equality, social well-being can prevail. And socialist as an idea, it stands for bringing equality, right? So it means Fabian socialists actually have this idea that if inequality is increasing in society, so solution is not to overthrow the government by having weapons in hand, like these Maoist support, Naxalist support, right? We have to take up arm and power flows through the barrel of gun, and that's how we are going to bring the socialism we want. But Fabian socialists said no need of violence. Without violence also we can bring this socialism. And how we can bring? Government means state can make this possible by making certain laws. Now some of you might be thinking, this is such a good thing. Then why we are using the word conservative with it? Because ideas were good. But idea says state will make such policies. But in our constitution, the status of DPSP is non-justiciable. It means it is not necessary for the state to make such policy. So that is why it is said that idea was good, but we were playing too conservative with regard to the possibility which could have been generated by making it proactive, making DPSP provisions proactive. Okay? So if you are clear with the discussion until now, mention clear. And you can also mention ultra clear or ultra clear max. Okay, now constitutional conflict. What does it mean? Means the presence of DPSP also gives a scope of conflict. For example, President and Prime Minister. Consider that Parliament has passed a bill, means consider Lok Sabha, Rajya Sabha has passed a bill, because when we use the word Parliament, it means Lok Sabha, Rajya Sabha and President. Okay, so Lok Sabha, Rajya Sabha passed the bill, and now this bill needs to be presented to Honorable President. But Honorable President finds that, oh, this bill is devoid of this DPSP, right? So in this context, President can actually obstruct the passage of this bill. And obstructing the passage of this bill will represent constitutional conflict. Okay? So it means the center can give direction to the... So this is between center and state. Yeah, this is the point which I was discussing, between the President and the Prime Minister. I'm going to come to that also. So in this case, constitutional conflict may occur. President will say, oh, DPSPs are not enshrined in this, right? This is devoid of, or this is in direct conflict of DPSP provision. So this can happen. So the ministry has no right to ignore them. They have to, take them into consideration. Another is between center and state. It simply means center can give direction to the state that this is mentioned in DPSP, and that is why we are giving you direction that you have to do this. You have to make such law. You have to bring such administrative change. But in case state says, no, we are not going to do that. In this scenario, center can actually exercise the power under Article 365, and by this manner, they can actually change the government there. Means they can impose president, you can say president rule. So dismiss the state government in this scenario. So this can be considered as misuse of this particular provision, DPSP part, right? You can consider that this can create a constitutional conflict because state government will say, no, our opinion is different when it comes to this law. Why we should be bound by you? So that is why we are using the word conflict, because there is no clear answer to such conflict. Now that will be decided by court, okay? Between the governor and the chief minister, the scenario which we discussed between president and prime minister, same can be the case between governor and CM. Consider that CM wanted a particular bill and this turned into act, but what happened when it is passed through state legislature, then government is not signing it. Government is saying it is devoid of DPSP, against DPSP. So it will also represent constitutional conflict at state level, okay? Now comes the point, utility of directive principles state policy. Use kya hai? What is the use? So you can here check out the comment which was made by MC Settlewood, was a former Attorney General. So what he said, DPSPs although confer no legal rights, create no legal remedies, are significant and useful in following ways. No legal right are there in DPSP. You cannot go to court. Legal remedies are not there. For example, in fundamental rights case, there was constitutional remedies mentioned in Article 32. There is no such article, no such remedy present in DPSP, yet they are very much useful. Number one, instrument of instruction. These are like instructions to state. The state will look into DPSP while making their policies in order to establish new social economic order. We are using the word new social economic order because socio-economic rights are going to be ensured by state following these instructions. Now there are these 6 points. One, help the courts in exercising their power of judicial review. As I told you, that what court do in Champakam Durai Rajan case, thereafter this Golaknath case. So court was reviewing the status and this conflict between fundamental and DPSP. For example, if government has made a policy regarding, say, abolition of zamindari, like Jawaharlal Nehru government did. So now validity of this law was questioned in court. There was a strong lobby of zamindar which were against this government action. How can this happen? Because this right to property is a fundamental right. Now what government said in court? Government said, Honorable Court, please look into the provisions mentioned as DPSP under Article 39B, 39C. On this point, court said, yes, this is the direction given by Constitution to the state that they have to take action for equitable distribution of resources and restriction of concentration of wealth. So Zamindari Prohibition Act is very much in consonance with 39B and 39C. So here, Supreme Court said, okay, theek hai, we are using this DPSP for judicial review purpose. So this is the utility. Please remember this is an important utility. Second, background to all state action, legislative and executive. Legislative and executive actions by state, they are taking inspiration from DPSP, what needs to be done. Direct. Third, facilitate stability and continuity in the domestic and foreign policies. You know that Article 51 talks about foreign policy, and from Article 38 to Article 50, we talk about various provisions where state policies, how state policies should be, it is very much clear. So it means no matter which government is in power, but every government will see our job is to look into DPSP and define our actions accordingly. So there will be a coherence in, you can say, state policies. Then comes this fourth point, enable the opposition to exercise influence. Now this point and this point is interconnected, fourth and fifth point. So what does it mean? That opposition can ask question that this should be done by the government as it is mentioned in DPSP. But what you are doing? You are not doing this. You have made no policy with regard to right to work. You have not made any policy in this year with regard to giving, you can say, good environment to worker. You have not made any such policy with regard to protection of environment. So from where this opposition party in the house is getting its comment or the point of analysis, they are getting it from DPSPs. Okay, and this can be these DPSPs can also be a check on performance of the government. that, okay, these are the DPSPs, what you have done in this regard. So it can be used as a test. Okay. Then comes the last, supplementary to fundamental rights of citizens. Some rights you have got in FR and other rights you can got as the extension coming from DPSPs. Okay. So these are the 6 utilities. Please remember, this can be asked in prelims as well as mains. Okay. Now, conflict between fundamental rights and DPSP, another famous part. So this conflict was visible in the first year of the enactment of Indian Constitution. And then we saw this Champakam Durairajan case 1951. In this case, Supreme Court was in, you can say, a pacify mode. The pacify mode means they were not that much activist like we see Supreme Court as of now. One reason is Jawaharlal Nehru, the Congress government, the kind of legitimacy and support they were enjoying in the country. So at that point of time, what Supreme Court said, fundamental rights are over the DPSPs. Means FRs are above DPSPs. But another important part is fundamental rights could be amended. And this changed the whole picture. It means they accepted FRs are above DPSPs, but FRs can be changed. So if FRs can be changed, it means FR can be removed also. If any fundamental right is obstructing the path of making law by the government, what government is going to do? A government can remove this fundamental right. Let's remove this. And this is a solution coming from the interpretation from Champakam Durairajan case. And this is exactly what government did. First Constitutional Amendment Act. The Parliament made first Constitutional Amendment Act 1951, Fourth Amendment Act 1955, Seventh Amendment Act 1964 to implement some of the directives. It means government wanted to bring these policies. For example, these land sealing laws, Zamindari Prohibition Act. In short, we can say land reforms. Now, some fundamental rights are obstructing this part, so they change the status of these fundamental rights. Right? They added certain laws. For example, we discussed in 31A, B, and C. Right? We also discussed later about 9th schedule concept emerging from this particular time. Right? So this creativity was actually coming from Parliament because this scope of amending the fundamental right was there. Until now, there was no concept of basic structure doctrine, which we have as of now as an outcome of Kesavanand Bharati case. Now coming to the Golaknath case 1967. And this is totally different from what court observed in this earlier Champakam Durairajan case. There, what they said, Parliament cannot take away, abridge any of the fundamental right. So it is like limitation was imposed on Parliament. You cannot do this now. You have done enough adventures in your life. Now you cannot do that. Fundamental right cannot be amended for implementation of the DPSP. This is the application part of it. So now it is like here the hands of government were actually open. But here the hand of government was in restriction. So do you think government will restrict so easily? No. Because Parliament has the power to amend the Constitution and Supreme Court is there to guard it through various interpretations. But ultimately they have to interpret what is written in Constitution. And this is exactly what our Parliament did through 24th and 25th Constitutional Amendment Act. For example, 24th Amendment Act, what they did? Parliament has the power to abridge, take away any of the fundamental rights by enacting Constitutional Amendment Act 368. So they even amended the Article 368 because Article 368 earlier it was saying process of amendment. Now it was power of Parliament to amend the Constitution. The title was changed. And it clearly mentioned if any amendment is done exercising the power of Article 368, then it will be beyond the purview of judicial review. Right? So now by this particular amendment, now Parliament was actually got the power in his hand. Right? So you can think it is a volleyball game which is going on. Now 25th Amendment happened, inserted a new Article 31C, and 31C clearly mentioned whenever we are going to make law, taking inspiration from DPSP 39B, 39C, and even if that law actually contravene provision of say Article 14, Article 19, then also Supreme Court will not declare this, or this particular law will not be declared as void. It means Supreme Court now cannot say this law is null and void, because this is clearly mentioned through amendment. Okay. Now, this we also discussed when we were discussing 31C. Now, laws made under 39B, 39C shall not be reviewed any court of law, no judicial review. Right? Look what was happening with the power of judiciary at this point of time. Unconstitutional under Kesavanand Bharati case. Kesavanand Bharati case said, "Ye kya ho raha hai? This cannot happen." In Kesavanand Bharati case, Supreme Court said, "Who is the boss? We are the boss. Supreme Court is the boss." So how they did that? They used this judicial creativity, and they brought basic structure doctrine. And when Parliament started asking, government started asking, what is this basic structure? We are also lawyers and we have read Constitution multiple times, but it is not written there. So Supreme Court said, we can do that because we are the guardian of Constitution. And there is no limitation on the power of Supreme Court to guard Indian Constitution. Right? And when Parliament asked, so, theek hai, this is basic structure, you are creating it, but give us the list now. What constitutes basic structure of Indian Constitution? So as a reply, Supreme Court said, for this, you have to wait. Now Parliament asked, till what time? They said, it will be decided on case-to-case basis. We will analyze this, our bench will analyze this, whether this should be considered as basic structure or not, and then we are going to pronounce the judgment. So in Kesavanand Bharati case, Supreme Court said, you are fighting for amending power of Constitution? Parliament said, yes. What fight? This is ours, as mentioned in Article 68, and we also amended Article 68. Supreme Court said, we have given you this power. We have no conflict with you. You have ultimate power to amend Indian Constitution. Parliament said, oh, it means conflict resolved. Then Supreme Court said, just listen to us completely. Supreme Court said, you can amend Constitution. Even you can amend fundamental rights. Please remember, if question statement says whether fundamental rights can be amended, whether Parliament has power to amend fundamental rights, you are going to answer yes. But this cannot abridge the basic structure of Indian Constitution. It means by using this line of basic structure of Indian Constitution, the Supreme Court brought the whole game in its favor. And who is the ultimate boss? Supreme Court said, we are the ultimate boss. Now, Minerva Mill case. Fundamental rights conferred under Article 14-19 were accepted as subordinate to DPSPs, right? As specified, because it was mentioned in 39C as well. Article 31, right to property, was abolished by 44th Amendment Act. We also discussed this when we were talking about fundamental rights. Balance between fundamental rights and DPSPs. Now from Minerva Mill case, a new hope was given to this conflict. That rather than considering that who is superior, who is inferior, we should consider the complementary nature of these parts of Indian Constitution. Okay. So now these are some divisions between DPSPs and fundamental rights. Now, when it comes to fundamental rights, these are negative. So you can easily remember all of these differences by remembering one keyword. Negative means you can enjoy your fundamental right when some limitation is imposed on state. Okay, so that is why nature of these rights is negative. When it comes to DPSPs, they are positive. Positive means a state has to perform these actions, then only these socio-economic rights can be ensured. Next, they are justiciable. It means you can go to court. They are non-justiciable. NJ. Aim is to establish political democracy. I mentioned this when I was mentioning a point by Dr. B.R. Ambedkar. These are there for socio and economic democracy. Now they have legal sanctions. They have moral and political sanctions. Legal sanctions means if you don't ensure this right, then people can go to court. Legal power is there. But here we have moral and political sanctions. Means it should be the duty of state. It should be the political reality that state will strive to make these provisions work? They promote welfare of individual. Please remember, they perform welfare of individual, they perform welfare of community. Means, welfare of community means they have socialistic tendencies. Means society, welfare of society should be primary. And that is why we say that Indian Constitution is right mix of different ideologies coming together. Okay, many nations, they actually recognize themselves, we are liberal, we are socialist. And what we can say, we are having right mix of different ideas so that best outcomes can be achieved for Indian people. They do not require any legislation for their implementation, means automatic, they are automatically applied. But when it comes to them, they require legislation from Parliament, right, as well as administration, means executive, because when it comes to DPSPs, so they're applicable on legislature as well as executive, right. The court are bound to declare law violative of any of the fundamental rights as unconstitutional, invalid. So because this is mentioned under Article 13, right, but the court cannot declare a law violative of any of the DPSP, okay, because they are not justiciable. And the provisions, the kind of provisions they are, they do not stand for this way that no law can be made which is abridging DPSPs. And please remember, this is a crucial difference. A beautiful statement can be made by UPSC in your prelims, and many students are going to get trapped in this easy statement. Alright? Now, implementation of DPSPs. So, do we have some examples where real work has been done by government? Yes, we do have. In last lecture, when I was discussing different features of DPSP, I was mentioning certain schemes, laws, which got inspired from these respective DPSPs, right? Same. For example, Planning Commission was made, now it was converted into Niti Aayog, and they are working in this direction. There are so many initiatives of Niti Aayog which draw inspiration from DPSP. So at this point, tell me, what do you know about Saath initiative of Niti Aayog? So Saath initiative of Niti Aayog, okay, and from which DPSPs do you think it is connected? Quite trivial question. So you can only answer, UPSC is going to make certain statements as well, but you can only answer this question when you have two understandings. One, what is Saath initiative? What are the objectives which are mentioned in Saath initiative? And along with this, you also need to have understanding, oh, where DPSP stands there. So those who are not aware, you should check. Saath initiative talks about education and health, working for increasing the outcomes of states which are considered poor in these sectors. So now how you can connect? Oh, DPSPs which mention about health and education as a priority of state policy. So if you got it, this kind of dimension question will be asked. If you got it, mention got it in comments. Abolition of intermediaries like Zamindari, Jagirdar, Imamdars, clearly visible, coming from 39B, 39C, right? Cooperative farming, we discussed 97th Constitutional Amendment Act, adding this, that cooperative societies, maternity benefits, mindset, community development program, and so on. So we have numerous laws and policies which got inspired from DPSPs. So by this discussion, I hope now all of you are clear to this point, that you cannot say that DPSPs, since are not justiciable, they are not having any real value. You cannot say that. You can see some real value. Okay? Now, directives outside DPSPs. So if a statement is made that directives to state are mentioned only in directive principles to state are mentioned only in part 4 of Indian Constitution. Do you think that statement would be true? Yes or no? Come on. Some students might say, oh sir, this statement is quite true because there's a dedicated part for that, DPSPs. So DPSPs are mentioned only there. So I've not said that they are present only there. means there are some directives to state regarding some actions which are present beyond this part 4 also. Okay, so you should be clear on this. For example, claim of SCs and STs to services, their claim to services. Appointment to services of the Union States, this is mentioned in Article 335, Part 16. So don't you think this is a directive to state for welfare of this section? But this is present in Part 16, not Part 4. Okay, so another instrument in mother tongue, this is another directive. The language is directive in nature. Instruction of the mother tongue at the primary stage of education to children belonging to linguistic minority group, 350A in Part 17 in every state. So here also there is another directive. Then development of Hindi language, duty of union, 351 Part 17. Okay, so these are the directives present beyond Part 4. I hope you will remember them. Okay, and in our journey of Indian Constitution today we need to talk about Part 4A. It means fundamental duties. But before we start, why duties as a part was not added in original Constitution? Why it was added later by 42nd Constitutional Amendment Act? And when we talk about the nature of fundamental duties, there's a word which is used, non-justiciable, not enforceable via court if law is not present. If such is the status, then why the word fundamental was used? So what are the political principles which actually shaped up this Part 4A? So as we start with the question, let's start with the question. So in mains, consider a question is asked, discuss the conception of fundamental duties as enshrined in Indian Constitution. I am repeating, please note it down. Discuss the conception of fundamental duties as enshrined in Indian Constitution. And consider there is another question, and where this word discuss is replaced with examine. So now tell me, would your approach to that particular answer would be different when the word discuss is used and another question word examine is used, or you are going to use same content, same answer structure? What do you think? Come on. These are the intricacies, details on which you have to play to get into the merit list. Because polity is not just about understanding the provisions, what is written. Okay, we have to understand the principal part, also how we need to apply this knowledge in exam, right? So think on this. That's the only purpose. I have no expectations from you as of now, because journey has just started. चलिए, तो इस पे सोचना है आपको. You have to think around it, and by the end of this session, you are going to have comfortable, scenario to answer this question. So fundamental duties, Article 51A, and within 51A, capital A, क्योंकि we have added this as a separate amendment, A to K. These are the subclauses. Part 4A. Now, when we use this word duty, you should understand, although in our constitution fundamental duties were not originally added, but duty as a conception in political reality. What does it mean? It means if we look back into the political systems of ancient time and medieval time, much importance was given to duties. And this importance was even more than rights. But don't you think, according to our constitutional scheme, this particular area is actually inverse, right? Because rights, we have given more preference, for example, FRs. But when it comes to duties, they are not given that stature, that importance. Now my question, my friends, are that why? What was the reason behind? What were the reasons in the mind of constitutional framers? Because I've told you, in ancient time, in medieval time, more stress was on duty. And why more stress was on duty? Because it was conceptualized that when it comes to citizens, they are enjoying benefits of state, and for efficient working of state, these citizens performing their duties is essential. So this was the logic. That's why in ancient medieval time, more stress was given on duty, what citizens need to do. And even if you look back into ancient Greece, there was a time when citizenship was given on the basis whether you will be able to contribute into the affairs of state or not. That's why women, children, and old people were not even given citizenship, because they would not be able to perform these duties which are necessary for further working of the state. And why we are talking about this in fundamental duties part? The reason is UPSC is asking these kind of questions nowadays, expecting you to understand these concepts. Why part? Okay. Now, so if this was the logic, then why are constitutional framers focused on rights, not on duties? What made them change their mind? Answer is because they were framing this constitution in a different time. We call it modern time. And in modern time, the conception of rights was quite prevalent. Take a look over this matrix. Individuals are given rights by our constitution, for example, fundamental rights along with other rights, legal rights. And when it comes to state, state is given duty. Because in part 4 we have read DPSP, Directive Principles of State Policy. Means our constitution is saying, oh state, you have to do this. Right? But what about duties of individual? They are not present there. So this can be considered as a relation between individual and state. But why? Answer is, in modern time, this concept of constitutionalism became prevalent. Number one reason is this. And this reason, so what is constitutionalism? You can simply understand it as of now, because we are talking about fundamental duties, that by this we are actually restricting arbitrary action of state. Arbitrary, focus need to be given on state. Arbitrary action of state. Because constitutionalism doesn't mean a state which is run by a constitution is constitutionalism. No. Constitutionalism means where rule of law is prevalent, where concepts like liberty, equality are prevalent, where state cannot abridge, or you can state actions cannot be arbitrary. That is the fundamental of constitutionalism. So when you talk about constitution, don't you think in this case how it can happen? It can only happen when restriction on arbitrary action of state. You can only impose this when you impose duty on state. What state need to do? Okay? And it was found. Second reason was it was found in medieval period especially, this concept of duty to citizens, duty to citizens and devoid of rights, means conception of rights was not popular, devoid of rights. It was actually leading to exploitation of people. So because this has happened in the past, that when you give duty to these citizens and give liberty to state, this happens. So that is why as a solution, what they thought, let's give duty to state and rights to citizen, right? But along with this, they were not saying that, oh, citizens need not to do any duty. Aisa nahi tha. This was not the case. According to them, rights and duties are correlative. There can be a statement based question on this in your prelims. Please remember, rights and duties are correlative. What does it mean? It was said that when you enjoy a right and you don't perform your duty, then it will be considered as abridgment of someone's right. So actually, rights and duties can only exist when they are together, because balance is needed. For example, consider you are talking about I need my right as mentioned in Article 19. So you have all the rights mentioned in Article 19, subclause 1, subclause A, B, C, D, right? And all. But you are not performing your duties. For example, to uphold the principles of Indian Constitution. For example, you can say cherishing the ideals on which India as a state was formed, respecting national anthem, national flag. Now, if you're disrespecting national anthem, national flag, if you're contravening the laws which are necessary for law and order, don't you think your such actions will abridge the prevalence of conception of rights in our society? Because others' rights will be compromised. So it means rights and duties are interlinked. According to Gandhiji, when we are going to perform our duties, we are on its own, we are going to have some rights for us. And this was not some pravachan, there was a logic inside. And logic was, consider that all of us know that I am here and this is what I need to do. And all of you start doing that, so that our system becomes better, efficient. Don't you think it will naturally lead to all of us getting our due space to actually grow, right? So it means duties are connected to rights, okay? And in ancient Indian political thought, this conception of fundamental duties is also connected to that. There was a concept of dharma. Now some of you might be saying, sir, dharma and fundamental duties part 4A? Yes, they are connected. Dharma is not religion. I'm not talking about religion, Hindu, Muslim, no. Dharma as a concept connects to duty. And it says that dharma, duty, is necessary for stability. Only when we do our duty, then only there can be stability. Take example of your home. Your father do certain duties for your home. Your mother performs certain duties for your home. I hope you were also performing certain duties for your home. Don't you think, since your mother was performing some duty, your father were performing some duty, you were actually quite stable. Okay, this I can get from mother, this I can get from my father, and that's how I can work in a balanced manner. The work, the life in home is balanced when everyone performs their duty, right? So similarly, when it comes to society, when each one of us perform our duty, then only there can be stability, then only there can be progress. So it is also connected to this concept of dharma and duty. So if it is clear to you by now, mention yes. And UPSC can make such statements, okay? One statement from here in prelims, another from here, correlative, and another statement from here, okay, and one from here. I hope you are clear with these dimensions. Now, in part 4A, you have in total 11 duties. When Indira Gandhiji was Prime Minister of India, during this internal emergency period, she recognized that people should also know their importance for realizing the aims of nation. What she meant at this point of time, let me tell you. She said individuals, and when she's saying individuals, she was talking about citizens. Citizens are active participants in realizing national goals. And these lines need to be used in your mains answer. Realizing national goals. So she was saying, citizens are not mere spectators. Spectators होते हैं कौन? Those who are sitting on the fence and looking, oh, what we have achieved now. Let's ask central government. Let's ask state government. No, that's a wrong way. The way you relate with your nation and its realization of goals. We all are active participants. It means we have to perform certain tasks on daily basis, then only our nation can become great. That's a fact. Many of us don't connect with this fact at deeper level, but that's a reality. Now, to realize these people that you are active participants, it is important to tell that they have some fundamental duties. Okay, so she gave this task to Sardar Swan Singh, that you do the research and tell us what kind of fundamental duties need to be added in our constitution. So Sardar Swan Singh recommended 8 fundamental duties, plus 2 more were added by government, and that's how 10 fundamental duties were added through 42nd Constitutional Amendment Act, okay, during the time of Indira Gandhi ji. Thereafter, one more fundamental duty was added through 86th Constitutional Amendment Act. We are talking about duty. So, what clicks into your mind when we talk about 86th Constitutional Amendment Act? We have repeated this 3 times. We talked about this in FR, then DPSP, and now FD. So, we are talking about education. It means if you're a parent, you have a child, then it is your fundamental duty that you have to give that child adequate opportunity to educate and grow. So this fundamental duty was added, and that's how we have now total 11 fundamental duties in part 4A. Okay? An interesting point is Sardar Swan Singh also recommended that these fundamental duties should be enforceable as becoming part of this constitution, means part 4A. If anyone don't do this fundamental duty, then it should be punishable by law. Means he was saying punishable by law. So tell me whether this recommendation of Sardar Swan Singh was accepted by Indira Gandhi government or not. Yes or no? Yes or no? Come on, we are talking about a recommendation. Answer is no, because it was not considered punishable. Okay. Now I am making a statement and you have to tell me that statement is true or false or not. Okay. Statement is fundamental duties are not enforceable by law. Now tell me the statement is true or false. Come on, in comments. Welcome Abhi, Hitambra, everyone. Tell me the statement is true or false. Come on. True, false. According to my experience, many students will say, sir, it's quite basic question. Its answer is yes. Fundamental duties are not enforceable by law. How many of you think answer is yes? My friends, answer is no. The statement is actually false. So you can say my advice to you is that whenever this word enforceable is used, don't just get into this zone ki acha this is not enforceable. Also read what is written after enforceable. Okay, so it means what the reality is. Reality is fundamental duties are non-justiciable Okay, point number 1. Point number 2, non-enforceable देखिएगा, enforceable by court unless law is present in this regard. What is the difference now? Because when we say not enforceable by law, it means even by law you cannot enforce fundamental duty. So वो तो वो वाली बात हो जाएगी, एक तो गलत होता है, एक सरासर, that would be सरासर wrong, because we have some laws regarding enforcement of fundamental duties. We are going to talk about those laws also in this video. Okay, so what the difference is, and non-enforceable by court means you cannot knock the door of court. Oh, this Abhi and this Mobinal Haq has not performed their duty, and that's why court, please give them punishment. Then court will say, let me check whether there is some law made by parliament regarding enforcement of fundamental duty or not. If court finds, oh, there is a law there that they should respect national flag, they should respect national anthem, they should respect national heritage, they should absolve violence of public property or engage in destruction of public property. So if there is law there and punishment is 6 months, then in this case court will pronounce the judgment, oh, law in this regard is present, so it means now they will get punishment. Okay, so there's a difference, non-enforceable by court unless and this. Okay, I hope you got clarity. If you are clear now, mention clear. Now please take a look here. Characteristics. First is moral and civic duties. Moral. The word moral is used because they are considered as moral obligations. Obligations means what you should do. Moral means some ground of good which is better for everyone. Right? And why this is used? Because in part 4a, no explicit mention of punishment is there. Highlight values of Indian traditions, religion, practices and mythology. So this is second, and third is parliament can enforce them with legislation. Law can be made. Fourth, only applicable to citizens. Please remember that. There can be a statement, question on this. And many students will get trapped if the word is used any individual. Any individual who is resident in India is means fundamental duties are applicable on that person. So what do you think? It would be true or false? Come on. In the haphazard manner, in the pressure of exam, many students will say, yeah, if someone is resident, then at least that person should respect Indian national flag, respect national anthem. It means fundamental duties are applicable on that person. But that would be wrong, because these are applicable only on citizens. Okay? What's the difference? There can be a law made by parliament which explicitly mentions that anyone who is in India, anyone means anyone, has to respect the local laws, has to respect the national flag, national anthem. So in this case, this law is explicitly mentioning that this particular provision is applicable on citizen as well as alien. But when it comes to part 4a of Indian Constitution, where we use the word fundamental duties, those are applicable only on citizens. If you are clear about the difference, mention yes. Now fifth, non-justiciable. You cannot knock the court, or I told you the reason. In what case? Now sixth, non-legal sanctions against their violation. Because this is not mentioned in part 4a. Legal sanctions can be made by parliament. Now take a look over the statement of Vivekanand ji. It is duty of every person to contribute in development and progress of India. Okay? And if you have read newspaper on 28th February, there was a judgment from Madras High Court, where Madras High Court has said that fundamental duties should be legally enforced in India now. Because they think that for vibrant democracy, contribution of individuals, means citizens, is necessary. And this particular judgment and this line can be a scope of question for you in mains. Okay? And there you have to use the, you can say, dimension coming from this dharma concept, duty concept, as well as evolution of the concept of duty and rights, correlative, and how rights became superior, earlier duties were superior, and how it is necessary for democracy. Okay, the statement which was made by Indira Gandhi that can also be used. Okay, now Sentencing Committee, I've already told you, need fell during internal emergency 75-77. Sardar Swan Singh, I've told you, 42nd Amendment, then 86th Amendment, total 11. Now, what are the fundamental duties mentioned? So, A is, so just go through that one by one, and after that, I'm also going to tell you a trick to remember all of these. Okay, because one kind of question which can be asked is, which of the following is not mentioned as fundamental duty in Part 4A of Indian Constitution? So how you can do that? If you just remember the keywords which are mentioned in this Part 4A, then job will be done. To abide by the Constitution, respect ideals, institutions, national flag, national anthem. To cherish and follow the noble ideals that inspired national struggle for freedom. So first of all, you should respect the Constitution, you should respect the national anthem, you should respect the national flag and the institutions established as per the Constitution scheme. So when you are done with that, then you should remember that we are free due to the struggle, due to the many, you can say, sacrifices which were made by our previous generations. So you should respect the ideals on the basis of which they fought this battle. Okay, and our life of this kind is made possible. Then comes the third one related to sovereignty, to uphold and protect the sovereignty, unity and integrity of India. That is the third one. Okay. To defend the country and render national service when called upon to do so. So first one was Constitution, means national flag, national anthem, that needs to be respected. Thereafter, you need to cherish the ideals of the freedom struggle. Third, you need to respect the sovereignty, unity and integrity. Now fourth, you should be ready to serve whenever nation needs you. For example, Ukraine needs their citizens to take up arm against Russian intervention. Similarly, if it happens, God forbid, then you need to be ready. This is a fundamental duty. Now, to promote harmony and spirit of common brotherhood amongst all the people of India, transcend religion, linguistic, regional or sectional diversity. It means there should be no discrimination in your mind and action on these bases, and renounce practices which are derogatory to dignity of women. Okay, so it means any social evil. Now you can realize that banning of entry in certain sanctums of temple, although the different opinions are there. So this particular practice was also read in this context, that this practice is derogatory to women because you are considering women as impure in that particular time. Similarly, caste-based discrimination. Similarly, you can say some hateful speeches, resentment on the religious line, they all are actually against the fundamental duty. And why it was added? Because, my friends, if India is this carriage, then we all need to work in the same direction. That's how we can progress. If we all are thinking and acting in different directions, then do you think that India can progress? Can we go here in a shorter time possible? No, we can be at halt, right? So that's why we need all to be together. Means brotherhood as a fundamental duty is mentioned in subclause E. Okay. Now, to value and preserve the rich heritage and the country's composite culture. So you should respect the heritage. It means you should respect the, you can say, monuments, symbols, whatever is connected to Indian history and India's present. Now, there is one way of reading this, okay, this is written. And another way which I want you, all of you should inculcate, is that you should think on this line that, oh, how I can use this dimension in my essay. Why culture is given so much importance? Because for many people who are reading this fundamental duty, they consider this is the least important fundamental duty. ठीक है. But the kind of essays UPSC is asking nowadays and kind of analytical questions, 2-3 analytical questions which UPSC ask, there your clarity and depth of thought will be reflected. And this is the difference between people who are reading Indian polity for knowledge sake, right? And the difference that the people who are going to be in the merit list. Because if you have to be a civil servant, you have to run this country, then you should have those qualities, na? And you should connect them with other aspects. For example, what Mahatma Gandhi was talking about, importance of culture. What Rabindranath Tagore was talking about. What Vivekananda was talking about. Because if you have to destroy a nation, just hit the roots, and roots are culture. Destroy the culture of a nation, and then they will not have anything to be proud of, and then they will follow you. And you should connect them with what Britishers were doing with us. And that's why it is important for us to understand the importance of this duty. You should read about the concept of Orientalism. This is a star point in my class. Orientalism. Why Britishers were actually spending so much on British scholars to read about Indian culture and then interpret Indian culture. For a good amount of period of Indian history, we were knowing about us, we were looking at us by a lens which was given by Britishers and other Western scholars. So they were explaining us that we lack any strategic culture. They were explaining us that we are not that much practical. We are rudimentary. We have so many social evils. Evils are present in every society, and with the movement of society, it is our duty to actually root out those evils. But we were actually interpreted like we are barbaric, and they are here to civilize us, and we were enchanted with the British culture, British way of life. If you ask some people of that time why you want to study, I want to be like an Englishman. Why you want to be like an Englishman? Because you are so much attached to their way of life. Because they have said your way of life is poor. So these narratives, these sentences are floated so that you lose something which you should be proud of. Then it becomes easier to control you. Okay? So that's why this fundamental duty is important. I hope you are clear now how you need to use it beyond this particular part. Now, you can see environment, right? To protect and improve the natural environment, including forest, lake, river, wildlife, and to have compassion. Now, compassion for nature. But the point is, are we doing something in this regard? If any one of you mention NGT, then I'm going to tell you, sarasar wrong. Why? Because we are talking about fundamental duties, not DPSP. And fundamental duties are about us, what we are doing in this regard. So do you know some citizen-centric solution to protection of environment? Do you know some solutions in this regard? So many reports or editorials keep coming in now that Mr. Rajan Singh Waterman has done this, Sundarlal Bahuguna did this, right? So it means these solutions should come from the people, okay? Because our life is connected to environment. To develop scientific temper, humanism. So what is the difference? First of all, scientific temper, so that we can actually remove social evils, okay, which are stopping our growth. Humanism, that our philosophy of life should be centered on welfare of humans. The spirit of inquiry and reform, that we should keep questioning what we are doing right and what we are doing wrong. And if we identify, oh, this we are doing wrong, then we can reform it. And this is the only way of progress. There should be a spirit in all of us. To safeguard public property and abjure violence. If you are engaged in acts like this, so who is the actual, you can say, actual person or people on receiver end. We all are. Means taxpayers' money is getting destroyed. Next is excellence. Means to strive towards excellence in all spheres of individual, collective activity so that nation constantly raises to higher levels. Because it is said that if each one of us just start doing our work in proper manner, then nation will change. Grand design, great plans, they all are based on one very fact, that we Indians start doing small things in excellent manner. That's it. India will be great. So this is the fundamental duty mentioned here. To provide opportunities, this is the last one, which was added through 86th Constitutional Amendment Act. From age 16 to 14 years, that it is the responsibility of parents to provide education to his child and ward. Okay. Now, what are the significance of these fundamental duties? Although from our discussion until now, many things are clear to you, but you should remember these phrases so that you can use readily them in your answer. Citizens to be conscious, so that you are aware, okay, how we need to engage in the development of India. Okay, you are the stakeholder, you are the participant, not mere spectator. Then deter from anti-national and anti-social activities, because if a nation is internally weak, then external circumstances will give such a shock which is going to destroy the present as well as future. Inspire citizens towards nation building and discipline. Remind citizens of their necessity in achieving national goals. Means individuals are necessary for achieving national goals. It is not just government is responsible for achieving national goals. Help courts examine. Yeah, this is another important part. If you remember, Article 31C. So Article 31C was talking about if a law is made taking inspiration from DPSP's 39B, 39C. So in this case, even if this particular law abridges Article 14, Article 19, yet this law will not be considered as null and void. So in this case, judicial review was actually used considering DPSPs in mind. Similarly, courts can actually use fundamental duties while actually doing judicial review. Okay, so that constitutionality of a law can be enshrined. Okay, if law is made and it is written fundamental duty, then court can say, oh, this is part of constitution as well. So it means your making of law represent the spirit of constitution. Okay, this is okay. Strengthens democracy. Because democracy is not just we getting into some election and deciding who is going to be elected from our area. According to one famous scholar, MacLeish, democracy is a act which all of is you can say is our series of actions which we have to perform on daily basis. I am repeating this. According to Professor MacLeish, democracy means series of actions which we have to perform on daily basis. Some of you might be thinking, oh, I am studying as of now. So is that something related to democracy? Democracy as an idea, you know that it is about that we are the active participant of this political system. It means your presence, your actions matter. Your aspirations matter, and they can only matter when you act in this manner. And democracy as an idea is not just connected to your relation with state, your relation with government. No, because democracy as an idea is also based on equality, and that is why in every action we perform, we have to uphold the principles of liberty, equality, that we should treat people in equal manner. That is, humanism approach should be there. We should not abridge the liberty of people so that their potential get obstructed. Then only we can be great democracy, right? If this is clear to you, mention yes. So you are getting good amount of arguments to be used in your mains answer. I hope you are getting it. Now, just check out the views of Miss Indira Gandhi ji. Moral value of fundamental duties would not be smother rights. Because this was the contention. Oh, fundamental duties may smother rights, may deter rights, decrease rights. She said no. This is not real. Actually, it is to establish a democratic balance by making people conscious of their duties equally. Because rights and duties are equal. Means there should be a balance as they are conscious of their rights. So this was a statement by Miss Indira Gandhi. Now, Verma Committee observation. So they said that existence of legal provisions for implementation of some of the fundamental duties should be made, and there are certain laws which are actually connected to this. For example, Prevention of Insults to National Honors Act, important, you can say, law, and this important law is connected to which fundamental duty? Tell me in comments. Come on. Can you mention the clause as well? In comments, fast. You should be quick. And that's why I was telling this in a story manner. First duty was Article 15A, subclause A. First duty was, come on, that you have to abide by the Constitution. You have to respect national flag, national anthem, right? Yeah, it is connected to A. Prevent disrespect to the Constitution of India, national flag, national anthem. So it means for first fundamental duty, we have a law. Okay, it means now this is legally enforceable. Then you have Protection of Civil Rights Act 1955, provides for punishment for offences related to caste and religion. And we just talked about brotherhood, no discrimination on the basis of religion line, region line, language line. So if there is discrimination on this basis of caste, then action can be taken as per Civil Rights Act 1955. Okay. Similarly, you have SC/ST Prevention of Atrocities Act, right? Indian Penal Code declares the imputations and assertions of prejudicial to national integration as punishable offences. It means any acts which are done by you, which are threat to the national security, then national integration, then action can be taken in this regard. The Representation of People Act 1951 provides for disqualification of MPs and MLAs if they engage into corruption, engage into corrupt practice, soliciting votes on the ground of religion. So this can be a basis of their disqualification. But the reality is these things happen, right? So it means there's a difference between what law says and what is happening on ground. And in future, we have to bridge this gap together. Now, promoting enmity between different sections of people means through hate speech based on caste, race, language, religion. You know, vote bank politics. So we have a law in this place, Representation of People Act. So it can be considered also a law enforcing fundamental duty. Then Wildlife Protection Act 1972 prohibits trade of rare and endangered species connected to protection of environment. So now what are the criticism? First criticism was that why you have not added some important duties as fundamental duties. For example, no nation can actually run without people paying taxes. Okay, so if you compare the tax reports of say 10 years back, you will find that in recent years the taxpayers, or you can say base of taxpayers, have increased after the decisions taken like Aadhaar card, PAN card seeding and seeding with bank account. So by these actions, considerable improvement is there. Also with GST implementation. But the point is still so many people actually, they do this tax evasion, right? And if we are doing tax evasion, what is the demerit? That we are running a parallel economy which government is not aware about. It is unaccounted money. Right? And if tax is paid, government will have revenue. If government will have revenue, government will be able to spend for the welfare of people. Family planning and so on. So these fundamental duties are not there. Duty to pay taxes was recommended by Swan Singh Committee. Swan Singh Committee also recommended that duty to pay tax should be there as a fundamental duty. Some of the duties, although you should know that every one of us pay taxes, right? There are indirect taxes. Even if you purchase a Parle G biscuit packet, so if the price is say 5 rupees and there is written inclusive of taxes. So indirect taxes we are paying, but here we are talking about other taxes as well. Okay. Some of the duties are vague, ambiguous, means confusing, and wherever there is no clarity in legal language, there are chances that it will not be followed. Right? That is why we are saying it's a criticism. For example, different interpretations can be given to the phrases like noble ideas, composite culture, scientific temper. What will the meaning of scientific temper? So clear definition is not there. Apart from this, non-justiciable in nature. Sardar Swan Singh was saying ki let's make them punishable. Inclusion of the constitution was described as superfluous. Why superfluous? Because it was said that you are adding them as fundamental duties, but they're not justiciable. So it is like there are some good words, good aspirations, but they are devoid of the practicality. Duties included in fundamental duties are fundamental, performed by the people even though they are not incorporated. So many fundamental duties we performed even if they are not incorporated. Respecting our national flag, respecting our national heritage, respecting the ideals on which this freedom struggle was fought, right? But still you should know that documenting them in one place and keep on pushing realization of these duties is definitely going to add value. Inclusion in part 4 was reduce their value and significance. It is said that duties are of such importance that they should have been included equal to part 3. Why you have added in part 4A, capital 4A, right? Because it says that fundamental rights are important. That is why you have mentioned in part 3, and part 4A you added later, and that's also after DPSP. So this is one ground of criticism. So this can be a shortcut to learn. As I told you, just remember keywords. So this shortcut can be used when question is which of the following statement, which of the following provision is not mentioned as fundamental duty. So you can say FSSDH, HESPE. So HESPE and FSSDH. And flag, national struggle, sovereign defense, harmony, excellence, public property, scientific temper, environment, heritage. Okay. Now just attempt this question. Which of the following statement is true of the fundamental duties of an Indian constitution, First statement says, you have to attempt this question. A legislative process has been provided to enforce duties. They are correlative to legal duties. Now tell me, what's the answer? A, B, C, D. Come on, fast, in comments. Abhi, Dheeraj, Mobinul, everyone. Those who are going to watch this class in video, I would advise if you just participate, like you just put a comment. Okay, some are saying A. Let's understand what the meaning of this sentence. A legislative process has been provided to enforce these duties. Now tell me, fundamental duties, part 4A. So in any provision, have you seen the provision talking about legislative process? I have not studied as such. So it means legislative process is not mentioned there. Okay. So they are correlative to legal duties, although we use the word correlative. But in what context? Rights and duties are correlative. And the explanation I gave you, that if you perform your duties, everyone perform their duties, then rights will be ensured, right? So there's a balance. But the word is legal duties. So that is not correct, because there can be n number of legal duties. And how is it necessary that they are dependent or correlated with fundamental duties, right? That is why answer is 4. Okay. So I hope it is clear. Next question that you have to attempt, okay, and this PDF will be available in the Telegram group and you can look at the explanation, okay.